Petition.
Serial number 9, list 3. Petitioner is before this court seeking for the following reliefs. A memo dated 5/2/25 has been filed, signed by the counsel for the petitioner, which reads as and accepting the said memo and submission of counsel for the petitioner. Petition is dismissed as withdrawn.
Please.
Serial number
Serial number 8.
Urgency is that election pertaining to the matter, election matter.
21. Corporate societies.
Cooperative.
Voting.
Filing the nomination. As well as filing the nomination.
Nomination we won't allow.
Malad, I will.
If you want to take a chance before this court, no
Document,
chance.
Malad, which has been produced by me.
Nomination, no chance, Mr. Shetty.
Documents Malad, on both counts, Malad, it's not correct.
21 file kodi.
Malad,
Say madbidana or voting who bad one.
Malad, serial number 8, Malad.
Malad,
I have a benefit of entry model.
ಇವಾಗಲೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕಾ ವಿತೌಟ್ ಫೈಲ್?
Malad, serial number 8, Malad.
8
Entry model.
entry model ಎಲ್ಲರಲ್ಲೂ extend please. 1 to 24 again repeating 11 2. Serial number 23 ಏನಪ್ಪ? 23 pass over. 24 ಇದೇನಾ corporate society? 23 ನು ತರಿಸಿ 24 ತರಿಸಿ.
Serial number 22 minutes.
20
22 may I request for 2 weeks minutes. I need to file impeding application in that.
22
List number 3.
at the request of counsel for the petitioner released on 20th February. 25 to 37 12 2. 25 to 37 12 2.
Serial number 3 in that list, Malad, sir. Third list, serial number 3.
ಆಗೋಯ್ತು.
Fresh matter antide. If I can request tomorrow or day after tomorrow.
It's
Your
11
copy of that writ petition has not been served on me, my lord.
It has been, really, it has been sent through registered post to my learned senior friend, Malad, sir.
to wait for it to reach.
Yeah, it's because long ago, this honorable court, Malad, has issued
He
notice.
is not received ಅಂತ ಇದ್ದಾರೆ.
Anyway, I'll send it by mail, Malad, to him once again.
11 2 ಅಷ್ಟೊಳಗೆ ಮಾಡಿ.
Tomorrow or day after tomorrow, Malad, sir.
ಅವ್ರಿಗೆ
You lodge my kindly have it on Monday, my lord.
11 2 it will
Yes,
come up.
yes, yes.
Oblige, my lord, oblige.
Number 1, adjournments, page 17, 67 to 72, page 18, 73 to 77,
76, my lord.
76.
Serial number 76, it is lordship's order covered by judgment. It can be disposed of in terms of. Allah.
Mentioning ಆಮೇಲೆ ನೋಡೋಣ.
Yes.
Yes.
Serial
ಹೇಳಿ
number-
ಮೇಡಮ್.
76.
ಅದೇ same
76 same wait.
Serial number 71 minute.
ಹಾ
Pray for a week time because in one of the RFA, the property involved in this writ petition is reserved for judgment.
ಹೇಳಿದಿರಾ?
I have informed Mr. Dinesh Kulkarni.
71 learned counsel for the petitioner submitted the subject matter of the above petition is being considered in a regular first appeal pending before this court. Hence released on 10th March.
page 19, 79 and 80, page 20,
Kindly, Lord.
81 to 84,
Serial number 80, Lord.
80
Please.
ಹಾ
And the
80
proxy counsel on behalf of Joe,
ಪ್ರಾಕ್ಸಿ ನಿಮ್ಮ ಹೆಸರು ಇಲ್ಲ ಇಲ್ಲಿ.
next week.
ಯಾರಿಗೆ ಪ್ರಾಕ್ಸಿ ನೀವು
Petitioner.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ?
Yes, I have.
Dharwad Patil,
80 at the request of counsel for the petitioner released on 18th February.
Please.
page 20, 81 to 84, page 21, 85 to 90, page 22, 91 to 95, page 23, 96 to 100, page 24, 101 to 107,
Serial number 102, my lords.
Hmm.
Petitioner
Mandamus, my lords. On the last occasion, my lords had directed the government to seek instruction.
You are mentioning, Mr. Counsel, reach ಆದ್ರೆ ಆಯ್ತು. ಎಲ್ಲಾರೂನು ಹಿಂಗೆ ಹೇಳಿದ್ರೆ ಎಲ್ಲಿ ತಗೊಳಕ್ಕಾಗುತ್ತೆ? ಯಾವ್ದು? We'll go in seriatim only. No exceptions.
Page 25, 108 to 111.
111, I am for the petitioner.
Yes.
I have informed both, my lord, the Shivsai Patil and the arguing counsel. May be taken on 18th, my lords.
111 at the request of counsel for the petitioner, 18th.
Much obliged.
Your Lordship, serial number 109.
105.
109.
109. Yes.
Your Lordship, short accommodation will file wakalat, Your Lordship.
ಯಾರಿಗೆ respondent 1 na?
Respondent number 1.
Anup
Respondent number
Deshpande.
1. Inform the petitioner counsel. My lord, sir.
That counsel for respondent number 1 seeks fund is granted 2 weeks time to
Interim
obtain
order may be
instruction and
extended.
make a submission. Released on 20th. Interim order earlier granted is extended till next date.
List to serial number 14, my lords. Lords, matter was posted for hearing, my lords. It has posted for B group, my lords. In fact, it should be posted for preliminary hearing, my lords. Fresh matter, my lords. It was not heard, my lords.
ಯಾಕೆ ಕಂಪ್ಲೈಂಟ್ಸ್ ಅಲ್ಲಿಗೆ ಬಂದಿದೆ?
ಅಂದ್ರೆ ವಕಾಲತ್ತಲ್ಲಿ, my lords, the other side,
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಯಾವ್ದು ಲಿಸ್ಟ್ ಆಗದೆ ಇರುತ್ತಾನೆ ಬರ್ತಾ ಇರೋದು?
it was a
ನಮ್ಮ ಮುಂದೆ ಲಿಸ್ಟ್ ಆಗಿರೋದು ಅದು ಫಸ್ಟ್ ಲಿಸ್ಟ್ಗೆ ಬರ್ಬೇಕು. ನಾವು ಲೇಟ್ ಕೊಟ್ಮೇಲೆ ಓಕೆ.
some request. He's requesting on Monday, my lords, at the.
Yes, ma'am.
List 2, sale number 14. Relist on 10th at the request of counsel for respondent. Relist on 10th February.
My lords, in fresh preliminary.
11th February.
In the
In
preliminary.
preliminary hearing category.
Obliged.
List 1, orders, Sharmila M. Patil.
On submission, your lordships. At serial number 53, your lordships. 53. 53, your lordships. Already the compromise has taken place, your lordships. We'll file our compromise petition on 17th of this month.
17th.
Yes, my lords.
Parties are to be present.
Yes, yes, your lords.
Yes, we'll keep them present.
We'll keep them present, your lords.
53. Both the councils submit that the dispute between the parties have been settled and settlement would be reported on 17th. Released on 17th at 2:30 PM.
Please, my lords.
Orders, 1, Sharmila M. Patil.
This, my lords, I have paid PF to the respondent number.
RP of 2018.
No, my lords, they are all covered by judgment, my lords. In 1.3, my lords, it could be disposed of, my
served a
lords.
copy, your lordship, that I have to go through this. Fusion,
RP 7 years
RP ne serve 441 days.
What about 9 to 19? You accept notice? Mr. Patil?
MH Patil.
MH Patil for 1 to 8 ಇದೆ.
For 11, legal heirs of 11,
9
my
and
lords.
19 ಯಾರು? ಯಾರು ಇದ್ದಾರಾ? Can accept?
They all had appeared
11
before.
is deceased.
11 is deceased, my lords. I'll get the legal heirs, my lords, but with regard to the other two, my lords, I have paid PF.
You paid PF. What about this 11?
I'll get the legal heirs list, my lords.
ಯಾವಾಗ?
On a week's time, my lords.
Counsel for the petitioner seeks fund is granted 10 days time to file necessary application, bring the legal representative of deceased, respond number 11 on record. In the meanwhile, process fee to be paid if not already paid. Relist on 13th. ಇದು delay ಬೇರೆ ಇದೆಯಾ?
In
ಒಂದು ನಿಮಿಷ,
1.1,
1.1 ಕೊಡಿ ಫೈಲ್.
I have paid in this also, my lords. Emergent notice.
ಏಳು ವರ್ಷದಿಂದ ಸರ್ವಿಸ್ಗೆ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ನೀವು? 1, 2, 5 and 6. Okay. 1.2 ಕೊಡಿ.
In 1.2, my lords, it's covered by judgment, my lords.
1 and 1.1 is not covered.
Adu cover agide. All the three are covered, my lords.
That AGA accepts notice for respond number 6 and 7.
Yes.
Registry direct print his name as such. He is also direct file wakalat affidavit of respond number 6 and 7 as to why despite service, no appearance has been made by them. The affidavit to be filed on or before 13th, relist on 13th.
Much obliged.
2, Sangram Kulkarni.
Needful done.
Counsel for the petitioner submit that the process fee has been paid, registry to verify and issue notice to unserved respondent written by 23rd April.
3, Sriharsh Nilopant.
My lord, notice may be held sufficient in respect of R2.
What about R3?
We will take steps within 2 weeks.
Counsel for the petitioner seeks fund is granted 2 weeks' time to file necessary application to bring the legal opinion of deceased respondent number 3 on record, as also to make payment of process fee in respect of unserved respondent number 2. Needful is not done by 21st, relist on 25th for dismissal.
Please, my lord.
4, SP Dodgaudar.
Dismiss.
ಅಲ್ಲಿ ಏನಾಗಿದೆ
Time.
ಒಂದೇ ಒಂದು ಅಂದ್ರೆ ಅಬ್ಜೆಕ್ಷನ್ ಏನಂತಂದ್ರೆ ಇದು
Pass over,
ಜಜ್ಮೆಂಟ್
comply ಮಾಡಿ.
ಅಲ್ಲ ಅದು ಜಜ್ಮೆಂಟ್ ಅಪ್ಲೈ ಮಾಡಿದ್ದೀನಿ ಸರ್ ಸಿಕ್ಕಿಲ್ಲ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಒಂದು ಪೇಜ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ರೈಸ್ ದೆನ್ ಅಬ್ಜೆಕ್ಷನ್
Judgment ಅಲ್ಲಿ ಒಂದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿಯಲ್ಲಿ ಒಂದು ಪೇಜ್ ಇಲ್ವಾ?
ಹಾ ಒರಿಜಿನಲ್ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ
ಏನು
ಪೇಜ್ ನಂಬರ್
ಹೇಳಕ್ಕಾಗಲ್ಲ.
3 and 4 ಇಲ್ಲ
ಹ್ಮ್.
ಪೇಜ್ ನಂಬರ್ 24 25 ಆದ್ಮೇಲೆ 3 and 4 ಪೇಜ್ ನಂಬರ್ ಬರ್ಬೇಕಿತ್ತು.
53. ಏನಪ್ಪ 53?
ಅನೆಕ್ಸರ್ ಬಿ ಅಲ್ಲಿ
Annexure,
ಬಿ ಅಲ್ಲಿ
page
ಪೇಜ್ ಆಫ್ಟರ್ ಪೇಜ್ ನಂಬರ್ 25 ಲಾರ್ಡ್ಸ್
45,
25
25.
please. Suit bearing OS number 84 of 1972.
Page 3 and 4 are not there.
Yes. ಅದನ್ನ ಸರ್ಟಿಫೈಡ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್.
ಇದು ಸರ್ಟಿಫೈಡ್ ಅಲ್ಲ, ಇದು ಫೋಟೋ ಕಾಪಿ ನೀವು ನಿಮ್ಮ ಹತ್ರ
ಇವನ್ ನಾನು ಕ್ಲೈಂಟ್ಸ್ ಹತ್ರನೂ ಕೇಳಿದೆ, ಅವ್ರ ಹತ್ರನೂ ಕೂಡ ಇದಷ್ಟೇ ಇದೆ ಅಂತ, ಆ ಉದ್ದೇಶಕ್ಕೆ ಅಷ್ಟೇ ಒಂದು
5 ವರ್ಷ
ಅಲ್ಲ
ಒಂದು ಕಾಪಿ ಕೊಡಕ್ಕೆ.
ಇವನ್ ಇಟ್ ಇಸ್ ಓನ್ಲಿ ಬ್ರೀಫ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಆಫ್ ದಿ ಕೇಸು ಪೇಜ್ ಇದಾಗಿದೆ.
ಓದೋದು ಬೇಡವಾ? Counsel for the petition seeks fund is granted 1 week's time finally to comply with office objection. If
Please.
not complied with by 14th, relist on 18th for dismissal.
ಪ್ಲೀಸ್
Online apply ಮಾಡಿ ಸಿಗತ್ತೆ. ಜಡ್ಜ್ಮೆಂಟ್ ಕಾಪಿ
ಆನ್ಲೈನ್ ಇದು ಓಲ್ಡ್ ಸೂಟ್ ಆಗಿರೋದ್ರಿಂದ ಆನ್ಲೈನ್ ಇಲ್ಲ ಸರ್.
ಎಲ್ಲ ಅಪ್ಲೋಡ್ ಆಗಿದೆ.
ಐ ವಿಲ್ ವೆರಿಫೈ.
5, Santosh.
My lord.
Only what?
Seek for 2 days accommodation to comply with the fresh office notice there. My lord. I will verify and
For the petition seeks fund is granted 3 days time to comply with office objection. Relist on 11th.
please, interim order me kindly. Please.
Interim order earlier granted.
Highly obliged.
6, NL Bhatkurki.
Court commissioner.
Lord, in this case, I want to file a objection to commissioner report.
ಬಂದಿದೆಯಾ ಕಾಪಿ?
Yes, man.
ನೀವು ಕೋರ್ಟ್ ಕಮಿಷನರಾ?
Respondent 1 to 3.
You received copy? ನಿಮ್ದು ಏನಾದ್ರು objection ಇದೆಯಾ? ಹೇಳ್ಬೇಕು ಬೇಗ. Any objection? Counsel for respondent number 1 to 3 submit that he has no objection to the court commissioner. The report of the court commissioner. Counsel for the petitioner seeks fund is granted.
Maybe have on Tuesday, my lords, ready copies are ready. I will file in counter.
2 days time to file his objections to the report of the court commissioner. Relist on 12th.
7, Prashant Matpati.
Lord, office objection, my lord, two office objection. One is, my lord, revenue inspector have not made party, I'll do it like.
Give a counsel submission. Counsel for the petitioner seeks fund is granted a week's time to comply with office objection.
My
Relist
lord,
on
today
14th.
itself, my lord, I'll come.
ಕಂಪ್ಲೈ ಮಾಡಿ. ಡೇಟ್ ಕೊಟ್ಟಿದ್ರೇನು ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಸಬ್ಮಿಷನ್ ಕೊಡಲ್ಲ.
ನೋಡ, ಅಲ್ಲ.
ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಕ್ಲರಿಕಲ್ ಇದು ಮಾಡ್ಬೇಕು ಅಂತೀರಾ. So much of time gets wasted, matters won't be taken up.
I'll
They're
comply
wasting
today.
so much of time on orders.
Yeah, I'll comply, my lord.
ಮಾಡಿ. Next.
8, GR Turmari.
R1 not limited, I have filed a memo for held sufficient. He was an ex parte before the trial. R1.
Counsel for the petitioner submit that respondent number 1 was placed ex parte before the trial court. Hence, there would be no requirement of issuing any notice to respondent number 1. Yes. Ready?
Suit, please, Lord.
Ready? Ready.
This is suit for the respondent number 1 and 2 file suit for declaration and injunction, Lordship. They have make a conclusion that a compromise decree is passed on 28/11/2019, Lordship. Afterwards, they have not handed over the property to the present petitioner, Lordship. He is filed EP, Lordship, EP number 8 of 2020. In the EP, Lordship, this trial court is dismissed non-maintainable. It is coming for the final disposal. Court commissioner report is filed and a survey report is filed. Final.
Where is the order?
Lordship. Next page number 26, Lordship.
Page?
Page number 26.
26.
It is start from page number 24, decree of immovable property. The provision of under order 21 rule 35 of CPC is as under decree for immovable property. So first where decree is for the deliver of income, second, third lordship, and last in the last para lordship, it is satisfied law that the consent decree is binding on the parties entered in the agreement, but the agreement is silent about prayer of this execution petition. Hence, the decision is also not applicable to this petition. Hence, the execution petition filed by the applicant is not executable. Therefore, I proceed past the following. Dismiss one. This court commissioner report is filed already. It is for final stage lordship. At this stage, this honorable trial court is dismissed for non-maintainable. As per Annexure B, compromise.
Compromise illide.
Annexure B, lordship. Page number 42. That is mentioned, lordship. Second, Vadiyara ಮತ್ತು ಪ್ರತಿವಾರ ದಾವಾಸ್ತಿ ಶರದ.
Page 42.
Page number 42, lordship. Annexure B. Last second para, lordship. ವಾದಿಯರ ಮತ್ತು ಪ್ರತಿವಾದರ ದಾವಾಸ್ತಿ ಸೌದತ್ತಿ ಶರದ ರಾಮಾಪುರ ಸೈಟ್ TMC number 3105 ಇದರ CTS number 5728 ಕ್ಷೇತ್ರ ಪೂರ್ವ ಪಶ್ಚಿಮ 40 ಫುಟ್ ಅಂಡ್ ಉತ್ತರ ದಕ್ಷಿಣ 80 ಫುಟ್ ಇದ್ದು ಖುಲ್ಲಾ ಜಾಗ ಇದ್ದು ಇದರ ವಾದಿಯರು ಮತ್ತು ಪ್ರತಿವಾದರು ಈ ಹಿರಿಯರ ಸಮಕ್ಷ ಹಂಚಿಕೊಂಡಿದ್ದು ಈ ಕೆಳಗಿನಂತೆ ಇದೆ. This is the
yes. So the actually thing is that we had decided to dispose of the matter. So
it may be allowed.
Petitioner is before this court seeking for the following release. The petitioner respond number 1 and 2 had filed a suit in OS number 94 of 2005 for declaration
and
injunction. The said suit came to be compromised and a compromise decree drawn up on 28/11/2019, wherein both the parties had the plaintiffs and the defendants had agreed on certain terms and division of the properties. In pursuance thereof, the petitioner who was
petition number 1E, son of the deceased defendant.
Defendant number 1E had filed execution proceedings in execution number 8 of 2020 and an application and order rule 35 of order 21 was filed for enforcing the compromise decree. While the order dated 12/7/23, the trial court dismissed the said execution proceedings on the ground that what was sought to be executed was a compromise decree. And in the compromise decree, there was no agreement arrived at between the parties that in the event of any of the parties not complying with the terms of the compromise and or violating the conditions of the compromise, the aggrieved party can file an execution. The trial court further observed that a part of the agreement arrived at under the compromise having been complied with, an execution petition is not maintainable. It is challenging the said order that the petitioner is before this court. Learned counsel for the petitioner submit that a compromise having been arrived at between the parties, the same is required to be implemented by way of execution proceedings if not complied with by either of the parties. Counsel for the respondent also supports the case of the petitioner and submit that the division of the properties can only happen by way of a commissioner being appointed and the measurements being undertaken. The parties by themselves could not divide the properties in the manner as agreed upon in the compromise petition. Having heard both the counsels and heard perused papers, the short question that would arise for consideration is whether an execution proceedings is maintainable when there is a compromise decree drawn up. The trial court in the present matter has proceeded on the presumption that when a compromise is arrived at, the parties would comply with the compromise and as such, no execution proceedings have to be filed. Such a presumption is not available under law. Even if a compromise is arrived at between the parties and a compromise petition filed on which basis a compromise decree is drawn up, there could be certain aspects which would require enforcement at the hands of the court in execution proceedings. There could also be situations where the compromise could be acted upon by both the parties without the intervention of the court. Wherever intervention of the court is required, merely because there's a compromise entered into between the parties would not lead to a conclusion that execution proceedings are not maintainable. In that view of the matter, and taking into consideration the fact that the compromise in the present matter was for division of properties after marking of boundaries and carrying out measurement, I have the considered opinion that the trial court ought to have proceeded with the compromise with the execution proceedings and given meaning and purport to the compromise entered into between the parties. As such, I pass the following order. Writ petition is allowed. The order dated 24/7/2023 passed and so is set aside. Matter is remitted to the execution court to appoint a commissioner.
Already appointed, Lordship. He was
To act on the report submitted by the commissioner.
report also submitted, so I have produced the
To
next.
act on the report.
Please, Lordship,
of the
please.
report submitted by the commissioner and pass necessary orders.
9, HM Darigond.
Pass on, my lord.
Pass over.
10, Mantesh Hiremat.
Please, my lords, petitioner, my lords. Copy, sir, madam. Okay, my lords, I'll serve the copy.
Annexure E.
Yes, my lords, I have produced the map, my lords. In that map, my lords, it has been handwritten. Only for the reference I have been produced with that map.
Counsel for the petitioner submit that he has produced annexure E only for reference and would not be relying on the manuscript portion. Accepting his submission of his objection, CL number 15 is overruled. Copy Kotilwa. Counsel for the petitioner undertakes to furnish two sets of one set of a copy of the petition along with annexures. A learned AGA who seeks for and is granted a week's time to obtain instruction, make his submission. Released on 14th February. Learned AGA accepts notice for respondent 1 to 4 Anthamila.
Please.
11, Narayan B. Yazi.
But office objection in respect of 32 is concerned, may kindly be overruled.
Your counsel's submission, Mr. Yaji. We won't be taking up these kind of things. Learned AGA accepts notice for respondent number 1 to 4. Notice to respondent number 5 is deferred for now. Relist, a week's time is granted to counsel for the petitioner, comply with the office objection. Relist on 14th.
But urgency in the matter is, but in an identical case, but this honorable court has granted the interim order, where but the application filed by the
interim order idea.
Identical case ali ide.
Identical case gottilla. Why are you keeping this office objection for 2 years like this?
But of course, I have filed IA.
Connect with so and so.
Please.
Lord, it is date given is on 7/2. Other ಇನ್ನೊಂದು matter 7/2 date ಇದೆ.
7/2.
Please.
12.
But may make
notice issued to respond number 6 has been returned with the endorsement refused.
Lord,
service in respect of respond number 6 is held sufficient.
I'm not one sufficient. In the, that is assistant executive engineer Ballari. I accept notice. R6.
Refusing ಮಾಡ್ತಾರೆ ಅವರು. ಜನರಲಿ ಸರ್ವ್ಡ್ ಅಂತ ಬರುತ್ತೆ. ನಿಮ್ಮ ಅಸಿಸ್ಟೆಂಟ್ ಇಂಜಿನಿಯರ್ ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ? ಯಾವ್ದಿದು? Proposed respond number 6.
I filed the application for impleading.
R6 refused ಐತಲ್ಲ AWE ಬಳ್ಳಾರಿ
IA number
pleading application.
Just come.
ಇಲ್ಲ ಬರೀ ಇದನ್ನ ಅಷ್ಟೇ ಮಾಡಿದ್ರು ಜಸ್ಕಾಮ್ ಅಂತ ಹಾಕಿಲ್ಲ
O&M
66
ಇದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾಗ ಅವ್ರಿಗೆ ಸರ್ವಿಸ್ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳ್ಬೇಕು. ನೋಟಿಸ್ ಏನಕ್ಕೆ ಹೋಗ್ಬೇಕು ಇವ್ರಿಗೆ?
Just.com ಇತ್ತು.
ಅಲ್ಲ ಬರೀ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ಬಳ್ಳಾರಿ ಅಂತ ಅಷ್ಟೇ ಮಾಡಿದ್ದಾರೆ O&M
Bellary mind Jescom. Jescom standing counsel ilva.
Subsequently, they have.
I have appeared.
Respondent number
5
5.
Millard has appeared.
I appeal.
He's appeared.
Respondent number 6 ಹೆಂಗ್ refuse ಹೆಂಗ್ ಮಾಡ್ತಾರೆ?
ಇಲ್ಲ ನಾನಲ್ಲ. It is not me. Six ಯಾರು?
Assistant Executive Engineer owned them Bellary.
ಅದೇ ಬರೀ ಬಳ್ಳಾರಿ ಅಂತ ಇದೆ ಅದಕ್ಕೆ for that reason.
So ಯಾರಿಗ್ ಹೋಗಿದೆ ಗೊತ್ತಿಲ್ಲ.
ಅವ್ರು ಜೆಸ್ಕಾಮ್ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Jescom ಅಂತ ಬರ್ದಿಲ್ಲ ಇಲ್ಲಿ.
Respondent number 5 is the Jescom.
ಜೆಸ್ಕಾಮ್ ಅಂತ.
ಇದೇನ್ Jescom ಇದು?
Just come.
The Chandrasekhar R. Iramat, who has appeared for respondent number 5, accepts notice for respondent number 6 also. Registry is directed, proposed respondent number 6 also. Registry is direct, print his name as such. Accepting the reasons stated in support of IA 1 of 24, being of the considered opinion that the proposed respondents are also necessary parties, proper and necessary parties. The said application is allowed. The person named therein are brought on record as respondent number 5 and 6. Counsel for the petitioner to carry out necessary amendment and file amended cause title.
The matter
Yes.
pertain to widening up the road. Lord, they are saying that I have to accept TDR. My lords have posted another matter on 12th.
ಅವತ್ತಿನ ದಿವಸ
Will force him.
ಅಲ್ಲ ಅವತ್ತು
Portion of the building is demolished.
the other
Lord, after interim order, they have not touched the building.
Connect
Other-
with so and so and relist on
12th.
12th. Nim TDR bedwa
TDR better.
compensation.
Lord, there is already an order of this honorable court, my lord, directing them, my lord, to consider my representation for compensation.
Inna madilla.
Innu madilla. Subsequent, my lord, they demolished the building.
12th ಗೆ
A building will have to be put back.
ಅಲ್ಲ now we have after the interim order which was passed by this honorable court we have not touched Miller.
They are not agreeable for TDR. Acquisition proceedings have
Only
not been
Millers, two
completed. How
persons
can you demolish?
Out of 28 Millers, only 2 persons Millers.
One is enough.
That is true. None of
One member of a joint family is enough. You have to complete it.
yes.
Yes.
13
Lord, interim order may kindly be extended.
Interim order earlier granted is extra.
13 Prakash
My lord, office objection is.
In 29(5) ಏನಿದೆ? How the petitioner is aggrieved by this?
Respondent 6 filed the 7A application, my lord, on behalf of petitioner 1 to 10, my lord.
Respondent filed 7A application on behalf of petitioner 1 to 10.
Respondent 6, my lord, Devappa, or petitioner 1 to 10, ಅವ್ರ ಪರವಾಗಿ 7A application ಆಗ್ತಾರೆ. Came to be rejected, my lord.
ಎಲ್ಲಿದೆ ಅವರು ಅವ್ರ ಪರವಾಗಿ ಹಾಕಿದ್ದಾರೆ ಅಂತ?
ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೆ, ಅನೆಕ್ಸರ್ಸಿ my lord. ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲೌ ಮಾಡಿಲ್ಲ, ಆಮೇಲೆ ನಮ್ 7A ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿ. ಅನೆಕ್ಸರ್ ಡಿ ಇದು ಇಂಪ್ಯೂಡ್ ಆರ್ಡರ್ ಮಾಡಿ. ದೇವಪ್ಪ ಬಸಪ್ಪ ಶಿವಬಾಸಣ್ಣ ಅವರು. Respondent number 6, my lord.
ಸುರೇಶ್ ಸೋಮಪ್ಪ ಸಿದ್ಧ ಅರ್ಜಿದಾರ. ಇವಾಗ ಯಾರು ಫೈಲ್ ಮಾಡಿರೋದು ಇದು?
Suresh, one of the petitioner, my lord.
Now you are, there are
Suresh,
10 petitioners.
petitioner number 8, my lord.
There are 10 petitioners.
Please, ma'am.
How are they aggrieved by this order? They are not parties. Annexure D, they are not parties.
Annexure D, my lord. Sri Devappa Basappa ಶಿವಬಾಸಣ್ಣ ಅವರು, ಸಾಕಿನ್ ಹೊಳೆ ಹೊಸೂರು, ಇವರು ಸವದತ್ತಿ ತಾಲೂಕಿನ ಬೋದಿಗಪ್ಪ ಗ್ರಾಮದ. ಇದರಲ್ಲಿ ಅಫಿಡೇವಿಟ್ ಇಂಪ್ಲೀಡ್ ಮಾಡ್ಕೋರಿ ಅಂತ ಹಾಕ್ತಾರೆ ಸ್ವಾಮಿ, ಅದ್ರ ಬಟ್ಟೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿ.
ನೀವು ಫೈಲ್ ಮಾಡಿಲ್ಲ?
ಮಾಡಿದ್ದಾರೆ, ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ.
ನಿಮ್ಮ ಫಾರ್ಮ್ 7A ಎಲ್ಲಿದೆ?
ಅಲ್ಲ ಇವ್ರು ಹಾಕಿಲ್ಲ,
ಮತ್ತೆ
ನಾವು ಹಾಕಿಲ್ಲ. ನಮ್ಮ ಪರವಾಗಿ ರೆಸ್ಪಾಂಡೆಂಟ್ 6
ಪರವಾಗಿ ಹೆಂಗ್ ಆಗ್ತಾರಪ್ಪ? ದೇ ಆರ್ ಡಿಫರೆಂಟ್ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್. They don't belong to the same family.
ಅದ್ರಲ್ಲಿ ನಮ್ದು ಹಾಫ್ ಶೇರ್ ಇದೆ.
ಇವಾಗ ರಾಮಚಂದ್ರ ಜೋಶಿ
ಈಸ್ ಓನರ್ ಆಫ್ ದಿ.
ದೇವಪ್ಪ ಬಸಪ್ಪ
ಶಿವಬಾಸಣ್ಣ ಅವರು.
ಶಿವಬಸಣ್ಣ ಅವರು.
ಎಸ್, ದೇವಪ್ಪ ಬಸಪ್ಪ ಶಿವಬಸಣ್ಣ ಅವರು. ಅವ್ರಿಗೂ ನಿಮ್ಗೂ ಏನ್ ಕನೆಕ್ಷನ್? ವಾಟ್ ಇಸ್ ದ ರಿಲೇಶನ್ಶಿಪ್? Are you belonging to the same family?
ಹೌದು ಸರ್.
ನೀವು ಒಂದೇ ಫ್ಯಾಮಿಲಿನ ಏನ್?
ಒಂದೇ ಫ್ಯಾಮಿಲಿ. ಇಲ್ಲಿ ಇದರಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸರ್, ಪ್ರಕರಣದಲ್ಲಿ ಅರ್ಜಿದಾರ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಪ್ರಕರಣದಲ್ಲಿ ಅರ್ಜಿದಾರರು ತಾನು ದಾವಾ ಆಸ್ತಿಗಳ ಸಂಬಂಧ ಇಲ್ಲದಿದ್ದರೂ ಸಹಿತ ಕೊಟ್ಟಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರು ಗೊತ್ತಾಗಿರುತ್ತದೆ. ವಾಸ್ತವದಲ್ಲಿ ದಾವಾ ಆಸ್ತಿಗಳು ಜೋಶಿ ಎಂಬುವರು ಮೂಲತಃ ಆಸ್ತಿಗಳಿದ್ದು ಸದರಿ ಆಸ್ತಿಗಳು ನನ್ನ ತಂದೆಯಾದ ಸೋಮಪ್ಪ ಬಸಲಿಂಗಪ್ಪ ಸಿದ್ದಬಸನ್ನವರು 16 ಎಕರೆ 22 ಗುಂಟೆ ಎಲ್ಲ ನಮ್ಮ ಫ್ಯಾಮಿಲಿನೇ ಇದೆ.
ಸಿದ್ಧ ಬಸವಣ್ಣವರು ಇಲ್ಲಿ ಯಾರು ಪಾರ್ಟಿ ಯಾರು ಇದರಲ್ಲಿ? ಶಿವ ಬಸವಣ್ಣವರು ಸಿದ್ಧ ಬಸವಣ್ಣವರು ಬೇರೆ ಅಲ್ಲಪ್ಪ.
ಇಲ್ಲ, ಅವ್ರ ಪಾರ್ಟಿ ಇಲ್ಲ ಇದರಲ್ಲಿ. ಈಸ್ ನಾಟ್ ಎ ಪಾರ್ಟಿ.
ಪಾರ್ಟಿ
ಪಾರ್ಟಿ is only ದೇವಪ್ಪ ಬಸಪ್ಪ ಶಿವ ಬಸವಣ್ಣವರು.
ಶಿವ ಬಸವಣ್ಣವರು.
ಎಸ್, ಬಟ್ ಅಡ್ರೆಸ್ ಎಲ್ಲರೂ ಶಿವ ಬಸವಣ್ಣವರ ಅಂತಾನೆ ಇದೆ.
ಸಿದ್ಧ ಬಸವಣ್ಣವರು ಅಂತಿದೆ, ಅಲ್ಲಿ ಶಿವ
ಬಸವಣ್ಣವರ ಅಂತ ಇದೆ.
They are both different.
And their form number 7 has been rejected. That has been rejected. If he is agreed, then they would have come before this court.
They should come. ಅವ್ರು ನಿಮ್ ಪರವಾಗಿ ಹಾಕಿದ್ರೆ ಅವ್ರೇ ಹಾಕಕ್ ಹೇಳಿ ಪಿಟಿಷನ್.
ಅದಕ್ಕೆ ಸಂಬಂಧ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
For the petitioner seeks for and is granted.
Meantime, notice me.
First you satisfy this, ಆಮೇಲೆ ಅದು. Seeks for a week's time to make a submission as regards the maintainability of the above petition by the petitioner. Relist on 14th.
Please.
14 GA Gachinmat.
These matters, my lords, were heard on the last occasion. These matters pertains to, my lords, where the sale deed is executed in my favor, and thereafterwards, my lords, the will deed, my lords, is executed subsequent thereto. So the person, my lords, who has executed the sale deed in my favor did not have the authority to execute the will deed. Those circumstances, my lords, the mutation entries, my lords, are now, my lords, standing in the name of the person, my lords, who are the legatees claiming under the will. So therefore, my lords, the sale deeds, my lords, will have upper hand because it were prior to execution of the will. The order passed by the deputy commissioner, my lords, directing to register their names. Plaint is produced by them, my lords. Plaint, my lords, it's only suit for bare injunction that has been filed by me, my lords, before the trial court. Because during the pendency of these proceedings, my lords, taking undue advantage of their names being entered in the mutation by virtue of the orders of the deputy commissioner, my lords, they were trying to disturb my peaceful possession. Therefore, I was constrained to file a suit seeking for bare injunction. The matter is still pending, my lords, and my IM, lords, is also still.
There is no proceeding challenging the sale deed.
No.
My lords, I am representing the respondent number 5 to 9, my lords. My lords, kindly please look into page number 24, my lords.
24. Yes.
They have produced a registered sale deed, my lords. It is of dated 23rd August 1956, my lords.
Yes. Annexure A.
Yes, my lord. They say that the original landowner being Srimati Chikkanni Revaka, she had executed the sale deed, my lords. In that page number 24, my lords, there is no any either thumb impression or any signature of Chikkanni Revaka, my lords. So since there is a dispute, my lords,
Type copy ಇದೆಯಾ ಇದರದು?
they have not produced, my lords.
ಏನು ಅರ್ಥ ಆಗಲ್ಲ ಇದರಲ್ಲಿ. It's not there ಅನ್ನೋದಕ್ಕೂ ಗೊತ್ತಾಗಲ್ಲ, ಇದೆ ಅಂತಾನೂ ಗೊತ್ತಾಗಲ್ಲ.
Yes, my lord, it is not clear that, so only I am making the submission, my lords. It is not clear, my lords. So they say that the 23rd August 1956 registration seal deed is itself invalid, my lords. So only they may be subjected to get it decided before trial court, my lords. And the subsequent.
Jappa is the executor of the sale deed.
Lords, in the first case, lords, it has been executed in favor of Hansi Kotrappa.
ಎಲ್ಲಿದೆ ಅದು?
My lords, if my lords could kindly see the encumbrance certificate, my lords, the next document, that is at page number 30. Encumbrance certificate, that is 23/8/1956 is the first sale deed where the name is, my lords, Revaka, Ajappa and Shekappa. All three, my lords, execute the sale deed in favor of, my lords,
in favor of my grandfather, that is Kotrappa. Kotrappa is my grandfather, page
Where
30.
is
may kindly-
Revaka's thumb impression or signature?
Lords,
Where is she being mentioned? Her name is also not mentioned here.
And kindly please look into the connected matter, my lords. That is
First is
10.
one ನೋಡೋಣ ಆಮೇಲೆ.
Yes, sorry, my
ಇದು,
lord.
my lords, the encumbrance certificate, my lords, which has been
Encumbrance
issued.
certificate, we have to look at the sale deed, not
Yes, yes.
encumbrance certificate.
I will, my lords, I will clarify this aspect of the matter. But
Only
encumbrance, my
Ajappa
lords,
has signed it and Shekarappa has signed it. Revaka's signature is not there, nor name is mentioned, nor thumb impression. So whatever her right is there cannot have been conveyed.
Ajappa, Shekarappa. My lords, I think it is in page 25, my lords. I'll clarify that aspect of the matter. But if my lords could kindly see, my lords, page 30, that is the encumbrance certificate, wherein the first sale deed, my lords, is shown
Encumbrance certificate may be wrong, Mr. Kachinmat.
23/8/1956.
We are not concerned with the encumbrance, we are concerned about the sale deed.
Please, I will produce.
If the entry is not made properly, that won't give you.
Please. True, my
We'll
lords.
put
I will,
Gurudev Kachinmat's name also there.
correct. I'll place it, my lords. I'll get the
Encumbrance
clarification.
certificate cannot be relied upon.
I'll
The
get the
sale deed you will have to
clarification.
place.
Yes, I'll place it.
What about the other matter?
Connected matter, my lords, 105061, my lords. Page number 26, sorry, my lords, 25.
Idu type copy illa.
Adu, I will furnish the
Even in
typed
that,
copy.
there is no any thumb impression or
No, this
signature,
is
my lord.
the
Alla, it's certified copy idu.
certified copy.
Where is the original of it?
My lords, original, my lords, of 1976 sale deed, my lords, first sale deed in favor of my vendor, not me directly, my lords. Thereafterwards,
Copy produced.
I'll furnish.
Counsel for the
And-
petitioner seeks and is granted a week's time to produce typed copy of Annexure A in both the matters. And also make a submission as to whether there is any sale by Revaka of her share in the properties.
Please.
List on 19th February,
Next week itself, I'll place.
14th February.
14th February, please.
15, J. Gachinmat.
My lord, this is also
Same.
expected to
Same,
same, my
same.
lord. Even in page number 24, there is no any thumb impression or signature, my lord.
I'll furnish.
15, same order, connect to 14.
Please.
Amit Deshpande.
1 week's time is
No,
finally
my lord.
granted to
My
comply.
lord,
with
already
office.
completed the office objection, my lord. In last occasion, this honorable court has directed.
Your lordship may permit, my lord. I'm sorry, my lord.
Just a moment.
I'm sorry.
Regarding non-compliance, not been complied.
Already complied, my lord. In last occasion, I had taken the passover, my lord, and completed the office objection, and this honorable court has directed to a government to take an instruction, my lord.
You ನೋಡ್ತೀವಿ compliance ಇಲ್ಲ ಅಂದ್ರೆ we'll dismiss it now.
Please, I have already complied, my lord.
We'll see it. If it is not done, we'll dismiss it now.
Please.
We'll dismiss it.
No, my lord, I have complied, my lord. All.
It's not complied on the face of it.
Only the 3 office objections were there, my lord.
Yes.
One.
1 and 3 have not been complied with it.
No, I have already produced the
Counsel
typed
for the
copy.
petitioner.
My lord,
submit
typed
that
copy
he
is already produced.
the office objection. A perusal of the papers indicate that office objection at sale number 18-2 and 31-2 have not been complied.
My lord,
Since
Annexure
a
A is
false
there, my lord.
submission has been made,
My lord,
petition is
Annexure A
dismissed.
is there, my lord. Typed copy is
ಅದ್ರ
filed.
ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ 31-2 and 18.
Yes, I have made, my lord. That is regarding the interim prayer and prayer, my lord. That is bearing
Not
number is
made
not.
anything, Mr. Counsel. Don't make false submissions.
No, no, my lord, I'm not making a false
You are
submission.
making a false submission because it's not complied. You don't comply, you waste time. Dismissed.
May I intervene, my lord?
We are not hearing you, Mr. Deshpande.
My lord, since he was going on, we did not want to intervene, my lord. My lord,
17.
I shall undertake.
During course of the day, I will comply, my lord.
No, a false submission has been made, we have taken
I'm
note of
not-
it and
my lord,
dismissed
I have
it.
not made a false
You
submission.
file a recall application, we'll consider it. Next.
17, S. Patil.
My lord, meantime, we may be permitted to comply also, my lord, so that I can insert him.
It is dismissed, Mr. Deshpande.
Allah, permission ಕೊಟ್ರೆ comply ಮಾಡಿಸ್ಬಿಡ್ತೀನಿ.
ಇವಾಗ next recall application ಹಾಕಿದ್ರೇನು we won't allow it. Don't make these kind, don't take the court for granted. 17.
For the petitioner. I'll file with respect to serving report within 2 days, my lord, for the trial court advocate, my lords.
Waiting service, ಯಾವಾಗ dispatch ಯಾವಾಗ ಆಯ್ತು? And what is seal number 16?
My lords, page number 43 typed copy, I give submission, my lords.
Seal number 16 ಏನದು?
Typed copy, page 43 is not visible ಅಂತಾರೆ. As the, my lords, the order challenge is
Learned counsel for the petitioner submit that page 43 is the facing sheet of certified copy as furnished by the trial court. And as such, accepting his submission, office objection CL number 16 is overruled. Notice to respondent number 1 to 9 has been dispatched on 1/2/25. Awaiting service released on 25th February.
interim order granted earlier.
Interim order earlier granted is extended till next.
Please, your lordship.
18, Girish Adwad.
Office objection at serial number 12 is
Yes.
regarding submission of certified copy of the impugned endorsement at annexure G. It is a digitally signed document, my lords, as received by the petitioners 1 and 5, page 73.
Counsel for the petitioner submit the annexure G is a digitally signed copy received by the petitioner. In that view of the matter, office objection at CL number 12 is overruled. Yes.
But in this case, the petitioners are the-
Additional registrar judicial to instruct the concerned that when digitally signed documents are produced, not to raise an objection as regards non-production of certified copies.
But
Yes.
the petitioners are defendants in a suit instituted by respondent number 3. But the petitioners in this case are aggrieved by, my lord, insertion of an entry, if I may directly take, my lords, to page number 54, annexure E.
What is being entered is the order of injunction.
I'll just specify how it is entered, my lords. May kindly take page number 54.
What is being entered is only an order of injunction passed
Order
by
of
the court.
injunction, it says, my lord, OS number so and so, court order order dated January 11, 2024. Page number 54, my lords, may kindly. In column number 11, an entry is made, page 54. Annexure E, column 11, my lords.
Yes.
OS 132/2023 dated January 11, 2024, 12 AM month. Now, my lord, because of this entry, what is happening is, my lord, there are several government, my lord, schemes under which, my lord, these will be beneficiaries. And every year, my lord, they take loans from the cooperative society.
Future, all the orders passed by the court will be entered in the RTCs automatically. Kaveri and the court are going to be interlinked, have been interlinked. Is a pilot project. Every order passed by the court in the High Court or the trial court will be entered.
Yes.
That is the list pendants register.
I would, my lord, not be aggrieved if such an order is made. But the order passed by the trial court may kindly be seen. What is the order?
Page.
Yes. Page 49.
Yes.
The defendants or anybody claiming under them operative portion, my lord, are hereby restrained from alienating the suit properties or creating any encumbrance thereon until the next date of hearing.
Yes.
Now, this was confirmed, my lord, and it is page number 53, extended until further orders.
Yes.
Now, my grievance is, my lord, in the absence of any such direction to the Tashildar, to, my lord, insert the same in the revenue record. But it is, my lord, we have made it clear before the trial court also, as well as before the Tahsildar, that we are not at all, my lord, alienating the suit properties.
There is an order and there is a matter pending.
Yes,
So that will be reflected
the reflection,
to avoid multiplicity of suits.
ah,
The petitioner is before this court seeking for the following reliefs.
my ground in this writ petition, only one submission.
The learned AGA accepts notice for respond number 1 and 2, notice to respond number 3 is dispensed with in view of the proposed order to be passed.
Only one submission. I have relied on, my lord, provisions under the Karnataka Land Revenue Act.
27 and 150. Yes.
Please.
127.
127 to 129 and rules, my lord, in chapter 9 of the rules.
We'll deal with it. The petitioner is before this court aggrieved by the entry in column number 11 of the interim order of injunction passed in OS number 132 of 2023 dated 11/1/2024. The submission of Sri Girish Yadwad, learned counsel for the petitioner, is that without a specific order of the trial court, no such entry can be made in column number 11. And in this regard, he relies upon section 127 of the Karnataka Land Revenue Act and submits that in terms of section 127 and or 127 and 128, and submit that in terms of both section 127 and 128, no entry of an order of injunction can be made in the record of rights without a specific order of the court. Shri Girish Yadwad, learned counsel for the petitioner, and perused papers. A perusal of section 127 and section 128 would only indicate that it provides for entries to be made on an application made by any of the parties. The same does not relate to any order passed by a court of law. What would be applicable is section 52 of the Transfer of Property Act, which deals with less pendants. And in terms of section 52, there is a requirement for the court to for the court to maintain a list pendants register. It is in that view of the matter that the software implemented by the state for registration of documents, as also for maintenance in terms of Kaveri, called Kaveri, and the software implemented for maintenance revenue documents relating to the properties named Bhumi has been developed by the state. The said software of both Kaveri and Bhumi now having been integrated with the court system, any order passed by the court is directed to be entered into both Kaveri and Bhumi so as to prevent unnecessary litigation and transaction as regards the property, which is subject matter of litigation. The entry made in column number 11 is in pursuance of section 52 of the Transfer of Property Act dealing with list pendants and constitutes a list pendants register. As such, there being no dispute that there is an order of injunction passed by the additional senior civil judge Jamkandi in OS number 132 of 2023. The said order having been entered into in column number 11, I do not find any infirmity in the said order. Section 127 and 128 of the Karnataka Land Revenue Act relied upon by Sri Girish Yadwad would not be applicable to the present case. No grounds being made out, the petition stands dismissed.
This may not come in the way of petitioner seeking permission from the trial court to do any transaction.
Needless to say, in the event of the interim order being vacated, varied, vacated, modified, the same would automatically get reflected in column number 11 of the RTC.
Obliged.
19, Shivraj Balloli.
Complete copy of Annexure B.
Please, my lord.
Weeks time
In
may be
fact,
granted minutes. Senior is out of.
may be taken up on Monday, my lords, regarding council submission. Annexure B, we have furnished the entire document, entire judgment. In fact, the pagination given by Learned trial court appears to be incorrect, my lords.
Is as furnished by the respondent before the trial court is not a good submission. You have to submit the full copy.
Please, my lords.
Or arda kotru nanu kaal bhaga ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ.
No, I'm sorry, my lords.
You have to give the full copy.
Lord, in
Counsel
fact,
for the petitioner seeks fund is granted 4 days time to comply with the office objection at CL number 32-1. Relist on
Monday.
12th.
Monday, my lords.
ಅಷ್ಟೊಳಗೆ ಆಗತ್ತಾ?
Please, my lord, in fact, on humble submission,
Released on 10th.
page number, it starts from 3. The pagination given by learned trial court is itself.
Wasting time on all this. Full copy kodakke.
Annexure B is at page number 29. In fact, from second page, the page number is given as 3. That is incorrect. So the office has raised objections.
ಇನ್ನ ಒಂದು ಪೇಜ್ ಇರುತ್ತೆ. From when the evidence started, when it was recorded, when it was completed, ಇದೆಲ್ಲ ಬರುತ್ತೆ.
I shall.
20, A.S. Patil.
Amendment, my lord, I will do it. During the course of the day, my lord, I will come. I have filed the amended petition already.
Affidavit and report ಯಾರು ಕೊಡ್ಬೇಕಾಗಿತ್ತು?
But the municipal council was directed to file the respond number 1. Entry order dated not.
That has been submitted.
When have you submitted?
On 31st, 31/1.
30?
31/1/2025. 31st January.
Yes.
Copy is not served to us, man. Patila. I collected it.
ಯಾಕಪ್ಪ ಅನ್ನೆಸರಿ ಇದೆಲ್ಲ ವೇಸ್ಟ್ ಆಫ್ ಟೈಮ್ ಇನ್
On Monday,
ಒಂದು ಕಾಪಿ ಕೊಟ್ರೆ ಮುಗಿದ್ ಮತ್ತೆ ಲಿಸ್ಟ್.
on Monday.
Next week, not 13th or 14th.
Learned counsel for the petitioner seeks for a day's time to carry out the amendment. Counsel for the respond number 1
Please.
seeks for a day's time to furnish copy of the report submitted by the respond number 1 before this court to the counsel for the petitioner and respond number are 2 to 5.
Yes.
They said copies to be furnished by end of day 6th February, released on 12th February.
Please. Interim order not
Interim order earlier granted is extended to next.
Please.
21, Sharad Patil.
But instead of 12th, may I request 13th, my lord?
13th.
Please.
21, Sharad Patil.
My lords, your lordships,
For the respondent in this case.
my lords, your lordships ordered me.
Citing.
No such address R2 to R4.
My lords, Sargin Kotal, my lords, they have not been appointed as an advocate. My lords. I have heard they have not kept any advocate, my lords, before the trial court.
No such address ಅಂತ ಬಂದಿದೆಯಲ್ಲಪ್ಪ.
Alla, my lords, I'll take that fresh steps. 2 days time will be.
ಅಲ್ಲ advocate ದೇ no such address ಅಂತ. It is mentioned as to serve to the advocates appearing for the respondent. And even one submission, your lordship, in this case, as per 105 Cooperative, Karnataka Cooperative Society Act, it itself is not maintainable. They have to approach before the society.
What have you challenged?
My lords, your lordships, my lords, order me kindly see, my lords, 7/1/2025, my lords. Lordships have ordered me, lords, to deposit the 50% of the amount, my lords. Amount is not deposited, my lords. My lords, only one submission, my lords. 3 months time will be granted, my lords. I'll deposit the entire loan amount.
ಇವಾಗ 4,50,000 ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ. They will not do that.
Lords, I'll make one submission. Lords, within 3 months, my lords, I'll deposit the entire loan amount, my lords. Otherwise, my lords, I'll withdraw this writ petition itself, my lords.
Next bench, other next bench, other next bench, no chance.
Order may be passed, my lords. Within 3 months, my lords.
We are
I'll deposit-
dismissing your petition now. Order will be passed now.
Please.
Despite the order dated 7/1/2025, the amount directed to be deposited has not been so deposited. It is therefore clear that the petitioner is not diligent in prosecuting the matter. The petitioner also having alternative efficacious remedy in terms of appeal to the registrar to challenging annexure A, reserving such liberty, the petition stands dismissed.
Much obliged.
Obliged.
22, Rajendra Patil.
Service of notice is awaited.
Notice to respond number 2 to 7 has been written.
Lords, I undertake to file wakalat for respond number. Undertake to file wakalat for respond number 1, my lords.
1.
1, my lords.
1 is awaited, my lord.
2 to 7 is written with the endorsement refused. In service in respect of respond number 2 to 7 is held sufficient. Registry is directed to print their respective names with the endorsement refused. She so and so submits that you would be entering appearance for respond number 1. Registry is directed to print his name as such after filing of wakalatnama.
Memo is filed, my lord, serving the copy.
8 ಏನಾಯ್ತು?
Memo is copy is served, my lord, and acknowledgement is filed.
R8 appear ಆಗ್ತೀರಾ ನೀವು R8 ಗೆ?
R8, R9, R10 served, my lord.
Served ಅಪ್ಪ ಯಾರು appear ಆಗ್ತಾ ಇದ್ದಾರಾ?
ಇಲ್ಲ, R1.
Only on behalf, I have.
There's only to facilitate you to serve. If they don't appear, ಮತ್ತೆ notice ಹೋಗ್ಬೇಕು.
Now the R8, R9 and 10, it is served. R9 and R10, they are press ex parte for the trial court.
R8 is served.
Served. 9 and 10 also served, but they have,
7. ಇನ್ಯಾರು ಉಳಿದ್ರು?
no, ಅಷ್ಟೇ ಸುಮ್ಮನೆ R1 to R10.
ಅಷ್ಟೇ ಅಲ್ಲ?
ಅಷ್ಟೇ ಅಷ್ಟೇ.
Yes.
A week's time accommodation, my lords.
ಏನಿಲ್ಲ?
Lords, I'm submitting on behalf of proxy counsel, my lord, Shekhar Gowda Nagnuri, since there's some inconvenience.
Counsel for respond number 2 to respond number 1, relist on 12th.
Please, please,
Entry model.
Entry mod earlier is extended till next week.
please.
23, Gowda, T.
I appears for petitioners notes. But sir, I completed the office objection with respect to
ಏನ್
office
complaint?
objections number 3 and 10 minutes. I made a submission before a lord's.
Yes. 5 and 44 and 45.
How, as per the earlier office objections minutes, I complied it. With respect to only succession certificate is concerned minutes, I have filed a suit for succession certificate. I will produce the orders before the suit. Other objections are all complied minutes.
It's not complied, Mr. Counsel. Please don't make that submission, making us dismiss.
As yesterday, as earlier, they have raised the objections minutes. As per their objections minutes, court fee paid minutes, affidavit of shown before the competent authority. I think afterwards they might have raised the further objections minutes. If your lordship permits,
In
I will.
submissions, nodi, ನೀವು ಬರೆದ್ರು ಯಾರು ಬರೆದ್ರು? Counsel for the petitioner seeks for and is granted 10 days time to comply with the office objection. We list on 17th.
Fix a date minutes, then I'll.
17.
Please.
24, Vidya Shankar, Dharwad.
Kindly pass on, he's held up in some other matter.
Pasho. Yeah.
25, Jagdish Patil.
Today I filed power for 8, 9, 12, 13, 15 and 16 members. So accepting 6, I have appeared for the contesting response.
1 to 5 and 7 to?
1 to 5. Earlier I had appeared for 5, 7, 10, 11 and 14 members.
So 5,
5 is, I am a
7 to 14, huh?
14.
PG Naik submit that she has filed wakalatnama for respond number 5 and 7 to 14 registered to verify.
My lords. Further I filed 8, 9, 12, 13, 15 and 16 members. I filed today.
You will file today.
Allah, only one person I cannot appear. Respond number 6, my lords.
There are 28 respondents. State is appearing for 1 to 4. So 5 to 28 apart from 6 appear ಆಗ್ತೀರಾ?
Allah, 5 to 28. Allah.
ಮತ್ತೆ
Last
ಯಾರ್ಯಾರು
person is 16. Up to 16, my lords.
15 na 16 ಮಾಡಿ. What about 17 to 28?
They are not
Then I
the
have to take
contesting.
steps. Then
Issue notice to respond number 17 to 6, 17 to 28.
Please.
Returnable by 19th March.
interim order to be also.
Interim order idea? Interim order earlier granted is extended
Not to precipitate the matter.
till next date of hearing.
26, I.I. Jalgar.
My lords, yes. Sorry, my lords. Earlier matter. Date may be fixed.
19th March.
ಬಹಳ ದೂರ.
ಸರ್ವಿಸ್ ಆಗಿ ಬರ್ಬೇಕು. ಅದಕ್ಕೆ ನೀವು ಅಪೇರ್ ಆಗ್ತೀರಾ ಅಂತ ಕೇಳಿದ್ದು.
20th ಬೇಕಾದ್ರೆ ಅವರು 20th will take chance. 20th
They are all
February.
In 20th of what?
February ಅವರು
10 ದಿನದಲ್ಲಿ ಸರ್ವ್.
Yes.
ನಿಮ್ಗೆ ಅಲ್ಲಿ ಪ್ರೋಸೆಸ್ ಬರೆಯೋದೇ 10 ದಿನ ಆಗುತ್ತೆ.
26, I.I. Jalgar.
Office objection at serial number 28. My lord, ink page 27, my lord. My lord, OS number, my lord, it appears
And
as
counsel for the petition submit that you will not be relying on annexure G1, E2, F1 and F2. Hence office objection serial number 28 is overruled.
not relying, my lord, it's reference, my lord. For reference, my lord, a copy.
Insofar as office objection serial number 54 is concerned, he submit that there is a typographical error in as much as what was to be mentioned is OS number 46 of 2017, of which the plaint has been produced and not OS number 14 of 2017.
Yes.
His submission is accepted, office objection serial number 54 is overruled. Yes,
My lord, short point is, my lord, my lord, plaintiff has filed, my lord, plaintiff, my lord, petitioner is a plaintiff before the trial court, my lord. Only she files a suit for partition, my lord, against her children, my lord. First property is, my lord, for partition, my lord, and second property, my lord, is, my lord, to declare the gift deed as a null and void, my lord. Thereafter, my lord, at the time of cross-examination, my lord, the DW4, my lord, defendant number 4 produced a document showing that, my lord, the property number 1, item number 1 is also, my lord, is also gifted, my lord, by changing a Kata extract in the year 2017, my lord. So, my lord, hence, my lord, I seek for amendment of, my lord, amendment of the plaint, my lord. Because, my lord, initially, my lord, in the year when I am filing the suit, my lord, the property number was standing in the name of
Husband.
husband, my lord. Thereafter, my lord, in 1 month only, my lord.
Notice to respond number 1 to 4.
My lord,
Returnable by 24th March. The further proceedings in OS number 46 of 2017 pending on the file of the third additional senior civil judge and JMFC Ubulli. He stayed till the next date of hearing. Process fee and copies to be furnished by end of day 7th February. Acknowledgement of service on the respective counsel for respondents to be filed on or before 13th February. Failing either of which, the interim order will stand automatically vacated.
my lord, meanwhile, my lord, notice to defendant, that is respondent number 1, 2, 3, my lord, may kindly dispense with, my lord.
Our ring dispense madaka.
Alla, my lord, they are not the contesting party.
Sir,
Please,
Madi.
please.
27, Gayatri SR.
Lord, the petitioners, Lord, sought for building permission to construct.
Typed
Lord,
copy of ಎಷ್ಟು documents, Mr. Nadav?
ಎಲ್ಲ legible ಇದೆ this one. If my lord, of the opinion that I have to produce, I will produce, my lord, the typed copy. Annexure D.
Q is not legible.
Then I will produce, my
ನೀವೇ
lord.
ಓದ್ಬೇಕದು.
ನಾನು ಹಾಕೊಡ್ತೀನಿ. I will, my lord, within 1 week, my lord, I will get all the copies typed.
Counsel for the petitioner seeks fund is
My lord,
granted.
the urgency is, my lord, even in spite of, my lord, I have submitted application in 2022. Earlier, they granted me permission. Your lordship kindly see, my lord, the permission is at, my lord, page number 52, annexure J1. They have permitted me to construct the building. I commenced the, my lord, construction. Subsequently, they said, my lord, that there is dispute, my lord, there is, my lord, mistaken, my lord, boundaries in the title deed as well as the, my lord, form number 3 issued by the Patana Panchayat. My lord, there was, my lord, inquiry was held. I was advised to, my lord, get the mistake corrected. Accordingly, my lord, I made an application as per annexure K, page number 55, dated 31/10/2000. My lord, boundary on east, it was mentioned as library instead of, my lord, Gauntana or open space. That was the only mistake. Subsequently, I got it corrected, my lord, and thereafterwards, my lord, I applied.
So, Gramtana special library ಕಟ್ಟಿದ್ರಾ?
ಅಲ್ಲ ಲೈಬ್ರರಿ ಅಲ್ಲ, ಅಲ್ಲಿ ನನ್ನ ಪೂರ್ವಕ್ಕೆ ಗಾಂವ್ ಓಪನ್ ಸ್ಪೇಸ್ ಇತ್ತು, ಅದನ್ನ ಲೈಬ್ರರಿ ಅಂತ ಬರೆದ್ಬಿಟ್ಟಿದ್ರು ಫಾರ್ಮ್ ನಂಬರ್ 3 ಅಲ್ಲಿ, ಅರ್ಲಿಯರ್ ಫಾರ್ಮ್ ನಂಬರ್ 3 ಅಲ್ಲಿ. ಐ ಗಾಟ್ ಇಟ್ ಕರೆಕ್ಟೆಡ್, ಮೈ ಲಾರ್ಡ್, ಆಫ್ಟರ್ ದಿ ಅಪ್ಲಿಕೇಶನ್, ವಿಚ್ ಈಸ್ ಅಟ್, ಮೈ ಲಾರ್ಡ್, ಪೇಜ್ ನಂಬರ್ 57, ಮೈ ಲಾರ್ಡ್, ಅನ್ನೆಕ್ಷರ್ ಎಲ್. ಚಕ್ಕುಬಂದಿ ಪೂರ್ವ ಗಾಂವ್ ಅಂತ ಮತ್ತೆ ಕರೆಕ್ಟ್ ಆಯ್ತು ಚಕ್ಕುಬಂದಿಯಲ್ಲಿ, page number 57 ಅಲ್ಲಿ. Subsequently, my lord, I applied on 25/7/2024 for construction of building. Till, my lord, December, they have not given any, my lord, orders. In December, my lord, they say they issued, my lord, an endorsement stating that ನಿಮ್ಮ ಮೊದಲನೇ ಅಪ್ಲಿಕೇಶನ್ಗೂ ಮತ್ತು ಈ ಕೊಟ್ಟಿರೋ ಅಪ್ಲಿಕೇಶನ್ಗೂ ಬೌಂಡ್ರಿ ಮಿಸ್ಟೇಕ್ ಇದೆ ಅಂತ. ಮೊದಲನೇ ಅಪ್ಲಿಕೇಶನ್ ಅವರೇ ಹೇಳಿದ್ದಾರೆ ತಪ್ಪಾಗಿದೆ ಅಂತ ಹೇಳಿ ನಾನು ಮಾಡಿದ್ವಿ. ಸ್ಟಾಪ್ ಮಾಡಿದ್ದಾರೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್.
Who is the respondent?
My lord, the chief officer Patana Panchayat, my lord.
Yeah, standing counsel here.
Standing counsel ಯಾರು? Patana Panchayat, my lord, ಭಾಗ್ಯನಗರ, ಕೊಪ್ಪಳ.
Shri Vijay Kumar Balgermat is directed to accept notice for the respondent. The operation of the endorsement dated 17/12/24 bearing number so and so at annexure P and P1. He stayed till the next date of hearing. Relist on 12th February.
Please.
28, CS Sitter.
Apologies, my lords. There is urgency in the matter, my lords. I am seeking for an interest. We will comply the office objection, my lords.
meanwhile.
Counsel for the petitioner seeks for and is granted a week's time to comply with office.
Urgency, there is urgency in the matter, my lords. I am seeking for an interim stay. Petitioners are the purchasers, my lords. The proposed applicants. Application under Order 1 Rule 10 has been rejected by the trial court.
Who are you? Who are the
I am
applicants?
the purchaser of the item number 2 property, my lords. My vendor is the defendant number 17. Respondent number.
You are a little late. Last week, Supreme Court judgment has come. You are not entitled to be.
I am relying upon the judgment of this honorable court principal bench, my lords.
Supreme Court judgment bere bandidiyamma.
My lords,
You'll be
today
bound by it without paying.
I am, my lords,
Pass over, note Supreme Court judgment, note it. Pass over.
please, my lords.
29, NP Vivek Mehta.
She is the widow of respondent number 1.
Filed by?
Widow of respondent number 1.
You have filed?
Yes, I have filed. It has been.
Neven alone. During the pendency of the matter, respondent number 1 expired on?
11/8/2019.
Though it was for the petitioner to file necessary application to bring the legal representative of deceased respondent number 1, the legal representatives themselves have filed an application IA-2 of 2025 seeking to come on records. Accepting the reasons stated therein, delay of 1909 days is condoned. Abatement in respect of respondent number 1 is set aside, and the person's name therein are brought on is brought on record as respondent number 1A. By accepting the submission of learned counsel for respondent number 1A that there are no other legal representatives of deceased respondent number 1. Counsel for the petitioner to carry out necessary amendment and file amended cost title.
Call next week. My lord.
Matter is a compromise.
Compromise agide.
ಅದಕ್ಕೆ ಅಲ್ವಾ
That is.
ಯಾವಾಗ ಪಾರ್ಟೀಸ್ ಬರ್ಬೇಕಾ ನೀವು
Parties ಬರ್ಬೇಕು.
ಯಾವಾಗ ಬರ್ತಾರೆ?
12th ಬರ್ತಾರೆ.
Yes.
12 next.
Both the counsels submit that the dispute between the parties has been resolved amicably, and if the matter is taken up on 12th, my compromise petition would be filed by keeping the parties present. Released on 12th at 2:30 p.m.
2:30.
For reporting compromise. Madam.
30, PG Mogali.
Number 6 died, my lord, heirs are filed to bring elders on record. Notice has to go, my lord.
Notice ಹೋಗ್ಬೇಕಾ?
So far as far as 17 is concerned, filing memo of number seeking dispensation of notice.
4 and 17.
4, my lord, the 1 to 4 are, my lord, the appellants before the trial court. So Karnataka appears for the respondent 1 to his brothers. He can take notice for respondent 4 also.
Where is he?
Not there.
17 ಏನು?
17, I am filing memo seeking dispensation of notice for. She is dealing with the petitions also.
Counsel for the petitioner has filed a memo seeking for dispensation of notice to respondent number 17. Accepting the said memo, notice to respondent number 17 is dispensed with as sole risk, cost and peril of the petitioner. The respondent number 4 was also a petitioner before the trial court, a plaintiff before the trial court.
But the appellant before the RA court, appellate court.
Trial court ಅಲ್ಲಿ?
RA appellate court, my lord.
Trial court ಅಲ್ಲಿ ಏನು?
Trial court he was sorry. Defendant, my lord.
Was it co-defendant before the trial court? Was a defendant before the trial court and the appellant before the first appellate court, for whom a single counsel appeared. Shri K. Karunakar, H. Karunakara has entered appearance for the other appellants. In that view of the matter, he is directed to accept notice for respondent number 4 also. During the pendency of the above matter, respondent number 6 has expired. Hence, IA 1, 2 and 3 of 2025 have been filed. Issue notice on IA 2 and 1, 2 and 3 of 2025 returnable by 24th April.
By interim order.
During the pendency of the above matter, petition number 1 has expired.
Memo.
Hence, a memo has been filed to treat petition number 2 to 5 as his legal representative. Said memo is accepted. Petition number 2 to 5 are treated as the legal representative deceased. Petition number 1, counsel for the petitioner to carry out necessary endorsement in the cost list. Interim order earlier granted is extended till next date.
31, HR Deshpande.
I refer for the respondent, my lord, I have filed application for seeking vacating of interim order.
Main merits ಮೇಲೆ
ಅಲ್ಲ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಪ್ಲೀಸ್
ರೆಡಿನಾ ಇಬ್ರುನು?
ಹೌದು
Yes.
I'm ready.
Yes, Mr. ಹೇಳಿ.
I had filed this writ petition, my lords, challenging the orders on IA1. IA1 was filed by the plaintiff to amend the plaint prayer, my lords. And in fact, the earlier, both father and son, they have filed two writ petitions in respect of the land acquisition matters. And the plaintiff had entered into an agreement of sale. And earlier to that, the lands were acquired. And subsequently, after framing of issues, he wanted to include one prayer seeking a compensation from the acquisition authorities. That application was allowed. And
Suit for specific performance.
yes, my lords.
So if specific performance application is, if a specific performance is allowed, to direct the compensation to be
Yes,
paid.
yes, ma'am. And that was earlier also, my lords. The coordinate bench of this Honorable High Court, my lords, they have allowed the writ petition.
ಯಾವ್ದು writ petition? ಇದರಲ್ಲಿ the sale, the acquisition was prior to the agreement of sale or after the agreement of sale?
Agreement of sale, Your Lordship. Lord,
Prior, my lords.
one more judgment.
Acquisition was prior to the sale agreement.
Lord, one more judgment, Your Lordship. Lord, that judgment is passed, my Lord, relying on the, my Lord, judgment passed in the year 1996. Now, my Lord, the Supreme Court, my Lords, in this case, Lordship, it is, my Lord, held. And, my Lords, kindly see, my Lords, page number, my Lord, para number 12, 13, and 14. Now, so far as the amount of compensation, my Lord, para number 8, Your Lordship, I'll come from that, Your Lordship. The similar issue is involved, Your Lordship, wherein it is stated that, my Lords, if an agreement holder, my Lord, he is filed, my Lords, suit for seeking decree of, my Lord, specific performance of contract. Under such circumstances, if that suit schedule property is acquired, my Lord, he is entitled to make, my Lords, the prayer, my Lords, to get, my Lord, compensation. Para number 8, may I read, Lord?
Mr. Card, your only question is whether the acquisition notification was issued prior to the agreement of sale or after the agreement of sale.
That will make, I will make that submission, Lordship. What has happened, my Lord, in this?
The answer ಮಾಡ್ಬಿಡಿ
ಅಲ್ಲ.
ಆಮೇಲೆ next ಹೋಗೋಣಂತೆ.
First, my Lord's acquisition.
I have produced Annexure D, my lords. Annexure D.
My Lord, what has happened? Lord, he is the, my Lord, owner of the land, Lords. He, my Lord, entered agreement, my Lord, with the, my Lord, the plaintiff in the year 2013. Lord, at the time of execution of the, my Lord, agreement of sale, he did not disclose about the, my Lord, execution proceedings, issuance of 4-1.
What check did you do about acquisition?
Lords?
You cannot say I did not know about acquisition.
No. It is, my Lord, because of that reason, my Lords.
You cannot, you won't be entitled for compensation.
I'll make submission. Lord, we have filed, my Lord, a suit for seeking specific performance of contract. Only after filing the written statement, my Lord, only after he disclosing, my Lord, the, my Lord, fact of, my Lord, acquisition of the proceedings, then only, my Lord, the plaintiff came to know about the, my Lord, acquisition proceedings. Thereafter, my Lord, issue is framed. And immediately thereafter, we have filed, my Lord, application for seeking
The
amendment.
fraud committed as per what you are saying, there cannot be specific performance. On your submission itself, your suit will be dismissed.
Hello.
If we record that submission, your suit will go.
Lord, he entered, my Lord, agreement, my Lord, with me. He has taken, my Lord, such, not about 90% of the amount.
Yes, you will be entitled to refund of that amount.
And, my Lord,
If you
it
are
is,
able
my
to
Lord, I am
establish,
seeking for the amendment of the, my Lord, the plaint as well as not the prayer.
you cannot get the compensation amount of that land as regards which land which had been acquired prior. Even if specific performance is granted, it will be at the rate of the acquisition.
Lord, in the, my Lord, subsequent judgments, my Lord, apex court, my Lord, held, my Lords, there are number of judgments, my Lords, wherein, my Lord, the position of law is
From what we
declared.
are aware, even this judgment that you are speaking of,
Here, in this case, what has happened, my Lords?
you do know that after the filing of the suit, but before passing of the final decree, land in question came to
But
be
the
acquired.
position of law, my Lord, it says, Lord, if the question, the land in question is acquired during the proceedings,
During the
whatever,
proceeding, no problem.
here in this case, during the proceedings,
Prior.
in my case,
In your case, prior. Acquisition was prior.
In this case, during the proceedings, during the pendency of the, my Lord, proceedings, it is acquired, and they sought for, my Lord, that prior lordship. That was granted.
Yes.
That was affirmed by the apex court lordship. There are other instances, my Lord, wherein, my Lord, I will bring, my Lord, all the judgments to lordship.
Learned counsel for respondent, after arguing for some time, seeks for a week's accommodation to place on record a judgment
bring all the
indicating
judgments.
that even if acquisition had been commenced prior to an agreement of sale, subject matter of the specific performance suit, the agreement holder stroke plaintiff would be entitled for the compensation amounts. Relist on 14th.
14.
One submission, my lords. 16th, it may kindly be.
16th. 16th. 17th.
Yes.
16th Sunday.
Please.
32, Prashant F. Gowda.
Section 5B.
Yesterday,
Yes.
this memo dated 3/2/25, my lord, wherein they want to show that section 5 subsection 3 at page 38.
Page
number 38, no. Started 38, it's on 39. Subsection 3, notwithstanding anything contained in subsection 1. A, every tenancy shall subject to the provisions of section 24 and 25 be liable to be terminated at any time on any of the grounds mentioned in section 14, and B, my case falls under this one. A tenant may terminate the tenancy at any time by surrendering his interest as a tenant in favor of the landlord, provided that such surrender shall be in writing and shall be verified before the Mamlatdar in the prescribed manner. The very same document, you know, I had produced yesterday. Page 139.
139 of the petition.
137 of my petition, Annexure G. So we read that Kannada version.
Yes.
And this is a Kannada one. This is a letter by the tenant. Yesterday we read that. Very same one has been produced and marked as Exhibit D1 in the year 1994. That page number 635 of the Land Tribunal records.
Records ಇರ್ಲಿಲ್ಲ ನೆನ್ನೆ ಅಂತ
635. 635. 635.
ನೋಡಿದ್ದೀರಾ?
Yes.
That is in Marathi.
Marathi.
But that's a Kannada translation which,
This is not in Kannada.
if that is in Marathi, that what I have produced is a Kannada translation. That's a
Marathi,
letter.
Kannada translation, ಆಮೇಲೆ English. Yes.
It's of the year 1955, my lord, wherein the, and subsequently there is a mutation entry at page 637. There is a diary, ME number 707.
Where is the Tahsildar's Mamlatdar?
That the
Mamlatdar is a Tahsildar.
Tahsildar. Initially verified by the village accountant.
35.
There is a diary mutation entry, my lord,
71.
Yes, ME number 707.
Now, what you have produced at page 137 and 138 is different from what is at page 635.
This is produced.
35 is the
This document is produced in suit. The page 137.
Annexure G ನೀವೇನ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
Yes, sir.
Is not what is here.
No, that is in Marathi, my lord.
ಮರಾಠಿ ಆದ್ರೇನು ಈವನ್ ಎಕ್ಸ್ಪೇಸಿ ನೋಡಿದ್ರೆ ಇದ್ರಲ್ಲಿ 10 ಲೈನ್ ಇದೆ, ಇದ್ರಲ್ಲಿ 25 ಲೈನ್ ಇದೆ.
Same, similar.
It can't be that translation will make it 25 lines and there are so many other signatures ಇದ್ರಲ್ಲಿ.
It is there on the next 635 and 636, my lord. Back side ಅಲ್ಲಿ there is a endorsement.
Ex-specie, it doesn't appear to be so.
And there is a mutation entry also on 1156.
ನಿಮಗೆ ಮರಾಠಿ ಬರುತ್ತಾ? ನೋಡಿ, it
Bharat.
doesn't appear to be so.
No,
on
no,
the
no.
face of it.
No, my lord. I can read.
ಇದ್ರಲ್ಲೆಲ್ಲ ನೀವು ಸಿಗ್ನೇಚರ್ ರೆಫರೆನ್ಸ್ 749
Yes, my lord.
ಏನೇನೋ ಹೇಳಿದ್ದೀರಾ, ಇಲ್ಲಿ ಯಾವುದು?
It is all raised. ಮರಾಠಿದಲ್ಲೇ ಬರೆದಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆಯಪ್ಪ?
And after this, there is an order
Is it the same, Mr. Mangi?
based on that
Lord,
application of tenant, my lord.
35 and 137 is the same.
There is slight variation in the document.
Slight variation, no?
You know, this document, which my learned friend refers to as 137, is produced in suit.
It is not
Translated
this.
also.
Yes. My lord, my lords may kindly see the seal below that, my lord, on page 137. 137, my lord. Exhibit D1A, seen, my lord, the seal of the court. On the top itself. my lord.
Yes, this is marked in the civil suit.
Yes, D1A,
D1A,
Additional Civil Judge and Junior Division,
Yes.
JMFC,
Yes.
Belgaum.
And
The
this
exhibit
document was
D1.
also marked as exhibit D1 in the land, before the land tribunal proceedings.
But D1A is a translated copy.
Translated.
D1 is the Santa.
my lord, my learned friend is making submission that this document was marked in evidence.
No, that,
My lord, he has not participated in the
no,
inquiry
no, no,
itself.
it's not mine, sir. The landlord who had.
I'll, my lord, let my learned friend complete.
This
This
was in-
document one, because it is a translation. Unless both of you agree that the translation is proper and you are admitting the documents to be the same.
Lord, the tribunal says there are absolutely no documents to verify the surrender of the land itself.
Tribunal has ignored this document, my lord.
ಅದು ಆಮೇಲೆ ಅಪ್ರಿಸಿಯೇಷನ್ ಆಮೇಲೆ ಬರೋಣ.
Yes.
This page 635 and 137. Do you agree that 137 is the translated copy of 635?
Yes.
Then we'll appreciate.
Yes.
This is, then there is a diary mutation entry on 637, my lord. Wherein, based on the application of this 637 only, that is in Marathi. There, the word one says, Kulacha now kami. There is what is that? This is said, this is based on the application of Taunu Basappa Padmanavaram to delete his name and enter the name of the owner Madhukar Omanna Muchandi. There is a worthy, that is application on 15/11/55 and 1/1/56. This entry has been made, my lord, in respect of 79/2 and 85/2. Thereafter, my lord, at page 631 of the very same tribunal.
31.
631, 631. There is a record of rights, RTC extract pertaining to 79/2, measuring 5 acre 4 gunta. The name of the original owner is existing in owner's column as well as the cultivator's column from 1964-65 to 1967-68.
Chandi Madhukar.
Madhukar Omanna.
But in a Potdar Madan.
Kudda in the sense that cultivator's column alone, his name only is there and he is self-cultivating.
Yes.
And from 68-69 to 1974-75, the subsequent purchaser, that is Madhukar Bindura Poddar, his name is entered pursuant to the purchase.
Yes.
And similar to, and that purchase has been reflected in page 639, the 639, no? Wherein this, after the surrender in 55, the original owner sold this land to Poddar, with ME number 921. There, Madhukar Ramanna Muchandi, by receiving an amount of ₹1,000, executed a registered sale deed on 30/9/1965 in favor of Madan Bindura Poddar. This is dated 1905-67, my lord. And from 1968-69 to 74-75, his name is appearing. And further, my lord, at page 641 to 650.
65.
Yes, ma'am.
Entry came to be effected in
1905-67. 367.
66-67 ವರೆಗೂ ಮುಚ್ಚಂಡಿ ಮಧುಕರ ಇದೆ.
Yes, ma'am. ಆಮೇಲೆ 68-69 ಇಂದ 74-75 ತನಕ this Madan Bindura Poddar.
What is this Sadar? 67-68, what is the entry?
67-68, my lord. Till 67-68, there is a change of name from Muchandi to Poddar. Pursuant to
66-67 Muchandi.
yes, ma'am.
68-69 Poddar.
Poddar. 69 till 74-75.
67-68 ಏನಾದ್ರು?
67-68.
What is that? 67-68 ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? Page 631.
130, 145.
The 145 is again Matte. There is a change of 145 is prior to that, wherein the original name of Padman.
RTC at page 631 copy ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ?
631.
And this is in Marathi, so what is that
Yes, sir.
word?
They used to use both Marathi and Kannada, both languages at that time.
No, Marathi नहीं.
I would explain a lot. That there also the name of the
Because in 67-68 there's some Sadur something is
no,
written.
no,
I don't
ಅಲ್ಲಿ
know what
change
that is.
ಅದು ಒಂದು ವರ್ಡ್ ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ because there is a worthy by the that's the application by the tenant himself to delete his name and enter the name of the owner. That is what in a short form they say.
That Sadur continues from 69-70 to 74-75.
That is ಖುದ್ ಅಂದ್ರೆ ಸ್ವತಃ ಕಲ್ಟಿವೇಶನ್ ಮಾಡ್ತಾನೆ. In the cultivators column, my lord.
66 to 66, 67, the full name is given as Muchandi Madhukar Oman.
Yes.
67, 68, ಅದೇನೋ ಸದೂರ್ ಅಂತ ಆಗುತ್ತೆ. 68, 69, Poddar, ಒಂದೇ year.
Maybe both are.
ಆಮೇಲೆ 69, 70 ಇಂದ ಸದೂರ್ ಅಂತ ಬರುತ್ತೆ. So there is only 1 year entry of Poddar.
No, from 68, 69 to 74, 75, Poddar ಅಂತಾನೆ ತೋರಿಸ್ತು.
ಇಲ್ಲ. That is why we are asking what the
Madhukar Bindura Poddar ಅಂತ ಆಮೇಲೆ ಅದನ್ನ.
What's yours?
And there, my lord, one more.
Both the survey numbers, it is something else.
Sadar andre, that is do. Sadar. Alla, ನಿಜವಲ್ಲ ಅದೇ. Same, this is my friend.
Ditto ಅನ್ನ.
Ditto.
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 Sadar ಅಂದ್ರೆ
Sadar
ditto.
ಅಂತ ಇದೆ ಅದು. Sorry.
It took by somebody else's name.
And at subsequently, my lord, at page 641 to 652,
Yes, sir.
641 to 652, the tax paid receipts by Madan Bindura Poddar. And at page 673, my lord.
70?
673, it's an evidence of Devendra Tavanappa Padmannavar, who is the respondent number. Respondent number. Where during the cross examination, he denied the surrender at page 674. Devendra Tavanappa Padmannavar was a applicant number 1B, my lord. And here he admits the sale of land by Muchandi to Poddar. ಇರಬಹುದು ಅಂತ ಒಂದು ವರ್ಡ್.
ಅಂದ್ರೆ ಮೇಲ್ಕಂಡ ತಹಸೀಲ್ದಾರ್ ಕಡೆಯಿಂದ ಆದೇಶವಾಗಿತ್ತು.
Wherein a suggestion was made that this land was sold by Muchandi to Poddar. He said ಇರಬಹುದು ಅಂತ ಒಂದು he admits there. At page 674. And subsequently at page 679, my lord, there is a evidence of the Omanna Madhukar Muchandi, who was acting as a GPA holder of the landlords. That was dated 6/4/1994. And he, during his evidence, my lord, this document which is marked at Exhibit D1, document at page 635 is
Madhukar Omanna.
Madhukar Omanna's son
Is
as a GPA holder of Poddar. Yes, GPA holder of Poddar. They were related, my lord, because the son of the original owner, as a GPA holder, he deposed as a DW1 on behalf of the landlord on 6/4/94 before the tribunal. And there, during that time, he produced this surrender of application, which is marked at, which is shown at 635, and it is marked as Exhibit D1. And even in the objections before the tribunal at page 611, there's a clear assertion by the landlord And now, if you lordship kindly see it, look at even in the tribunal's order at page number 709, my lord, which is dated 1694. Tribunal, 1694, my lord.
Typed copy idea.
Typed copy.
That order is set aside.
No, that's set aside, but I want to, that in that order, this has been considered, which has been ignored by in the subsequent order.
Is there a typed copy of this available? Relevant portion ಯಾವುದು?
Relevant portion, Lord. Just stand. This is at second page, my lord. Second page, there they say, ಎದುರುಗಾರ, second paragraph. ಎದುರುಗಾರ ಪರ PA ಹೋಲ್ಡರ್ ಶ್ರೀ ಓಮಣ್ಣರಾವ್ ಮಧುಕರ್ ಮುಚ್ಚಂಡಿ ಇವರು ತಮ್ಮ ಹೇಳಿಕೆ ನೀಡಿ ಅದರಲ್ಲಿ ದಾವೆ ಜಮೀನುಗಳ ಮಾಹಿತಿ ನನಗೆ ಇದೆ. ಸದರಿ ಜಮೀನುಗಳು ಶ್ರೀ ಮದನ್ ಬಿಂದುರಾವ್ ಪೋದ್ದಾರ್ ಇವರ ಕಬ್ಜೆಯಲ್ಲಿ ಇರುತ್ತದೆ. ಸದರಿ ಜಮೀನುಗಳನ್ನು 39/65ರಂದು ಮಧುಕರ್ ಬಿಂದುರಾವ್ ಪೋದ್ದಾರ್ ಇವರ ಕಬ್ಜೆಯಲ್ಲಿ ಇರುತ್ತವೆ. ಸದರಿ ಜಮೀನುಗಳನ್ನು 39/65ರಂದು ಮಧುಕರ್ ಓಮಣ್ಣ ಮುಚ್ಚಂಡಿ ಇವರಿಂದ ಖರೀದಿ ತೆಗೆದುಕೊಂಡಿರ್ತಾರೆ. ಅಲ್ಲ, ಅದು ಟೈಪ್ಡ್ ಕಾಪಿ ನೆಕ್ಸ್ಟ್ ಇದೆ. ಸಾರಿ ಮಿಲಾಡ್, the tribunal's order 715, Milord. Sorry. 715 clear copies. The handwritten, I think. 715, sorry. Kindly see at internal page number 2, Milord. This. At 716 actually. Yes, ma'am. ಎದುರುಗಾರರ ಪರ PA ಹೋಲ್ಡರ್ ಶ್ರೀ ಓಮಣ್ಣರಾವ್ ಮಧುಕರ್ ಮುಚ್ಚಂಡಿ ಅವರು ತಮ್ಮ ಹೇಳಿಕೆ ನೀಡಿ ಅದರಲ್ಲಿ ದಾವೆ ಜಮೀನುಗಳ ಮಾಹಿತಿ ನನಗಿದೆ. ಸದರಿ ಜಮೀನುಗಳು ಶ್ರೀ ಮದನ್ ಬಿಂದುರಾವ್ ಪೋದ್ದಾರ್ ಇವರ ಕಬ್ಜೆಯಲ್ಲಿ ಇರುತ್ತವೆ. ಸದರಿ ಜಮೀನುಗಳನ್ನು 39/65ರಂದು ಮಧುಕರ್ ಬಿಂದುರಾವ್ ಪೋದ್ದಾರ್ ಇವರ ಕಬ್ಜೆಯಲ್ಲಿ ಇರುತ್ತದೆ. ಸದರಿ ಜಮೀನುಗಳನ್ನು 39/65ರಂದು ಮಧುಕರ್ ಓಮಣ್ಣ ಮುಚ್ಚಂಡಿ ಇವರಿಂದ ಖರೀದಿ ತೆಗೆದುಕೊಂಡಿರ್ತಾರೆ. ಖರೀದಿ ಕೊಡುವುದಕ್ಕಿಂತ ಮೊದಲು ಎದುರುದಾರರು ರೈತರು ಅಂತ ಯಾರಿಗೂ ನೇಮಕಾತಿ ಮಾಡಿಲ್ಲ ಅಥವಾ ಹಚ್ಚಿರುವುದಿಲ್ಲ. ತಾವೇ ಸ್ವತಃ ಸಾಗುವಳಿ ಮಾಡಿರ್ತಾರೆ. ತವನಪ್ಪ ಪದ್ಮನ್ನವರು ಇವರು 50 ವರ್ಷಗಳಿಂದ ರೈತ ನಾತೆಯಿಂದ ಮಾಡುತ್ತಾರೆ ಅನ್ನೋದು ಸುಳ್ಳು. ಅರ್ಜಿದಾರರು ಗ್ರಾಮ ಲೆಕ್ಕಿಗರಿಗೆ ಕೊಟ್ಟಿ ವರದಿ ಕೊಟ್ಟು ರೈತರು ಅಂತ ತಮ್ಮ ಹೆಸರನ್ನು ದಾಖಲು ಮಾಡಿಕೊಂಡಿದ್ದು, ನಂತರ 4 ಜನ ಪಂಚರು ಕೂಡಿ ತಿಳಿ ಹೇಳಿ ಅವರ ಕಡೆಯಿಂದ ತಮ್ಮ ಹಕ್ಕನ್ನು ಬಿಟ್ಟು ಕೊಟ್ಟು ತಾವು ರೈತರು ಅಲ್ಲ ಅಂತ ದಿನಾಂಕ 15/10/55ನೇ ದಿವಸ ತಮ್ಮ ಹೆಸರು ಕಡಿಮೆ ಮಾಡಲು ಅರ್ಜಿ ಕೊಟ್ಟರು. ಆ ಪ್ರಕಾರ 1/1/56ರಂದು ಇಸ್ವಿಗೆ ತಹಶೀಲ್ದಾರರು ಮಿಟೇಷನ್ ಪಾಸ್ ಮಾಡಿ ರೈತರ ಹೆಸರು ತೆಗೆದು ಆ ಜಾಗೆಯಲ್ಲಿ ಮಾಲಕರಾದ ಮಧುಕರ್ ಓಮಣ್ಣ ಮುಚ್ಚಂಡಿ ಇವರ ಹೆಸರು ನಮೂದಿಸಲಾಗಿದೆ. ಸುಮಾರು 50 ವರ್ಷಗಳಿಂದ ಮದನ್ ಬಿಂದುರಾವ್ ಪೋದ್ದಾರ್ ಇವರು ತಮ್ಮ ಜಮೀನಿನಲ್ಲಿ ತಾವೇ ವ್ಯವಸಾಯ ಮಾಡ್ತಾರೆ. ಈ ದಾವೆದಲ್ಲಿ ತವನಪ್ಪ ಮದ್ವನ್ನವರು ತಮ್ಮ ಹೆಸರು ಕಡಿಮೆ ಮಾಡಲು ಕೊಟ್ಟ ಅರ್ಜಿ ನಕಲು ಹಾಜರು ಮಾಡಿದ್ದೇನೆ. ಡೈರಿ ಉತ್ತಾರ ಮತ್ತು ಮದನ್ ಬಿಂದುರಾವ್ ಪೋದ್ದಾರ್ ಇವರ ಹೆಸರು ಖರೀದಿ ಪ್ರಕಾರ ದಾಖಲಾದ ಬಗ್ಗೆ ಡೈರಿ ಉತ್ತಾರ ಇನ್ನಿತರ ದಾಖಲೆ ಹಾಜರುಪಡಿಸಿ ಮತ್ತು 4-5 ಜನರ ಅಫಿಡವಿಟ್ ಸಲ್ಲಿಸಿ ಅದರಲ್ಲಿ ದಾವೆ ಜಮೀನುಗಳನ್ನು ಮಾಲೀಕರೇ ಸ್ವತಃ ಸಾಗು ಮಾಡುತ್ತಾರೆ ಅಂತ ನಮೂದಿಸಿದ ದಾಖಲೆ ಹಾಜರುಪಡಿಸಿ ಅರ್ಜಿದಾರರು ತಾವೇ ಜಮೀನುಗಳ ರೈತರು ಅನ್ನುವುದು ಸುಳ್ಳು ಅಂತ ತಿಳಿಸಿದರು. ಉಭಯ ಪಕ್ಷಗಾರಗಳ ನ್ಯಾಯವಾದಿಗಳು ತಮ್ಮ ಲಿಖಿತ ವಾದವನ್ನು ಹಾಜರುಪಡಿಸಿದರು. ಅದರಲ್ಲಿ ಅವರು ತಮ್ಮ ಪಕ್ಷಗಾರರ ಹೇಳಿಕೆಗಳನ್ನು ಪುನರುಚ್ಚರಿಸಿರುತ್ತಾರೆ. ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು, ಸಾಕ್ಷ್ಯಾಧಾರಗಳನ್ನು ಅವಲೋಕಿಸಿ ನೋಡಿತು, ಪಹಣಿ ಪತ್ರಿಕೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಅರ್ಜಿದಾರರ ಹೆಸರು 1/3/74ರಿಂದಾಗಲಿ ಮತ್ತು ಅದಕ್ಕೂ ಪೂರ್ವದಲ್ಲಿ ಸಾಗುವಳಿದಾರರ ಕಾಲಂನಲ್ಲಿ ದಾಖಲೆ ಇದ್ದದ್ದು ಕಂಡು ಬರುವುದಿಲ್ಲ. ಅರ್ಜಿದಾರರ ಹೆಸರು ಡೈರಿ ನಂಬರ್ 567ರ ಮೇರೆಗೆ ಸಂರಕ್ಷಿತ ಕುಳ ಅಂತ ದಾಖಲಾಗಿದ್ದು, ಅರ್ಜಿದಾರರೇ 15/10/55ರಂದು ತಮ್ಮ ಹೆಸರು ಕಡಿಮೆ ಮಾಡಲು ವರದಿ ಕೊಟ್ಟಿದ್ದು, ಅದು ಡೈರಿ ನಂಬರ್ 707ಕ್ಕೆ ಅದೇ. ಎದುರುದಾರರು ದಾವೇದ ಜಮೀನುಗಳು ತಮ್ಮ ಸ್ವಂತ ಸಾಗುವಳಿಯಲ್ಲಿವೆ ಅಂತ ತೋರಿಸಲಿಕ್ಕೆ ಆಜುಬಾಜು ಜನರ ಹೇಳಿಕೆಗಳನ್ನು ಸಹ ಕೊಡಿಸಿರೋರು. ಅರ್ಜಿದಾರರು ಸಹ ತಮ್ಮ ಹೇಳಿಕೆಗೆ ಪೂರಕವಾಗಿ 2 ಜನರ ಸಾಕ್ಷಿಗಳನ್ನು ಹಾಜರುಪಡಿಸಿದರು. ಅರ್ಜಿದಾರರ ಪರ ನ್ಯಾಯವಾದಿಗಳು ತಮ್ಮ ಲಿಖಿತವಾದದಲ್ಲಿ ಸದರಿ ಜಾವೇದ ಜಮೀನುಗಳನ್ನು ನಿಯಮಾನುಸಾರವಾಗಿ ತಹಶೀಲ್ದಾರರ ಮುಂದೆ ರಾಜೀನಾಮೆ ಪ್ರಕರಣ ಮಾಡಿ ಕಬ್ಜಾ ಪಡೆದದ್ದು ಇರುವುದಿಲ್ಲ. ಎದುರುಗಾರರ ಪರ ನೀಡಿದ ಸಾಕ್ಷಿದಾರರಿಬ್ಬರು ಶ್ರೀ ಪೋದ್ದಾರ್ ಇವರ ಸೇವಕರು ಇರುವುದಾಗಿ ತಿಳಿಸಿ ಅವರು ತಮ್ಮ ಮಾಲೀಕರ ಪರವಾಗಿ ಹೇಳಿಕೆ ನೀಡಿದ್ದ ಅದೇ ಅಲ್ಲದೆ ಅವರ ಜಮೀನುಗಳಿಗೆ ದಾವೇದ ಜಮೀನುಗಳು ಹೊಂದಿದ ಇರುವ ಬಗ್ಗೆ ಪಹಣಿ ಪತ್ರಿಕೆ ಉತ್ತರ ಹಾಜರುಪಡಿಸಿಲ್ಲ. ಅಲ್ಲದೆ ಎದುರುಗಾರರು ದಾವೇದ ಜಮೀನುಗಳ ಚಕಬಂದಿ ಸಹ ತಿಳಿಸಲು ಅಸಮರ್ಥರಾಗಿರುವುದು. ಅಂತ ಎತ್ತಿ ತೋರಿಸಿರುವರು. ಅಲ್ಲದೆ ಅರ್ಜಿದಾರರೇ ದಾವೇದ ಜಮೀನುಗಳ ಕಬ್ಜೆಯಲ್ಲಿರುವುದೆಂದು ಅಧಿಭೋಗದ ಹಕ್ಕು ನೀಡಲು ವಿನಂತಿಸಿರುವುದು. ಎದುರುದಾರರ ನ್ಯಾಯವಾದಿಗಳು ತಮ್ಮ ಲಿಖಿತವಾದಲ್ಲಿ ಡೈರಿ ನಂಬರ್ 707 ಪ್ರಕಾರ ಅರ್ಜಿದಾರರ ಹೆಸರು ರೈತ ಹಕ್ಕಿನಿಂದ ಕಡಿಮೆ ಮಾಡಿದ್ದರೂ ಸಹಿತ ಯಾವುದೇ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಆಹ್ವಾನಾರ್ಹ ಚಾಲೆಂಜ್ ಮಾಡಿರುವುದಿಲ್ಲ. ಸದರಿ ಜಮೀನುಗಳು ತಮ್ಮ ಸ್ವಂತ ಸಾಗುವಳಿ ಇರುವ ಬಗ್ಗೆ ಪಣಿಪತ್ರಿಕೆ 1956ರಿಂದ 94ರವರೆಗೆ ಸರ್ಕಾರಿ ಪಾಳಿ ತುಂಬಿದ ಬಗ್ಗೆ ಪಾವತಿ ಹಾಜರುಪಡಿಸಿದ್ದು ಇದೆ. ಅರ್ಜಿದಾರರು ತಮ್ಮ ಪರವಾಗಿ ಮಾಡಿಸಿದ ಸಾಕ್ಷಿದಾರರು ಜಾವೇದ ಜಮೀನಿನ ಆಜು ಬಾಜುದಾರರು ಇರುವುದಿಲ್ಲ. ಅವರಿಗೆ ತಂಟೆದ ಜಮೀನುಗಳ ಬಗ್ಗೆ ಏನು ಜ್ಞಾನ ಇರುವುದಿಲ್ಲ. ಆದುದರಿಂದ ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿದ ಫಾರ್ಮ್ ನಂಬರ್ 7 ಕೊಟ್ಟಿದ್ದು ಅದನ್ನು ತಿರಸ್ಕರಿಸಲು ವಿನಂತಿಸರು. ಅರ್ಜಿದಾರರ ಹೆಸರು 1/3/74ರಂದು ಮತ್ತು ಅದಕ್ಕೂ ಪೂರ್ವದಲ್ಲಿ 2 ವರ್ಷ ರೈತರು ಇದ್ದ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಗಳಿರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ಅವರು ಸದರಿ ಜಮೀನಿನಲ್ಲಿ ರೈತರು ಅಂತ ಸಿದ್ಧಪಡಿಸಲು ವಿಫಲರಾಗಿರುವುದರಿಂದ ಅಧಿಭೋಗದಾರರಂತ ನಿರ್ಣಯಿಸಲು ಬರಲಾಗದು ಅಂತ ಅಧ್ಯಕ್ಷರು ಅಭಿಪ್ರಾಯ ಪಡುವರು. ಆದರೆ ಹಾಜರಿದ್ದ ಇನ್ನುಳಿದ 3 ಸದಸ್ಯರು ಅರ್ಜಿದಾರರ ಅಧಿಭೋಗದಾರರಂತ ನಿರ್ಣಯಿಸಲು ಅರ್ಹರು ಅಂತ ತಿಳಿಸಿ ಅದರಂತೆ ದಾವೇದ ಜಮೀನಿಗೆ ಅಧಿಭೋಗದಾರರಂತ ನಿರ್ಣಯಿಸಲು ತಿಳಿಸರು. ಆದರೆ ಈ ಬಗ್ಗೆ ಯಾವುದೇ ಸ್ಪಷ್ಟೀಕರಣ ನೀಡಿರುವುದಿಲ್ಲ. ಈ ಮೇಲೆ ಕಾಣಿಸಿದ ವಿವರಣೆಗಳಿಂದ ಅರ್ಜಿದಾರರ 3-1 ಬಹುಮತದ ಮೇಲೆ ಅಧಿಭೋಗದಾರರ ಅಂತ ನಿರ್ಣಯಿಸಲು ಮತ್ತು ಈ ಕೆಳಗಂಡೆ ಆದೇಶಿಸಲಾಯಿತು. ದಾವೇದ ಜಮೀನುಗಳಿಗೆ ಬಹುಮತದ ಅಧಿಭೋಗದಾರರನ್ನು ನಿರ್ಣಯಿಸಲಾಯಿತು. Here, my lord, the president of the tribunal clearly holds that the applicants have failed to prove, and he perused the surrender documents also, the order passed by Tehsildar also. There only the other 3 members have dissented, so they decided to grant the occupancy rights. This was challenged before this honorable court, my lord. This honorable court observed that there was no appreciation of evidence and remitted back the matter. And what the impugned order says, my lord, I'll like to show. The entire order sheet I have gone through. The order sheet of the land tribunal, it starts at page 22, my lord, initially. First and starting ಅಲ್ಲಿ ಇದೆ.
Yes.
There on 13/10/2022, the evidence is filed. I'd like to draw my lord's attention at page 22. There they say ಪ್ರಕರಣವನ್ನು ಕೂಗಿತು, ಅರ್ಜಿದಾರರು ಹಾಜರು, ವಕೀಲರು ದಾಖಲೆ ಗುರುತಿಸಿದರು, ಮುಖ್ಯ ವಿಚಾರಣೆ ಪತ್ರ ನೀಡಿದರು. 1950-51 ಗ್ರಾಮ ನಂಬರ್ ಅದನ್ನು ಎಕ್ಸಿಬಿಟ್ P1 ಅಂತ ಗುರುತಿಸಿ ಇತರ ದಾಖಲೆಯನ್ನು ಎಕ್ಸಿಬಿಟ್ P2 ಇಂದ P11 ಅಂತ ಗುರುತಿಸಿದೆ. ಅರ್ಜಿದಾರರ ಸಾಕ್ಷಿ ನಂಬರ್ 2, ಸಾಕ್ಷಿ ನಂಬರ್ 3 ಇವರ ಮುಖ್ಯ ವಿಚಾರಣೆ ಹಾಜರುಪಡಿಸಿದರು. ಎದುರುದಾರರ ವಕೀಲರು ಹಾಜರು ಕ್ರಾಸ್ ಇಲ್ಲ ಅಂತ ತಿಳಿಸಿದರು. A2 ಗೈರು ವಿಚಾರಣೆ ದಿನಾಂಕ 20-10-22 ಮುಂದೂಡಿಕೆ. So 20-10-22 ಮುಂದೂಡಿಕೆ. They directly posted on that day, my lord, 20-10-22. ಪ್ರಕರಣ ಕೂಗಿತು, ಅರ್ಜಿದಾರರ ವಕೀಲರು ಹಾಜರ್, ಅರ್ಜಿದಾರರ ಸಾಕ್ಷಿ ಮುಗಿದಿದೆ, ಎದುರುದಾರರ ಪಾಟಿ ಸವಾಲು ಇಲ್ಲ ಅಂತ ತಿಳಿಸಿದ್ದರಿಂದ ಪಾಟಿ ಸವಾಲು ಇಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಪರಿಗಣಿಸಿ ಅರ್ಜಿದಾರರ ವಕೀಲರ ಆದೇಶಕ್ಕೆ ಇರಿಸಲು ಕೇಳಿದರು. ಪ್ರಯುಕ್ತ ಆದೇಶಕ್ಕೆ ಇರಿಸಲಾಯಿತು. ಡೈರೆಕ್ಟ್ಲಿ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ಆರ್ಡರ್ಸ್. Here they say the applicant says that there is no cross of by this one, and the other side evidence need not be taken and posted for orders. So he posted for orders. Subsequently, my lord, on 27, this matter was posted for on the orders on 27/10/2022. ಪ್ರಕರಣ ಕೂಗಿದೆ, ಉಭಯತರು ಗೈರು ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿದ ಅಧಿಭೋಗದಾರಕ್ಕೆ ಹಕ್ಕಿನ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ. ದಿನಾಂಕ 1/6/94 ಆದೇಶವನ್ನು ಸ್ಥಿರೀಕರಿಸಿ ಸರ್ವಾನುಮತದ ಆದೇಶವನ್ನು ಘೋಷಿಸಿತು. Now kindly come to the impugned order. It starts at page 31. The relevant portion is in fact.
The suit in OS number 679.
There was a suit filed by the original the tenants, my lord. declaring that they are the tenants. When then that suit came to be dismissed, stating that it's the land tribunal which has to be decided this issue. Now, I would like to draw my lord's attention at page 37.
Yes.
37 of impugned order. Writ petition, annexure A. Starts from page 31.
Yes.
Here, my lord, one submission is that nowhere the tribunal takes into consideration the earlier evidence and the documents marked by the tribunal itself during the year 1994.
Now exhibit P1 to P2 to P11 have been marked.
Yes, my lord.
What are those documents are not shown?
P1 is, my lord, exhibit P1,
Form 7. P1 is Form 7.
Ramanaksha number 7 ಅಂತ ತೋರಿಸುತ್ತೆ. Kindly see the document, my lord. That has been actually produced it.
Form number 7 or no, exhibit
Form
P1.
number, actually it's not a form number 7, namuna number 1. It is produced at page 145 of my writ petition. Same document.
145.
145, annexure J.
Exhibit P1.
Yes, ma'am. There also, the name of the applicant is shown from 1950-51. This is actually the record of rights extract pertaining to 79/2, measuring 5 acre 4 gunta. It is called as Namuna number 7 at that relevant point of time. And here, from 1950-51 till 1954-55, next page, Milo. The name of the applicant is shown. Subsequently, now 1955-56, the name of the landlord, Madhukar Romana.
After the surrender.
Yes, ma'am. There again they clearly mention kud in the sense self-cultivation.
Yes.
The translated copy is produced.
Yes.
And here, my lord, exhibit P1 clearly suggests that there is a surrender and this one. And exhibit P2, my lord, there also, this is pertaining to RTC, that exhibit P2 from land terminal records, which is at page 87. P1 is at 83. Page 87, my lord. This pertains to another land survey number 85/2, measuring 6 acre 22 gunta. There also in cultivators column from 1950-51 to 54-55, they show the name of Padmanavar. At page 88, from 1955-56 to 63-64, Madhukar Romana Muchandi.
Yes.
And exhibit P3, my lord, at page 91, is again RTC pertaining to 79/2. This is from 1955-56 to 63-64. Their name of the owner, landlord,
Starts from 55.
Madhukar Romana Muchandi. There also it is showed Khud 92, that is self-cultivation. In exhibit P4 at page 93, my lord. 79/2, 5 acre 4 gunta. 64-65 to 67-68, Madhukar Romana Muchandi. 68-69 to 74-75 is Madan Bindurao Poddar.
Yes.
Then another document at page 95 only. From 75-76 thereafter, they both in owners and cultivators column. And further documents I would not be relying because that's pertaining to 88-89 and
Yes.
other related documents. So now kindly see the impugned order. starts at page 31. The typed copy is at page 40. Now, the relevant portion, the observation starts from page 37, my lord. In this entire order, the evidence of the landlord has never been considered, my lord. And these documents have never been ascertained and never been examined. And at page 37 at the bottom, my lord, ದಾವೆಯ ಜಮೀನುಗಳ ಕುರಿತಂತೆ ದಿನಾಂಕ 1/1/56ರಂದು ಮಂಜೂರಾದ ಹಕ್ಕು ದಾಖಲೆ ನಂಬರ್ 707 ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿ ಜಮೀನುಗಳ ಆರ್ಟಿಸಿಯಲ್ಲಿ ರೈತ ಅಂತ ಇದ್ದಂತ ಅರ್ಜಿದಾರರು ತವನಪ್ಪ ಬಸಪ್ಪ ಪದ್ಮನ್ನವರ್ ಇವರ ಹೆಸರನ್ನು ಕಡಿಮೆ ಮಾಡಿ ಮಧುಕರ ಒಮ್ಮನ ಮುಚ್ಚಂಡಿ ಇವರ ಹೆಸರನ್ನು ದಾಖಲಿಸಲು ಸಲ್ಲಿಸಿದ ವರದಿ ಅರ್ಜಿಯ ಮೇಲಿಂದ ಅವರ ಹೆಸರನ್ನು ಕಡಿಮೆ ಮಾಡಿದ್ದು ಕಂಡು ಬರುತ್ತದೆ. ಆದರೆ ಭೂ ಸುಧಾರಣೆ ಕಾಯ್ದೆ 1961-74 ಕಲಂ 25 ಅನ್ವಯ ಅರ್ಜಿದಾರರು ಗೇಣಿ ಹಕ್ಕನ್ನು ಬಿಟ್ಟುಕೊಟ್ಟ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಗಳು ಇರುವುದಿಲ್ಲ. Here they apply Karnataka Land Reforms Act. ಅರ್ಜಿದಾರರ ಪರವಾಗಿ ಹಾಜರುಪಡಿಸಿದ ದಾಖಲೆಗಳು ಹಾಗೂ ಅವರ ಪರ ನೀಡಿದ ಸಾಕ್ಷ್ಯಗಳನ್ನು ಗಮನಿಸಲಾಗಿ ಅರ್ಜಿದಾರರು ದಿನಾಂಕ 1/3/74ರಂದು ಮತ್ತು ಅದಕ್ಕೂ ಮುಂಚೆಯಿಂದಲೇ ದಾವೆದ ಜಮೀನುಗಳನ್ನು ಗೇಣಿನಾತೆಯಿಂದ ಸಾಗುವಳಿ ಮಾಡಿದ್ದು ಸ್ಪಷ್ಟವಾಗಿ ಕಂಡು ಬರುತ್ತದೆ. ಅದರಂತೆ ಎದುರುದಾರರು ಸಹ ಅರ್ಜಿದಾರರ ದಾವೆ ಜಮೀನುಗಳನ್ನು ಗೇಣಿನಾತೆಯಿಂದ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವುದನ್ನು ಅಲ್ಲಗೆಳೆದಿಲ್ಲ. ಈ ಎಲ್ಲಾ ವಿವರಗಳನ್ನು ಪರಿಗಣಿಸಿ ಅರ್ಜಿದಾರರು ದಾವೆ ಜಮೀನುಗಳನ್ನು ರೈತ ನಾತೆಯಿಂದ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವುದು ಸ್ಪಷ್ಟವಾಗಿ ಕಂಡು ಬರುತ್ತಿರುವುದರಿಂದ ಸದರಿ ಜಮೀನುಗಳಿಗೆ ಎಲ್ಲ ಅರ್ಜಿದಾರರನ್ನು ಸಾಮೂಹಿಕವಾಗಿ ಮತ್ತು ಜಂಟಿಯಾಗಿ ಅಧಿಭೋಗದಾರರನ್ನು ನೋಂದಾಯಿಸಲು ಭೂ ನ್ಯಾಯ ಮಂಡಳಿಯ ಆದೇಶ ದಿನಾಂಕ 1/6/94 ಸ್ಥಿರೀಕರಿಸಿ ಭೂ ನ್ಯಾಯ ಮಂಡಳಿಯ ಎಲ್ಲ ಸದಸ್ಯರು ಸರ್ವಾನುಮತದಿಂದ ತೀರ್ಮಾನಿಸಿ ಈ ಕೆಳಗಿನಂತೆ ಆದೇಶಿಸಲಾಯಿತು. ಮೇಲ್ ಪ್ರಸ್ತಾವನೆ ವಿವರಿಸಿದ
reasoning of this one para.
Yes, ma'am. Yes. There they say earlier order is dated 1694 is ಸ್ಥಿರೀಕರಿಸಿದೆ. The complete ignorance of the records, my lord. The applicant themselves have produced the documents which clearly shows that there is a clear surrender of the tenants, even if they are treated as tenants. And that has never been challenged even under the erstwhile Bombay Tenancy and Agriculture Lands Act. So my respectful submission, my first contention is that there did not exist any tenancy at all, my lord. And having lost the same in the year 1956, the applicant could not have filed an application seeking for the grant of occupancy rights. So my respectful submission is that in this regard, my lord, I have placed some judgments.
We'll come back and take it.
Please.
Serial number 76, my lords. It's covered by decision.
Serial number 28, my lords, passport matter. Kindly 2 days accommodation may be given, my lords.
28
Please, my lords.
at the request of counsel for the petitioner, relist on
Monday, my lords. I kindly be taken on Monday.
10th.
Obliged, my lord.
Serial number 40, my lord.
Ah,
The appeal for respondent.
yes.
I pray for a 10 days time to place some records to the documents.
So inform the petitioner, Mr.
So he himself wanted time.
40 at the request of counsel for respondent number 2,
20th.
relist on
20th.
20th.
Not interim order to be.
Interim order earlier granted is extended.
My lordship, serial number 97. in First list. It is simple mandamus, my lordship. Already this honorable court passed the order directed the
Mentioning Niranjan, what do you want to say?
any date
mandamus simple matter ಅಂತ ಅದೇ ತಗೊಂಡ್ಬಿಟ್ಟು ಬಾಕಿ ಎಲ್ಲ ಬೇಡ ಅಂತ.
ಅಲ್ಲ ಅದು ತಗೊಳ್ದಲ್ಲ ಎನಿ ಡೇಟ್ ಇನ್ ದಿ ಆರ್ಡರ್ಸ್ ಲಿಸ್ಟ್, my lordship.
ಎಲ್ಲರೂ ಅದೇ ಹೇಳ್ತಾರೆ. 230 Bangalore.
ಸರ್ ನಾಲ್ಕೂರಿಗ್ರಿ ಮೇಡಮ್ 1:00ಗೆ ಒಂದ್ಸಲ ಚಾನ್ಸ್ ತಗೊಂಡ್ ನೋಡ್ರಿ ಅಂದಿದ್ರು. ಇದು ಒಂದ ಮ್ಯಾಟ್ರ್
32.
Cell number 32, Dharwad bench matter. 32, Shrant F. Gowda.
Citations. Yes, Mr. Gowda, citations.
There are two set of citations, one dated by memo dated 24/10/24.
24?
10/24.
ಅದಿಲ್ಲಲ್ಲಪ್ಪ ಇದು
24th.
ಅಲ್ಲೇನಾದ್ರು ಇದೆಯಾ? For production of documents, citations ಯಾವ್ದು ಇಲ್ವಲ್ಲ?
ಅದರಲ್ಲಿದೆ ಮೆಮೊ ಫಾರ್ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಪ್ರೊಡಕ್ಷನ್. ಸಾರಿ ಮೈ colleagues ಸ್ವಲ್ಪ. This starts from page number 90.
Yes.
First judgment is here, the surrender of tenancy was upheld in the Abundant of Exor. What are the conditions for being valid and binding surrender? Here, the page 92. At the relevant point of time, para 3, they have held out that thing, and at para 12, my lord, at page 94, the effect of surrender of tenancy, surrender of tenancy was considered by this court in Vallabhbhai Nathbhai versus Bhaijivi and Ramchandra Keshav Adke versus Govind Jyoti Javre. In the latter case, it was inter-alia held that tenancy of such surrender comes to an end. The rights arising out of that relationship terminate. A surrender by tenancy can be only valid and binding on him if it was in writing and was verified by Mamlatdar, whose duty is to ascertain whether surrender was voluntary and was not under any pressure or undue influence of the landlord. In the instance case, the documentary evidence clearly established the fact that the surrender was voluntary and without pressure or undue influence. As noted above, the Tahsildar has endorsed in his findings on the document itself. It is necessary to refer to section 7 and 41 of the Act, which provide for the restoration of the possession under certain circumstances. The procedure for recovery of such possession is also prescribed. Undisputedly, no such application was, however, filed by respondent number 2. Additionally, no action was taken by respondent number 2 for grant of tenancy rights from 1955 till 1971. Same is the case in this case also, my lord. And the next judgment, my lord, wherein the page 95, there was a remedy provided under the tenant. What is the remedy provided for such tenants who really want to dispute that? That is at para 3 and 4 at page 97. Again, they have reiterated they subsequently inserted section 15, my lord. I would not be in place of 5.3 and para 7. They say what is the procedure prescribed at para 19. Under section 29, they can still apply for the restoration. So I would not be going into that because that is the remedy provided for the tenants in such cases. Because here the surrender was in the year 1955.
Yes.
And the next judgment, my lord, that is also Maharashtra Bombay High Court judgment at page 103. There again they discussed the surrender of tenancy and delivery of possession by the tenant to be landlord. After the valid surrender of tenancy of right, the land cannot be sold to be held by the tenant. In case of valid surrender, question of obtaining possession by landlord under 36(2) does not arise. So when there is a valid surrender of tenancy, the question of seeking grant of occupancy does not arise. There at page 109 at para 13, my lord, the term surrender as per advanced law lexicon is defined. And lastly, they observed that it would be travesty of justice if the real meaning of the word surrender is not given. When Datturam during his lifetime never disputed the surrender deed, accepting the story of legal representatives about the alleged wide character of the surrender would be nothing but making a section 20 of the Act nugatory. Subsequently, my lord, again, and the surrender of the land prior to 1974 at page 111. Here, my lord, there was they were dealing with the summary eviction. Then the High Court was justified in allowing the tenant's writ petition and passing the eviction order. The one-page order under section 29. Not to show that what was the remedy available to such tenants who dispute the surrender of tenancy, my lord. Thereafter, my lord, page 113, this honorable court has clearly held, my lord, when there is a surrender of land by the tenant prior to 1/7/1974.
Page?
But page 113. This is
where are you reading?
113, my lord.
113 is the head note. As well, judgment starts at 114.
Starts at 113. Justice Swami Siddhamma and another
ಅದು
versus.
head note ಅದು ಅಷ್ಟೇ. ನೋಟ್ ಇದೆ 113.
ಹೆಡ್ ನೋಟ್ ಇದೆ ಅದರಲ್ಲಿ ಜಸ್ಟ್
ತರ ಇಲ್ಲಿ.
ಸಾರಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 9 and 10.
9 and 10. Yes.
It is clear from the aforesaid page 119. This was under section 25 of the Karnataka Land Reforms Act. It is clear from the aforesaid extracts of the order of the tribunal that the surrender was accepted by tribunal as bona fide and landlord was permitted to enter upon the land as per provisions of section 25. As it then stood, section 25 of the Act stood at the relevant point of time as follows. The same provision is there. From what has been stated earlier, it is clear that in the instant case, the surrender had taken place in accordance with the provisions of section 25 of that. Now it is to be seen as to what is the effect of such an order of surrender on the tenancy right of the third respondent. The tenancy is a matter of privity of parties. Subject to the law governing the same, it can be put an end to either by a flux of time agreed under the contract.
You
or,
read that?
Yes.
Next.
There I would not bring in. And the next is at page 125. Uppegowda, Justice Bhima, no.
Para?
This is para 8. Wherein tribunal has ignored. The owner's case was rejected by the tribunal on the ground that surrender alleged by the landowner was not before the competent authority in writing and such surrender was not duly accepted. The tribunal has committed an error of law in giving such a finding which is contrary to the provisions of the proviso to subsection 2 of section 5 of the Mysore Tenancy Act. And further it held that assuming that tenancy was created in the at para 10, my lord. Assuming that tenancy was created in the year 1950, continued after 29th January 1955, it could be terminated by consent as per the proviso quoted above, before the expiry of period of 5 years by surrendering tenants' interest in favor of landowner. The case of the landowner is that after the expiry of period of lease, he has been cultivating the land in question. He has deposed to the effect that in the course of his statement, the tenant has merely asserted that he has been cultivating even after the expiry of lease period in 1950. But the stand taken by him is neither supported by oral
10
or
and 11.
Same again here. So the last is that the division bench judgment of this one, Rayappa Basappa Kallar. There also, if the applicant is not in possession of the land from 1957, filing of such application for registering as a tenant at para 5, para 2, it starts from para 2 at page 131.
Para 2 and 5.
Fine. Yes. And lastly, this Puttegowda was again taken to division bench. And para 7, not here. At page 133 it starts. Para 7, where it is held that where it was not proved that tenant had delivered so and so. The question of lands held by, what is this one? Here the tenancy, the tax receipts In the present case, my lord.
This is not of any help to you.
No, no, no. Here only for the purpose of showing that what is the land held by. Because here they have even they say today, my lord, what has happened is even after the surrender of tenancy by our father, we continue to be in possession. They did not show any document to prove that this one, my lord, or prior to 1/3/1974.
This
now-
doesn't further your case anyway, you have cited. Yes.
And then one more I would like to, my lord, on 3 to.
And this Meenakshi Adir is what is being cited in that.
Yes, my lord. And in 3 to 25 memo, again same one, only three judgments I have quoted.
The Meenakshi Adir ಇನ್ನೊಂದಿದೆಲ್ಲ
Yes, Meenakshi ಆಮೇಲೆ ಇದು.
ಅದರಲ್ಲಿ ಯಾವ ಪ್ಯಾರ?
The tenants at sufferance. Maneksha others in Iran.
(13 and 14).
Yes. And in three more judgments by my memo dated 3 to 25.
Yes.
Starts from page 82. In fact, I would like to. This has already been quoted. I'm sorry, Manoj. 85.
ರಾಯಪ್ಪ ಆಗಿದೆ.
Yes.
77 Karnataka 497 85.
This I already have quoted. And page 85, Manoj.
Para?
Page 85 here. Here, my lord, para 5, sorry. The procedure to be adopted by the tribunal immediately after the receipt of the application.
Yes, para
Rule
5.
19, what it provides. That one. And one more thing, my lord. Sorry, my lord, on memo dated 31/1/2020.
ಇನ್ನೊಂದಿದೆಪ್ಪ ಹನುಮಂತ ಗೌಡ ಪಾಟೀಲ್.
Hanumant Gaudu Patil. Here also, my lord, the statement of the this one was father was recorded, and thereafter at para 8, at page 91, in view of this statement made by these persons before land term, it is difficult to accept the contention that counsel that petitioner now that the petitioner was also the tenant along with his father of this land. It is very clear that the case of the petitioner that he was also tenant of the land is developed by the petitioner as an afterthought. The proceeding before the land tribunal discloses that the father has surrendered the land. There is no material produced by the petitioner to lead to the inference that there was any fraud practiced on his father by for surrendering the land. This theory of fraud also appears to be very improbable in view of the fact that not only the petitioner's father but the petitioner himself was examined before the land tribunal, and in his statement before the land tribunal he has not stated that any fraud was practiced by respondent number 3 on his father for surrendering the land. Therefore, it will have to be held that the petitioner's father was the only tenant of the land surrendered his tenancy rights, and that surrender was accepted by the tribunal. The other contention that is raised by the counsel for the petitioner is that no possession has been delivered by the father of the petitioner in pursuance of the surrender, and therefore the petitioner continues to be in the tenant of the land. The learned municip who has been the presiding officer over the tribunal has passed a detailed judgment, the copy of which is produced in this case. Therein it is recorded as follows. Therefore, he wants to surrender the suit land of the opponent being aware of the tenancy rights in the suit, and he has affixed so and so. Referring to the evidence of the respondent.
Read that. Anything else?
Nothing. And only one last. On 31, last, what has happened is on 31/1/25, I have filed one more document wherein the very same.
31/1/25.
There is one more memo. 31/1/25.
Very memo.
These are the, sorry, my lord, I'm mixing. These are the deeds of consent executed by the respondents claiming themselves to be the tenants in favor of the subsequent purchasers. the first document that is I have described that here one, the father of the respondent number 3 to 7, sorry, for the respondent number 16, in this case, my lord, on 8/10/2013, has executed a registered consent deed when they conveyed all their right, title and interest. They say that what has happened, my lord, in this case, Madan Bindura Poddar had executed a power of attorney. In the year 2001, my lord, on 30/12/2002, the said power of attorney sold the land in my favor, both the lands. Subsequently, my lord, on 13/7/2011, the original landowner sold the lands in favor of respondent number 8 and 3. My lord. One respondent number 3 being the one Mr. Firdos Darga.
No, this is in 2013.
What?
2013.
2013, same date, 2013. Now there is a dispute, there is a suit going on between the two parties who claim to be the purchasers of the land, my lord.
Hmm.
Now these tenants, so these people who claims to be the tenants have already transferred their rights in favor of one of the purchasers.
What right? Surrendered right.
And the copy of the civil court judgment on 42/269.
Hmm. Yes, Ashtana.
Yes, man.
Yes, Mr. Bangi.
Present petitioner is a purchaser of land in 2002. He is not the owner
Yes.
nor the tenant.
Hmm.
Lord, I'll just refer to Milord from the surnames which are in dispute. Milord, Muchendi was the original owner of the property. Milord, he executed sale deed in favor of one Poddar.
Hmm.
Poddar, Milord, is the owner of the land. Milord, the tenant is Padmannavar.
Hmm.
Milord, the present petitioners claim that they have purchased the property from Poddar's GPA holder on 31/12/2002.
Hmm.
And Milord, in fact, it is on record that Milord GP had been cancelled on 29/12/2002, 2 days prior to Milord the execution of the sale deed. Milord, main thrust, Milord, with this background, that Milord, the writ petitioner has come into picture only after.
Appearing for whom?
Milord, I pay for the tenants Padmannavar.
For R9 to
Milord, there is
11.
no dispute with regard, Milord, there is no quarrel between the landlords and the tenants.
Hmm.
It is the person, my lord, who has come before my lords in the present writ petition. He is a purchaser from the Poddar's GPA holder who happened to be the son of original owner.
One submission with my friend's permission, my lord. This honorable court had permitted me to get myself implicated before the tribunal.
Who is respondent number 12?
Well, is Adarsh Shaman Momin, he is the purchaser, my lord.
Arshad Ahmed, Mohammed Sharif Momin.
Momin, he is also a purchaser of the land, one of the land, in the year 2011.
Hmm.
On 31/12/2002, my lord, I have purchased the property through the general power of attorney. And these
2A, 2B are the owners.
Yes.
Yes.
3 to 7 are the purchasers. 8 is the earlier owner.
Yes.
8, my lord, is the GPA holder.
GPA holder.
9 to
11,
9 to
13 to 18 are the tenants. 13 to 21.
20, my lord. 21
Tenants.
is 20.
20, na? 21 arrow.
21 is my uncle, my lord. Is one of the respondents, the former respondent.
Yes. So you appear for the tenants 9 to 11 and 13 to 20.
Yes.
Yes. Yeah, my lord, he has purchased the property in 2002 when the real tenancy dispute was pending before the land tribunal.
ಒಂದೇ ನಿಮಿಷ. I had
20 ಮತ್ತೆ ಇಲ್ಲಿ ಅಪಿಯರೆನ್ಸ್ ಎಲ್ಲ ಸ್ವಲ್ಪ ಕಷ್ಟ ಆಗಿದೆ. R20 ಜಯಂತ್ ಸರ್ವ್ಡ್ ಅಂತಿದೆ, R21. Yes.
I had filed 2 suits before the trial court challenging the sale deeds executed by them in the year 2011. That is pending. During that pendency of them, then the tenants filed their impleading application. That was rejected. And they approached this honorable court, there the honorable court.
You would not be deciding
No, no,
your inter se rights.
I'm not, I'm just.
Only surrender, if we surrender, we accept.
I'll demonstrate.
Then rest of it goes in terms of, if surrender is not accepted, it goes further on the suits on that basis. Only the surrender aspect we are concerned.
And ignorance of the documents by the tribunal.
Only the aspect of surrender. All other disputes inter se between you, who is the purchaser, who paid, who did not pay, who could he purchase from, who could not sell, all that is in those suits.
Lord, I'll just, my lord, there was suit pending. Impleading applications were filed. Matter came up before this honorable court. This honorable court, my lord, considering the status of the parties, my lord, directed the writ petitioner, my lord, to get himself impleaded before the land tribunal. Before the land tribunal, my lord, he made an application to implead. He did not contest the proceedings. My lord, the entire, my lord, proceedings went in his absence. My lord, he has not led any evidence. Now, my lord, coming to the question of surrender. My lord, these document which my learned friend produces at page number 137.
Exhibit D1A.
Yes, my lord.
Yes.
My lord, it is addressed to village accountant. Then, my lord, it is dated 15/10/1955, bottom of the page, my lord. Then, on the back side, the seal of the Tahsildar is appearing. Then, my lord, this endorsement, I'll just read this, my lord. This is important. ದಿನಾಂಕ 9/11/55 ಮೋಜೆ ಮಜದೂರಿನ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಸ್ಥಾನಿಕ ಚೌಕಡಿ ವಿಚಾರಣೆ ತನಿಖೆ ಮಾಡುವ ನಂತರ ಸದರಿ ಜಮೀನು ಸೋ ಅವರು ಸಾಗು ಮಾಡದೇ ಇದ್ದು ಅವರು ಪದ್ಮಣ್ಣವರ ಸದರ ಜಮೀನನ್ನು ಸಾಗುವಳಿ ಮಾಡಿಲ್ಲ, ಮಧುಕರ್ ಓಮಣ್ಣ ಮುಚ್ಚಂಡಿ ಇವರು ಸದರಿ ಜಮೀನನ್ನು ಸಾಗುವಳಿ ಮಾಡಿ ಅಂತ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಸದರಿ ಜಮೀನು ಹುಲ್ಲಿನಿಂದ ಕೂಡಿದ್ದು, ಅದರಿಂದ ಮುಂದಿನ ಕ್ರಮಕ್ಕೆ ವ್ಯವಸ್ಥೆಗೆ ಕಾಗದ ಪತ್ರಗಳ ಪ್ರಕಾರ ಆಗಬೇಕೆಂದು ಅಂತ ಟಿಪ್ಪಣಿ ಸಲ್ಲಿಸಲಾಗಿದೆ. My lord, this is signed by, inquired by the village accountant. Then it is countersigned by Tahsildar.
Yes.
My lord, may I request, my lord, the provisions of the act may kindly be seen, my lord, in reference of this, whether there is a valid surrender of the as per proceedings. My lord, the concept of surrender, my lord, first came into picture in the year 1939. My lord, under the provisions of Bombay Tenancy Act. May I pass on this?
Yes.
Lord, Lord, section may I request section 4 may kindly.
Section
4.
Yes.
My lord, section 4 defines, my lord, protected tenant. Then, my lord, section 7, subsection 5. Section 7.
Yes.
Lord, I'll not, my lord, read the entire provision because, my lord, it deals with landlord's right to determine protected tenancy. 5 is the relevant provision, my lord.
Yes.
Subsection 5. If at any time the tenant makes an application under section 13 to the Mamlatdar and satisfies him that the landlord has failed to comply within a reasonable time with the provisions of subsection 2 or 2A, as the case may be, the tenant shall be entitled to direction of the Mamlatdar to obtain immediate possession of the land and to such compensation as may be awarded by the Mamlatdar for the loss caused to the tenant by the eviction and failure on the part of the landlord to restore give possession of the land to him as required under section 2A, as the case may be.
This is on termination of tenancy and offer of first
Yes.
right of refusal.
The requirement is that, my lord, he was required to make an application to the Mamlatdar, then he has to hold an inquiry.
This is
Then, my
after
lord,
possession is taken over.
Pardon?
After possession is taken over.
Yes.
By the tenant.
my lord, in that, my lord, the procedure that was contemplated was he must make an application to the Mamlatdar. The moment application is made to the Mamlatdar, then he would inquire, satisfy himself, pass an order. Then, my lord, it is only a valid surrender of tenancy.
This is not surrender. Subsection 5 of section 7 is once the.
Then I'm just reading this provision to demonstrate, my lord, how possession is taken in, my lord.
This is a completely different thing, Mr.
My lord,
This is a situation where the landlord terminates the tenancy, takes over possession, and the tenant complains that the possession has been wrongfully taken. He makes a complaint to Mamlatdar, who makes an inquiry and restores the possession to the tenant. It is not by the landlord. And during the interregnum, if any loss is caused due to crops, etc., that compensation will be paid by landlord to the tenant.
Yes.
This
Lord,
provision is not attracted in
Lord, this aspect, how, my lord, I am just trying, my lord, to demonstrate that, my lord, if an application is to be made by the tenant himself, what is the procedure? And if the application is to be
this is for recovery of possession, not for surrender.
My lord, the satisfaction of the Mamlatdar, my lord, is what I am trying to, my lord, come up with.
Different things require different satisfaction.
Yes. Then, my lord, I will directly take my lords to, my lord, the section, the provisions of 1948 Act.
Hmm. Yes.
With the name. My lord, 5 is what, my lord, my learned friend has read. No tenancy to be less than 10 years. No tenancy of any land shall be for a period of less than 10 years. Notwithstanding any agreement, usage, or law as contrary, no tenancy shall be terminated before the expiry of period of 10 years, except on the ground mentioned in section 14. Provided that any tenancy may be terminated by tenant before the expiry of period of 10 years by surrendering the interest as a tenant in favor of the landlord. Then, my lord, section 29, my lord.
Yes.
Lord, how possession is to be taken. A tenant or agricultural laborer or artisan entitled to possession of land or dwelling house under any of the provisions of this act may apply in writing to for such possession to the Mamlatdar. The application shall be made in such form as may be prescribed. No landlord shall take possession of any land or dwelling house held by a tenant except under an order of the Mamlatdar. For obtaining such order, he shall make an application in the prescribed form. On receipt of the application under subsection 1 or 2, the Mamlatdar shall, after holding an inquiry, pass such order thereon as he deems fit. Any person taking possession of the land or a dwelling house, except in accordance with the provisions of subsection 1, as the case may be, he shall liable forfeiture of the crops, if any, grown in the land, in addition to the payment of the cost as may be directed by Mamlatdar or by the collector, and also the penalty prescribed under section 81. But first, an application to be made to the Mamlatdar, either by the tenant or, my lord, if is required, it is for the landlord. For any purpose. I don't know, my lord, once it is surrendered, So the satisfy, what I'm trying to, stress upon is that, once a Mamlatar receives an application, he has to satisfy himself that, there is a valid surrender of tenancy. Then only, landlord come into possession of the property. Section 5B has been interpreted by the Honorable Supreme Court, considered by the Honorable Supreme Court. Okay. Para 7 onwards, here also, there was the, read from para 7, The common question that fall for consideration in these appeals is whether the circumstances of this case, the alleged surrender by the tenant was valid. There was complete, surrender of the tenancy. There were documents. Mamlatar, had passed the order. The deputy collector and the tribunal have concurrently answered this question in the negative on the threefold grounds. That so-called surrender was sham, and the transaction between the tenant continued thereafter to be in possession and paid the rent to the landlord of 1959. The circle officers were not competent to dispose of the tenancy cases. As such, so-and-so order dated September 18, 1953 was without jurisdiction, that the surrender had not been verified as required by law. The High Court upheld the findings on the ground: 1, the same being a finding of fact as shown to be erroneous. It did not think it necessary to go into the second ground. Regarding the third ground, it held that the alleged surrender was nullity, as there was no compliance with the mandatory requirement of Section 5(3) of Bombay Tenancy Act 1953, read with Rule 2A in regard to the verification of surrender. Section 5B, it is extracted. Para 11, the manner of such verification has been prescribed by Rule 2A in these terms. The Mamlatar, when verifying surrender of the tenancy by the tenant in favor of the landlord under clause B of subsection 3 of section 5, shall satisfy himself after such making inquiry as he thinks fit, that the tenant understands the nature and consequences of surrender, and also that it is voluntary, and shall endorse his findings in his behalf upon the document of surrender. It will be seen from the combined reading of these provisions that the surrender of tenancy by tenant, in order to be valid and effective, must fulfill the requirement. These requirements: it shall be in writing, it must be verified before the Mamlatar. While making such verification, the Mamlatar must satisfy himself in regard to the two things, namely that a tenant understands the nature of and consequences of surrender, and it was voluntary. The Mamlatar must endorse his findings as to such satisfaction upon the document of surrender. Shri So-and-so learned counsel for the appellants contended that the provisions of Rule 2A are directory and not mandatory, that in any case there has been a substantial compliance with the requirements of relevant provisions of the Act and the rules. It is submitted that the deed of surrender executed by tenants was presented along with the application of the landlord to Mamlatar, that the circle office, exercising powers of Aval Karkun, then made an inquiry and recorded a statement of the tenant and the landlord to ascertain whether the surrender had been intelligently and voluntarily made by the tenant, and it was only after verification of the required facts that the officer made order directing the delivery of possession to the landlord and deletion of the tenant's name from the record of right. It is argued that the mere fact that the circle officer's office or endorsement was strictly not in the prescribed would not invalidate a surrender. In this connection, the learned counsel drew our attention to the sentence in the judgment of the tribunal. But there is no doubt that the above formalities were gone through before the circle offices. Thus, the first point to be considered is whether the requirements of these provisions is mandatory or directory. No universal rule, as Lord Campbell can be laid down as whether mandatory enactments shall be considered directory only or obligatory with with an implied nullification for disobedience. It is duty of the courts of justice to try to get the real intention of the legislature by carefully attending to the whole scope. Such intention of the legislature is therefore to be ascertained upon the review of the language, subject matter, and importance of the provision in relation to the general subject intended to be secured. The mischief, if any, is to be prevented, and the remedy is to be promoted by the Act. Prior to enactment of Bombay Tenancy Act, the laws governing the relations between the landlords and tenants in the state did not ensure equal status of contract or agreements to the contracting party, inasmuch as the tenants were in such an inferior position. The tenant had no security of tenure nor any protection against the eviction or renting. Bombay Act 1939 was the first measure intended to remedy these evils and to improve the condition of the tenants of agricultural lands in province. The Bombay Act 1948 required an advance in the matter of enumerating the lots of rights. It marks a big step taken post-independence era by the state legislature towards the implementation of the policy of the agrarian reform. Chapter 2 of Act deals with tenancies in general. Section 5 and 15 were in this chapter. Chapter 3 makes a provision for special rights and privileges of tenants and the alleged matters. Provisions of these chapters confer upon protected tenants the rights to purchase their holdings from their landlords, to prevent the uneconomic cultivation and to encourage pleasant proprietorship. The provisions for surrender of tenancy after first appeared in a barred form without any safeguards in proviso to section 2 of 5.2 of the Act of 1958. Proviso ran thus, para 18. It is unguarded form that the provision was inadequate and vulnerable. It was susceptible to abuse. Under these clauses, scheming the landlords and the squeeze out the tenants or introduce any of the questionable means to leave the protected umbrella of the Act. Bombay Amendment Act 1952, which came into force on January 12, 1953, recast this provision and hedged round the surrender with the effective safeguards. It stipulated subsection 3(2) as reproduced by us earlier in this judgment for the old proviso to section 5. The language of section 5(3)(b) and rule 2A is absolute, explicit, and preemptory. The words provided that read that the words shall be repeatedly used in section 5(3)(b) make the termination of tenancy by surrender entirely subject to the imperative conditions laid down in the proviso. This proviso throws a benevolent ring of protection against the tenants. It is designed to protect the tenants on two fronts against the two types of dangers: one against the susceptible coercion, undue influence, or trickery proceedings from the landlords, and the other against the tenants' own ignorance, improvidence, attitude, and helpless self-help resignation stemming from its weaker section and the tenant-landlord relationship. Thus, the imperative language, the benevolent purpose, and the importance of these provisions for efficacious implementation of the general scheme of the Act all unreally led to the conclusion that they are all intended to be mandatory. Neglect of any such statutory requisites would be fatal. Disobedience of even one of these mandatory would render the surrender invalid and ineffectual. Having seen that the requirements of section 5(3)(b) and rule 2 are obligatory and not directory, it seems to be considered whether these imperatives have been substantially complied with the manner prescribed, and if not, what is the consequence of non-compliance. The question of inherent jurisdiction aspect, all the circle officers did in this case was he recorded a statement of the tenant and landlord and made the order, which he had reproduced in full earlier in this judgment. Although in this order he rendered the tenant's statement that he does not want to cultivate the same any longer and he is surrendering the possession willingly along with the crops and also the right pro tenant. He did protected tenant. He did not say a word that he is satisfied that the tenant had voluntarily made the surrender after understanding its nature and consequences. Much less, he did not endorse his satisfaction on the tenant's deed of surrender as required under Rule 2A. Verification of the surrender implies that the authority was satisfied as to the statutory requisites after due inquiry. Such satisfaction of the authority was the essence of the whole thing. In the other words, the requirement as to the recording of satisfaction by the authority in the manner prescribed by the rule was the substance of the matter and not the empty formality. In the absence of requisite endorsement, therefore, it cannot be said that there has been a substantial compliance of the statutory requirement. Sri so-and-so contended that the tribunal had found that the circle office has complied with the formalities prescribed by law. Does not appear to be correct. The sentence from which it is sought to be spelled out should not be torn from its context. Earlier in his judgment, the tribunal had clearly said that the concurrence of the deputy collector that the surrender did not even verified as required by law. Next point to be considered is whether the consequence of non-surrender, non-compliance with the mandatory procedure. A century ago, Taylor and Taylor, Master Roll Jessel, adopted the rule that where the power is given to ascertain the thing of a certain way, the thing must be done in that way and the method. The rule has stood the test of time applied for the Privy Council in Nazir Ahmed so and so, and later by this court in several cases of so and so. Then Miller line. The rule will be attracted in full force in the present case because non-verification of the surrender in the requisite manner would frustrate the very purpose of this provision. Intention of the legislature is to prohibit the verification of the surrender in the manner other than one prescribed is implied in these provisions. Failure to comply with these mandatory provisions therefore had vitiated the surrender and rendered the non-est for the purpose of section 5(3)(b). Millard, now the next question is, Millard, even if after Millard complying all the requirements, if the application had not been made with Millard Mamletar, Millard someone else conducted the inquiry, Millard, even if the satisfaction is recorded and recorded by the circle office, not by the Mamletar, then the consequences is, Millard, the Honorable Supreme Court has restored back the possession to the landlord, tenant after 50 years. Millard, next judgment. One-page judgment. Lord, even this judgment which I read, Lord, in this judgment, the contention, para 2, Lord, the contention raised by the appellants before the tribunal that the tenant had surrendered the lands in accordance with law on so and so, and that he was not in possession of the lands in question appointed day was repelled by the tribunal. This very contention has been reiterated before us on behalf of the appellants in this appeal. We agree with the reasoning and the conclusion of the tribunal that a surrender could have been made lawfully only under section 15, read with section 29(2) of the Bombay 1948 Act as it stood at the material time. There was no such order passed by the competent authority under the BTL Act evidencing the surrender in accordance with the provisions of the Act. Under the circumstances, submission urged by the appellants that the tenant had surrendered his tenancy in favor of the appellants on so and so, it cannot be exceeded to the or sustained. Such being the position, the appellants cannot succeed in this appeal, therefore fails and dismissed with no order. The interim order granted by the court earlier stood vacated. Revenue authorities under the BTL Act are directed to ensure that the respondents are put in possession of the lands in question as early as possible and in any case before the expire of 6 months from today.
Yes.
So, Millard, the document which my learned friend is trying to place reliance is the document of surrender. Does not mean, Millard, meet the requirement of the
What does it not meet? What is the violation of?
Millard, one is it is not made to the Mamletar. It is made to the one village accountant. Second, Millard, it is the verification done by the revenue authorities under the Mamletar are not competent under section 5(3). Assuming, Millard, my case is to Millard reply to his argument that there is valid surrender. Millard, my contention is there is no surrender at all. Millard, to reply to that, Millard, the application is not made to the Mamletar. Second, Millard, Mamletar has not visited the spot. He has not conducted any inquiry. Nor, Millard, he has recorded in satisfaction that this surrender has taken place without there being any force or ill. Millard, undue influence, what are contemplated under section 5(b). 52C. So, my lord, in the absence of meeting all these requirements, my lord, the contention of the petitioner that there was a valid surrender of the tenancy prior to 56 itself. My lord, 50, I am placing that because after 56, my lord, law is amended, there is no question of surrender. My lord, my lord, the date on which is mentioned is 55. So, since my lord, the document does not speak of surrender as required under section 5(3). So it is not valid surrender. The next question, my lord, is whether if surrender had not taken place or, my lord, taken place. If the surrender had taken place. My lord, the Honorable Supreme Court says, even if it has taken place, then if it is not done in requirements as per law, then, my lord, it has to be reverted back. Then, my lord, in all competency for the tenant, my lord, if the requirements of section 5(3) is not met, the tenant is entitled to make an application under section, my lord, form 7 for the, my lord, tenancy rights. So, my lord, considering all these aspects, my lord, the tribunal has.
You could have made under 29 for restoration. No application in 29 has been made for restoration.
My lord, that was a situation where, my lord, there was a valid surrender. My case is, my lord, we are not surrendered at all. The landlord also says, my lord, that is recorded in the course of the order of the tribunal, that landlord is saying that there is no surrender at all. So by my lord, the mutation entries will not confer any right, nor take away the right of the tenant to be my lord, a protected. He was a protected tenant. My lord, he was not, my lord, tenant. He was a protected and recognized in the 1939 Act. My lord, if a protected tenants, my lord, are to be expelled, my lord, the detailed inquiry is to be contemplated.
The sale has happened in favor of the Poddar family in 1965.
65.
And their name has come in and they
Yes.
have paid the taxes.
Yes.
You did not do anything. The landowner who has sold it has no interest post the sale.
My lord, the question of tenancy still remains. My lord, mutating the name of the landlord, deleting the name of the tenant would not take away the right of a tenant to continue in possession.
What have you shown to show that you are in possession?
My lord,
That is what the Supreme Court says. So you'll have to show that.
my lord, my lord, on the contrary, my lord, to answer to this, my lord, is the contrary question is to be, my lord, answered by the person who says that the surrender had taken place. My lord, my
Rebuttable issue.
My lord,
Now,
yes.
what have you shown
Poddar,
that
my lord, I'm sorry.
This alleged surrender did not take place and you continue to be in possession?
My lord, Poddar has admitted in evidence that even after purchase of the property, the tenants continue to be in possession of it.
Where is that?
My lord, my learned friend, my lord, referred to that, my lord, in page 674, my lord.
Padmannavar. Not a Poddar. Sorry.
674, my lord, Padmannavar denies, my lord, surrender of any land.
Poddar is never.
Where is the positive statement made by either Muchandi or Poddar? This is your statement.
Yeah, my lord, I have, my lord.
It's your statement remains as your statement.
My lord,
what is the document produced to show that you have paid the tax, you continue to be in possession?
Lord, my statement in form 7 stating that I am continued. Lord,
the two judgments that you have relied upon are not contemporaneous with the 1974 Act. They were contemporaneous with the 1956 Act.
Yes.
And that is why the court came to a conclusion that it was contemporary 1 year. It cannot be believed.
Yes.
Here is a situation where the surrender happened in 56. Form 7 was filed in 74. Nobody knew that in 1956, 74 Form 7 can be filed.
Yes.
And 65 there is a sale.
Yes.
Taxes have been paid by the Poddars.
Because
there is no document which you have produced.
My answer to my question is, since the protected tenants' rights could not have been terminated without
due... been terminated.
Since
there is a world of difference between termination and surrender.
Yes. Surrender, it is all, the question whether the tenant goes out of the premises is the question.
That won't be as, it's not as.
Milord,
simple
yes,
as that.
Milord, I'm getting what is
It's
there in my
different
mind.
connotation.
Yes, Milord, the point,
What have you shown that you continue to be in possession?
Milord, I can only say from the records, the statements that we continue to be in possession of the property right from, Milord, the days on 1939 Act.
No documents.
Milord, apart from that, is, Milord, oral statements, Milord, this is, and admission of the Podar.
Where is that admission?
I'll just point out from the records.
From what was read
Milord,
out,
I'll
there is no
just,
admission.
the reasoning of the tribunal, reasoning of the tribunal.
Reasoning of the tribunal we are questioning.
Milord, in that,
Now the question is, where is the final commission of Poddar or Muchandi?
I'll just, Milord,
That is never deposed. That is never deposed.
Poddar is never deposed.
No, his GPA holder, that's Madhukar.
Even the GPA holder on behalf of the Poddar.
Yes, see page 679.
may I request page 45 of the writ petition papers, Milord.
Hmm. Yes.
Milord, the typed impugned order,
Hmm.
last para. ಮುಂದುವರಿದು, my lord saw that para.
Yes.
ಮುಂದುವರಿದು ಸದರಿ ಜಮೀನ RTCಯಲ್ಲಿ ದಿನಾಂಕ 1/3/74ರಿಂದ ಇದಕ್ಕೂ ಪೂರ್ವದಲ್ಲಿ ಅದರ ಕುಟುಂಬದ ಹೆಸರು ನಮೂದಿರುತ್ತದೆ. ಅದರಂತೆ ಹಕ್ಕು ರಿಜಿಸ್ಟರ್ ಸಂರಕ್ಷಿತ ಕುಳ, ವರ್ಡ್ ಇಸ್ ಮಿಸ್ಸಿಂಗ್, ಸಂರಕ್ಷಿತ ಕುಳ ಅಂತ RTCಯಲ್ಲಿ ಇರುತ್ತದೆ. ತದನಂತರ ಅರ್ಜಿದಾರರಿಗೆ ಯಾವುದೇ ಮಾಹಿತಿ ಬೆನ್ನು ಹಿಂದೆ ಹಕ್ಕು ದಾಖಲೆ ಕ್ರಮಾಂಕ 707 ಅರ್ಜಿದಾರ ಹೆಸರುಗಳನ್ನು RTC ಇಂದ ಕಡಿಮೆ ಮಾಡಿದ್ದಿರುತ್ತದೆ. ಆದರೆ ಜಮೀನುಗಳು ಈವರೆಗೆ ಅರ್ಜಿದಾರರ ಕಬ್ಜೆಯಲ್ಲಿ ಇರುತ್ತವೆ. ಈ ಎಲ್ಲ ವಿಷಯಗಳನ್ನು ಎದುರುದಾರ ಒಂದು ಶ್ರೀ ಸೋಯನ್ಸೋ ಅವರು ಒಪ್ಪಿಕೊಳ್ಳುತ್ತಾರೆ. ಅದು ಅಲ್ಲದೆ ಅರ್ಜಿದಾರರು ರೈತನಾತೆಯಿಂದ ಸಾಗುವಳಿ ಮಾಡುವುದನ್ನು ಸಹ ಒಪ್ಪಿಕೊಳ್ಳುತ್ತಾರೆ.
ಈ ಎಲ್ಲ ವಿಷಯಗಳನ್ನು ಎದುರುದಾರ ಶ್ರೀ ಮದನ್ ಇವರು ಎಲ್ಲಿ ಅವರು they did not lead evidence. Madan Bindurao Poddar did not lead evidence.
Milord, they have come before the court. Milord, tribunal, they have come before the tribunal.
ಒಪ್ಪಿಕೊಂಡಿರ್ತಾರೆ ಅಂದ್ರೆ ಎಲ್ಲಿ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಅದೇ ತೋರಿಸಿ ಅಂತ ಹೇಳ್ತಾರೆ ನಿಮ್ಗೆ.
I'll just point out from the record.
Show us that.
Yes.
We'll leave it for now. You
Yes.
complete your argument. That only
Milord,
one thing.
that is the only crux of the issue. The second part is, Milord, since the petitioner has purchased the property when the Milord, whether it was, Milord, the tenancy would be conferred with the occupancy rights or not. Milord, whether, Milord, the writ petition could have purchased the property from a person who had no authority of law.
That the suit will decide.
Milord, I'm, Milord, placing, Milord, the petitioner on the caveat on the ground that, Milord, he has purchased the property in 2002 when tenancy dispute was pending. Whether he has purchased from the rightful owner is not, Milord, is second part. Secondly, Milord, may I request, Milord, the order of this honorable court.
Mr. Bangi, if we are to hold that your surrender is proper, then your entire defense everywhere will go.
Yes.
Only if your surrender is proper, then their defense will go in those suits.
Yes.
But those suits will have to be decided in
Milord,
those suits.
there is
not
all,
here.
Milord, in one suit, there is an order that he would be bound by the orders of the tribunal.
Obviously, both of you are bound by it. But that binding is only as regards surrender.
Yes.
Whether it was purchased properly, whether they had rights or not, that
And
cannot be
just,
gone
Milord,
into in
a
this.
locus of the petitioner, Milord.
So only surrender we are dealing with.
Yes.
So for that particular, this ಒಪ್ಪಿಕೊಂಡಿದ್ದಾರೆ ಅಂತ
Yes.
ಒಪ್ಪಿಕೊಂಡಿರ್ತಾರೆ ಎಲ್ಲಿ ಒಪ್ಪಿಕೊಂಡಿರ್ತಾರೆ ಅಂತ
I'll just, Milord, point out from the record.
Rest of your argument.
Just one last submission, Milord. This honorable court, Milord, directed, Milord, the petitioner to make an application for impleading in the present proceedings. I'll read, Milord.
Date of the order?
Yes, 2000.
Page number.
7th March 2019, Milord.
Page number.
Page 125 of the writ papers.
ಯಾವ್ದು?
ಇದ್ರಲ್ಲ.
Writ petition.
Earlier to, Milord.
Page?
125.
Annexure F.
Annexure F.
7/3/2019.
I'll read from para 11, Milord.
Yes.
This arises, Milord, from the suit. In the peculiar facts and circumstances narrated above, these writ petitions succeed in part. The impugned common order so and so passed by so and so on I number so and so. The impleading application is by allowed permitting the petitioner to get impleaded as defendants so and so, and the respondents plaintiff are permitted to get themselves, my lord, the respondent plaintiffs 1 to 5 are permitted to get themselves impleaded before the land tribunal in the proceeding pending application form for the grant of occupancy rights in respect of the very suit land. All the parties together submit that the direction may be issued to the land tribunal to adjudicate long pending claim for occupancy post haste the orders. My lord, after this order, my lord, before the tribunal, the present writ petitioners may not file an impleading application. That is on record. After that, they did not participate, nor my lord, they led any evidence, nor my lord, they brought anything on record. My lord, though my lord, they were permitted to my lord, get themselves impleaded, my lord, having not participated before the land tribunal, my lord, they could not have filed the present writ petition.
That was your first argument.
Yes.
That we
My lord, it is coupled with the purchase of the land.
That is a technical.
Yes.
That argument, technical, we don't get into, you know that.
There are only two things I wanted to just.
Indian
Only because this 5(3)(b) came into force on 12/1/1953, page 39 of my memo. And this was again amended. That has been replaced on 29/3/1956.
Surrender has been taken away.
Yes, so that. And what my learned friend regarding Adke judgment Supreme Court, there the application was by the landlord. Here the application is by the tenant himself.
Yes.
There is no absolute involvement of this one is there. And in Exhibit D1, my lord, there is an endorsement by the Mamlatdar to forward this application to the village accountant. In that endorsement is there, because in Kannadadalli, corner is there.
Yes.
And after that endorsement,
Left side, bottom. Ali.
Yes, ma'am. That there, then for the inquiry, the verification, then they pass an order.
You have to show us.
Yes.
Heard Shri Prashant Gowda, learned counsel for the petitioner, Shri Mrutyunjay Tata Bangi, learned counsel for respond number 9 to 11 and 13 to.
Yes.
Registry is directed to correct the noting in the cause list as regards respond number 20, Jayant served, to read as respond number 21, Jayant served. None appears for respond number 3 to 7 and 12. Yes, madam, what do you say?
Please, my lord.
In there, 2A and B.
Please, my lord, we are sisters, we are sealing with the respondent.
Ms. Deepa P. Dodatti, learned counsel for respond number 2A and B, supports the argument, adopts the argument of Sri Mrutyunjay Tata Bangi. Heard, reserved.
I'll flag it and give. Great.
At the end of the day, you point it out.
Yes.
If we have any question, we can ask.
Yes, yes.
Yes. Let me know also.
Preliminary hearing 230. 112.
230 matter, 112.
I beg to appear for the respondent number 4 in this matter.
Yes.
Your lordships had heard this matter, I'm told, a couple of weeks ago, and then passed a detailed order on 31st January, where your lordships had passed detailed directions to implement the 321 order, and also had directed an inquiry against various officers. I appear for the landowner, but there is one small submission I'd like to make, because that direction was issued, possibly was inadvertently the BBMP didn't bring it to your lordship's attention, but after the order under 321(3) was passed, that is on 15/11/24, I had on 29th November 24, my lords, filed for review of that order on the ground that when the joint inspection was conducted, I was not given an opportunity.
Who is the review maintainable, Mr. Wilgore?
In any event, but the fact of the matter is, which is why on the bona fide genuine belief that my application is pending, I did not challenge it. Now, after your lordship passed the order, well, since the BBMP said there is no challenge to it, I've immediately filed an appeal. So my only request is this, my lords. Now, it's a mistake, yes. We should have filed an appeal immediately, yes. But
if you say the joint inspection has not been conducted, we'll get it conducted tomorrow in your presence, and we'll see if the violation is there or not.
Yes, but of course, that can be done. There's also
Your
another.
client has troubled the petitioners enough.
No, there's not.
The two ladies have been troubled enough by your client. He
No,
cannot
but
be
there's
going.
also another development. One of the major, and I admit, my lords, there is a violation. I'm not going to stand on technicalities and say there is no violation. But insofar as that basement is concerned, the bylaws, my lords, I'm instructed to submit that at that point in time, the area on which the construction was made was not adequate to construct a basement floor. I'm told, my lord, subsequently some 240 square meters has been purchased, the adjacent property, which would possibly regularize it. So we've also filed for a modification of the plan sanction. So all I'm saying is, my lord, if the demolition is complete and a fait accompli is presented. So
No, no problem. Now that you have come forward, until now you have not come. Now
No,
that
my
you
lord,
have
no, that also can I just explain, my lord. I don't know, possibly, I'm sure your lordship, that would have been inadvertence. The notice was returnable on 20th February, my lords, which is why I'm told until that 31st January order was passed, I didn't know that, because if my lords were to see the order of 21st January, it says
there's
notice
a
returnable.
typographical error.
Yes, my lord, which is possibly
You
why.
are entitled to take advantage of it.
No, not advantage, my lord. I mean, I was surprised. I'm sure there was a mistake. I mean, that's why. So, my lord,
So
my
many
only
things keep on coming for correction of the typography.
no, my lord, even when I saw it, I was quite
No
sure.
problem. What we will do is, now that you are here,
Yes.
we will direct a inspection.
Yes.
Let the a joint inspection happen. Let the verification happen as to what
Very well.
exactly is the violation.
Yes.
And if the violation can be rectified,
Very well.
it can be rectified.
I'm so grateful. That's
Whatever
all I'm asking.
cannot be rectified will have to
That
go.
will have to go. Absolutely, man. I can't ask for anything more. Absolutely. So great.
Shri Vikram Moilgol, learned senior counsel appearing for respond number 4, submit that the earlier inspection on the basis of which the 310 proceedings were initiated was carried out in the absence of the petitioner, and as such the petitioner was not present when the measurements were taken. His further submission is that if a joint inspection were to be conducted, the violations and or deviations from the plan sanction stroke building bylaws where if found would be rectified by the petitioner so as to try and save the building. And necessary application for modification of the building plan would be made by the petitioner.
Has already been filed, I'm told. Has already been
Yeah,
filed.
that is, the inspection was made on 4/5/2022.
Direct once more, you will also be there.
Thereafter, sufficient opportunity was given to the respondent number 4.
Building demolition
Demolition tala, but
bylaws
attitude,
prakara barಬೇಕು.
attitude of the respondent, because he has demolished my property totally. Your Honor, please to see the photos.
We saw that. That's why we said you're
That is
troubled.
totally my property has been fallen, and he has demolished my property since 2018. I am not using that property. That it is.
It will be direct inspection. They will compensate you for that losses also. Mr. Wilgol is here. No.
I mean, he has given.
Mr. Malli is here. Both of them are there. ಮುಂಚೆ ಯಾರು ಇರ್ಲಿಲ್ಲ ಇವಾಗ ಬಂದಿದ್ದಾರೆ. They will compensate.
Even he has given a revised plan. It was rejected by the authority also.
Revised plan.
Whatever we can salvage, we'll salvage. That's all.
Rejected.
He has sought for regularization of basement. Basement can only be regularized, Milords, only if the property, Milords, if it is more than 240 square meters. His property, Milords, is less than 240 square meters. So, Milords, basement cannot 215 birthdays.
Correct,
so
my
now
lord.
he's
That's why.
purchase an adjacent property and then submit.
Correct.
So he's purchased
That's exactly what we've done.
Consider that. If that is there, yes.
Yes. That's
not there, it will go.
Absolutely.
But whatever the damages have been caused to the petitioner, you will, as we observed some time back, your client has caused enough of.
Frankly, I wasn't aware of it. I won't. Whatever it is, I'll instruct my counselors.
He has made some other allegations against me that I agreed earlier. I agreed for joint venture, and I have made a submission. All the allegations are there, but I have not agreed for joint venture. Never I agreed for joint venture, and he himself has demolished my property without my consent, and in my absence, he has demolished my property.
Direct that. Don't worry. Carry out the application for modification of plan has already been submitted.
Yes.
The submission of Shri B.V. Somapur, learned counsel appearing for the petitioner, is also that a portion of the building of the petitioner has been illegally and unauthorizedly demolished by respondent number 4 while putting up construction by respondent number 4. In that view of the matter, the assistant executive engineer,
The zonal assistant commissioner. Assistant engineer.
assistant engineer,
He is present, not before.
who will be the
Executive engineer,
senior officer? Yeah.
executive engineers.
Deputy Director of Town Planning. Since it is a commercial property, Deputy Director of Town
The
Planning.
deputy director of town planning, with the assistance of such other officer of the HDMC.
One correction. Since the Deputy Director of Town Planning, my lords, there is no person, my lords, who has occupied the post. Let it be the zonal assistant commissioner. He will conduct the spot inspection.
ಇಷ್ಟೆಲ್ಲ ಹೇಳಿದ್ರೆ ನೀವು ಕಷ್ಟ. The
Zonal assistant.
commissioner,
Commissioner
HDMC,
Commissioner.
is directed to cause a inspection of the property of the petitioner and that of the respondent. Carry out necessary measurements of the constructed area, the setback area, ground coverage, and such other identifying factors as are available under the building bylaw stroke sanction plan, and submit a detailed tabulated report as regards the construction carried out, construction permitted under the plan sanction, and construction permitted under the building bylaws. Similar tabulated statement to be placed on record in respect of the open areas required to be maintained, as also the basement. Para. The commissioner shall also cause the inspection of the property of the petitioner to ascertain the nature of demolition which has been caused, the extent of demolition, including the area thereof, and submit a report. Since the order is passed in presence of all the council, there would be no requirement of issuing any fresh notice. The inspection and measurement shall be carried out commencing from 7th February, 10:30 a.m. on 7th February, and report to be submitted by 11th February, after furnishing a copy thereof on the counsel for the petitioner and the respondents. Since inspection has now been ordered, the order dated 31/2025 shall remain stayed till further orders. Needless to say, the ESCOM, Karnataka Urban Water Supply and Drainage Board, the jurisdictional police station house officer need not take any steps in furtherance of said order. It's however made clear that the commissioner, HDMC, shall submit a report in terms of para 7 of the order dated 31/2025 by the next date. Relist on 11th February.
Grateful. Request 14th, I'm there physically, well, for another matter. 14th, if it's
14th February.
Grateful.
Great. Why are all of you people coming to Dharwad on 14th?
Not sure who else is coming.
Everybody seems to be coming. Mr. Arvind Kamath is coming. Ms. Pratima Vannapura is coming. You are coming.
Not for the same matters, probably some other matter.
Don't blame this court at home.
No, not at all.
You are voluntary. This is a voluntary non-fit injury all of you have taken.
Frankly, Maharaj, the only beneficiaries are Indigo Airlines and some of the hotels around there.
Yes.
Great.
30.
33, Harsh Desai.
Appearing for respond number 5 to 10 minutes.
Petitioner, my lord. My lord, requires to be heard.
The rejoinders have been filed.
Please, my lords.
The respective rejoinders filed are taken on record. IA 1 of 2024 and IA 2 of 2024 will be considered along with the main. Yes, it has to be heard. How long will you take?
But it may, between us, my lord, both of us, it may take an hour.
10 minutes, my lords.
Then, my lord, I will finish in 20
10
minutes.
minutes ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
In
ನಿಮ್ಗೆ
20
ಎಷ್ಟೊತ್ತು ಹೇಳಿ?
In 20 minutes, my lord, I will.
20 minutes. When will you do it?
We are ready, my lords.
Any Wednesday, next Wednesday.
ನಾವು ಇವತ್ತು preliminary hearing ಗೆ ಬಂದಿಲ್ಲ ಇನ್ನ ಮ್ಯಾಟರ್ ತಗೊಂಡಿದ್ದೀವಿ.
Tomorrow, my lords, may I request?
Friday 7th?
Friday, please.
My lord, Friday, I'm,
Friday ಬೇಡ ನೀವು.
my lord, Wednesday, my lord.
Next Wednesday 12th?
Please.
Released on 12th.
Could it be
at 2:30 p.m.?
2:30?
Please, my lords.
Mrutyunjay Tata Bangi.
What is this amendment, Mr. Bangi?
Could recollect, my lord, in the prayer column, my lord, I had sought a writ of prohibition. That, my lord, I have filed an application for correction.
Allow the application.
That application may be allowed, my lord,
Accepting the
last
reasons
occasion.
stated in support of IA 1 of 25, the said application for amendment is allowed. Counsel for the petitioner to carry out necessary amendment, file amended petition.
Yes.
Any further objection, Mr. Patil?
Further objection is not there, my lord. There, last time I submitted that this writ petition itself is not maintainable.
That we'll consider on.
Because once it has gone up to Supreme Court, it has come back.
Amended Act Barley. Amendment to be carried
Short.
out and amended petition to be filed on or before 10th February, failing which the petitioner will forfeit the right of the amendment order. Relist on 12th.
Please.
Obliged.
35, Harish Naik.
Second respond filed, passed implement order against the dead person, my lord, in a land tribunal, my lord.
Chandrasekhar Gowda.
All are served, my lord.
Cavator.
Cavator, my lord.
So the,
Yes.
my lord, I appear for the fifth respondent. My lord, the present petition itself not maintainable, my lord, because the statutory remedies before the Karnataka Appellate Tribunal, my lord, as per section 118, subclause 2 of Karnataka Land Reforms Act, my lord.
Whose order is challenged here?
Assistant Commissioner order, my lord.
Assistant Commissioner order, my lord.
On form number 7A, my lord.
77.
On form number 7, my lord. Writ is maintainable, my lord. Since,
My lord, I have produced.
Wait, Mr. Gowda. How is the writ maintainable?
One judgment is also quoted, my lord, Supreme Court. There is the
Kodi, judgment Kodi.
judgment, and I will
Copy Kodi.
furnish it tomorrow, my lord.
If you want to rely on it, you have to furnish it to the other side and to the court also. When counsel for the petitioner seeks for and is granted 3 days time to place and record a judgment that he wishes to rely upon. Yarappa, good morning. ಇವಾಗ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. List on 10th January, February.
Please, my lord.
36, G.A. Gitchinmat.
I filed an application, my lords, seeking, my lords, directions, my lords, to permit me to take up the examination. My lords,
How examination?
my lords, BAMS first course, first year course. My lords, petitioner number 1, my lords, is a college, and petitioner number 2 is, my lords, is a only student. And my lords, in the first instance, my lords, she has qualified marks and she has attended the counseling also.
Her ranking is 9,56,639th rank.
How so? And there will be stray rounds, my lords, last rounds. And the last date, my lords, for appearing through counseling would be on 30/11/2013. She has appeared in the counseling and she has paid the entire fees also. And there afterwards, my lords, she has opted for this college. Now, my lords, the only contention is that, my lords, the college, my lords, has got the
And she is?
She is not 60th candidate.
60th.
60th candidate. And the interim order is already granted wherein she has been permitted not for admission. Now the examination is not something taken.
She has to, my lords, get the allotment letter from the KEA. She has to get an allotment letter, my lords, from the KEA. Then only, my lords, the university, my lords, approve the admission.
On her complying,
Allah,
permitted.
As per, my lords, the KEA, my lords, she has not attended the counseling. They have filed objections.
No, she has attended the counseling.
When is the exam? When is the exam?
Lords, it's coming up on in the, I have produced the document also. Lords, February 14th onwards, lords, the exam.
We'll take it up on 7th. Get ready to address arguments. Relist on 7th at 2:30 p.m.
Please. My lords, for KEA, my lords, Shurvi Kulkarni. My lords,
I
she
appear
appears.
for the examination authority, my lords.
Has she attended the counseling?
She had attended, but she was not allotted any seat, my lords. I've produced the allotment list with my objections.
Not allotted only because of the intake criteria being not satisfied.
There were two seats, my lords, as on the date of last allotment. And they have been allotted to two other candidates. She was not allotted any seat, my lords.
60 ಒಂದು ನಿಮಿಷ ಇರ್ರಿ ಅವ್ರು ಕೇಳ್ತೀವಿ ನೀವು KEN
Please, the seat matrix for...
complete ಆಯ್ತಾ
Please, my lords. The vacancy for the last round, as per annex, my lords, my objections, page number 13.
Yes.
Lords, the vacancy is shown in the sixth, my lords, line from bottom. Mahavir Pulakeshe Ayurvedic Medical College. 1742 AQ is the code, my lords. Page number 13.
13.
Please.
13.
This is filed by...
There's only documents. Objections are here.
On behalf of respond number 1, my lords.
That documents. 13.
13, my lords. Sixth from bottom. 1742 AQ is the code, my lords, in the first column. That college had two vacancies in the last column, my lords. And as per annexure R4, my lords, page 19 may be perused.
Yes.
Page 19, serial number 20 is one candidate, my lords. And page 20, serial number 37 is the other candidate.
Serial number?
37 at page 20, my lords. And the petitioner number 2 was not allotted any seat. And my lords, in violation of the regulations, the petitioner number 1 has admitted petitioner number 2 without counseling, my lords.
So these two people at 19 and 37, 20 and 37.
Please, they are admitted.
Have been admitted.
Please.
So 60 quota is reached.
Full, my lords. And as per regulations, my lords, I have produced at annexure R5. My lords, the relevant regulations are, my lords, page number 23.
Yes.
Page 23, regulation, my lords, 7. And more importantly, NCISM is not a party to this petition, my lords, whereas that is the authority which regulates the admissions to Ayush seats. Regulation 7, may I read, my lords?
NCISM is not a party.
It's not a party, my lords.
ಯಾಕೆ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ?
My lords, KEA comes at the end, my lords.
You will have to send the list to NCISM, which in turn is forwarded all over the place.
Yes.
NCISM is the first block. ಅವ್ರನ್ನೇ ನೀವು ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಅದು ನಿಮ್ಗೆ ಇವಾಗ ಅವ್ರ ಅಪ್ರೂವಲ್ ಕೊಟ್ಬಿಟ್ರೆ ಆಯ್ತು ಅಂತ, ಬಟ್ ಯು ಹ್ಯಾವ್ ಟು ಸ್ಯಾಟಿಸ್ಫೈ ಲಾಟ್ ಆಫ್ ಅದರ್ ಥಿಂಗ್ಸ್. Are 60 students already taken in? Then this petition number 2 will be 61.
Only 59 students are there in my college as of today.
So who is going to tell us that? NCISM will have to tell us as to who are the students who are enrolled with you.
They have to submit.
One more,
ಆಮೇಲೆ ನಾಳೆ ಅವ್ರಿಬ್ಬರಿಗೂ ಕೊಡಿ ಅಂತ NCISM ಕಳ್ಸಿದ್ರೆ ನೀವು.
one more submission, my lords, as per,
See, if you are within 60, we'll permit. If you are not within 60, college will pay 25 lakhs compensation to the student.
even as
1
per
year
this,
loss.
even as per these regulations, my lords,
ಎಲ್ಲ ಬಿಟ್ಟೋಗ್ಬಿಟ್ರೆ ಎಲ್ಲ ಬಿಟ್ಟೋಗ್ಬಿಟ್ರೆ ಸ್ಟೂಡೆಂಟ್ಸ್ well within ಅಂತ ಹೆಂಗ್ ಆಗ್ತಾರೆ.
as per these regulations, there can't be any direct, my lords, admissions by the colleges. And my lords, that is in violation of these regulations and also directives of the NCISM.
There's already an interim order passed by this court.
Please,
If they are
please.
within 60, we'll continue. If this is 61, it won't be permitted. Being of the opinion that the NCISM, National Commission for
Indian System of Medicine.
Indian System of Medicine is a necessary party. NCISM is brought on record as respond number 4. Our standing councillor,
Avinash Angadi.
Shri Avinash Angadi is directed to accept notice for respond number 4. Counsel for the petitioner to furnish two sets of the petition along with annexures on the said councils. Relist on 7th February at 2:30 PM.
May I request on 6th, my lords, 7th I have some,
6th is tomorrow.
please.
Instructions baratta ella.
ಇಲ್ಲ ಅವ್ರು ಯಾಕಂದ್ರೆ ಅವ್ರು 30 ಆದ್ಮೇಲೆ ಅವ್ರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೋಬೇಕು.
Relist on 10th February.
Not on 10th, on 11th.
My lords may have it on 7th. My lords may have
7th
it on
February. To enable the respective councils for the respondents to obtain instruction, make their submission as regard the total number of students admitted at the petition number 1 institution for the BMS UG course for the academic year 23-24. 2:30. Thirty-three interim order earlier granted is extended till next year.
37, Sunanda P. Patil.
Please.
The name of the petitioner is going to be entered in the record of rights pertaining.
We'll have it on another day, madam, in a preliminary hearing, Mukshan. 37 relist, due to paucity of time, the matter cannot be taken up today. Relist on 13th February. Interim order earlier granted is extended till next week.
38, Vittal Teli.
Same order. Relist on 13th.
40 Arjun, 41, Santosh Mane.
13.
39 ಆಯ್ತಲ್ಲ.
40 ಅಜ್ಜನ್ ಆಗಿದೆ.
39 ಆಯ್ತು.
ಇಲ್ಲ
40 ಅಲ್ಲಿ ನೀವು petitioner ಇಲ್ವಲ್ಲ? 40 is SB Doddagowder.
ಇಲ್ಲ ನೋಡು, serial number 39 is not called out.
ಒಂದು ನಿಮಿಷ ಯಾವ್ದು ಕನ್ಫ್ಯೂಷನ್ ಇದೆ?
39, Vittal Teli.
In
38.
38. 38 we'll have it on 13th.
13.
Admission preliminary hearing ಮಾಡೋಣಂತೆ. There are some urgent matters.
It is arising out of execution proceedings, insisting.
Yes.
39, Vittal Teli.
10 days time to get the records. There was a direction.
Is granted 10 days time to secure the records. Records to be secured on or before 14th, relist on 19th. If records are not secured by then, respond number?
The land tribunal, R1.
R1, the chairman of respond number 1 shall be present personally before this court.
41, Santosh Mane.
38 interim order. 41 due to paucity of time cannot be taken up, relist on 13th.
42, Sadiq Gudwala.
I have 1 to 5. Counsel for the petitioner seeks fund is granted a week's time to file his objections to the impeding.
One thing, Malas.
Objections, if any, to be filed on or before 13th, relist on 18th.
As a notification, my lords
Interim
have
order earlier
granted
granted is extended.
interim order. Section 50 ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ ಅಂತ
We'll
ಮಾಡಿದ್ರು.
see that next.
Please.
Interim file objection.
Date, my lord.
18.
Please, please.
43 RH Changdi.
Counsel for the petitioner has filed a memo seeking for dispensation of notice to respond number 29. Accepting the same, the notice to respond number 29 is dispensed with at the sole risk, cost and peril of the petitioner. Needless to say, respond number 29 will not be bound by any orders passed by this court. Idondena irado in ella compliance. Counsel for the petitioner submit the rest of compliances have been made. Relist on 17th.
44 Jagdish Patil.
Counsel for the petitioner submit that he has obtained the certified copy today and he'll comply with the objection given 2 days time. Relist on 11th.
45 Sri Vidya.
For the.
Why CRP connected with GM?
Yes, right petition.
LR of R15. Notice ಆಗಿದೆಯಾ?
ಆಗಿದೆ ಎಲ್ಲರೂ ಇದು
ಅಲ್ಲ R15.
R15 ಯಾರು?
R15 ಸರ್ವ್ ಆಗಿಲ್ಲಲ್ಲ ಮಿಸ್ಟರ್ ಒಡೆಯರ್.
Writ petition.
55.1. R15 ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ? ಇವರಲ್ಲಿ ಯಾರಾದ್ರೂ ಅಪಿಯರ್ ಆಗ್ತಾರಾ ನೋಟಿಸ್ ಕೊಡಕ್ಕೆ?
ಇಲ್ಲ ಅದ್ರಾಗ ನಾವು ಪಾರ್ಟಿ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ರಿಟ್ ನಲ್ಲಿ
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾದ್ರೆ. During pendency of the above matter, respond number 15 has expired. As such, IA 1 of 25 has been filed. Issue notice on IA 1 of 25 returnable by 25th March. During pendency of the above matter, respond number 5 is also expired. Hence, counsel for the petitioner has filed a memo as legal representative of deceased, respond number 5. Counsel for the petitioner to carry out necessary endorsement in the cause list, cost act. Interim order earlier granted is extended till next date.
Preliminary hearing 46 urgent 47 PG Chiknargun.
Orders from 21. Yes. There is no question of stay. And AGA accepts notice for respond number 1 to 3. Issue emergent notice to respond number 4 to 13, returnable by 11th March.
48 Srihas Nilopan. Srihas Nilopan.
This case, last time he submitted that the chairman is resigned. And they have become the chairman. They are now neither the chairman nor the secretary.
No, this has to be listed on 22-25. Why is it listed today?
ಅದು 5 ಅಂದ್ರೆ 22 ಆಯ್ತು ಸರ್. ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ 22 ಕಾಗಿ. ಆದ್ರೆ ಎರಡು ಪೋಸ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ. He submitted that he will produce that resolution. The chairman is here. He has not. ಅಲ್ಲ this. He is representing the chairman in another case. He says that he has not resigned. He himself is the chairman and somebody else coming out before this one.
We'll have it on 20th. Relist on 20th.
Lord, may I request on 22nd?
Earlier date ಕೊಟ್ಟಿರೋ 20th.
22nd
ಹೆಂಗಪ್ಪ ಸ್ಯಾಟರ್ಡೆ ಬರ್ತೀರಾ ನೀವು?
Sorry.
20th.
Please. 20th.
49 Sanjay Chanal.
2 days time.
Today's time to file.
And AGA 6 fund is granted a week's time to file affidavit of respond number 2 and 4, relist on 13th. Interim order earlier granted is extended till next day.
50, BV Somapur. BV Somapur.
And AGA accepts notice for respond number
1 to 4.
1 to 4. Issue notice to respond number 5 to 26, returnable by 18th March.
51, Enna.
Michael Matadi, Mr. Mike. Annexure C.
Please.
Yes.
On earlier occasion, my lord, when the MA order was under challenge, this honorable court, my lord, directed to dispose of the suit within 6 months, my lord. That was in 2022, my lord. Thereafter, my lord, the defendants used to file one application after the another, my lord. Still, my lord, the matter is going on since 2 years, my lord, without any. Therefore, my lord, with the direction, my lord, to dispose of the suit within 6 months, my lord.
Once already agide alla.
ಅಲ್ಲ ಹಿಂದೆ ಆಗಿದೆ therefore
Extension ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ.
ಇವರು ಅಪ್ಲಿಕೇಶನ್ಸ್ ಹಾಕ್ತಾನೆ ಇದಾರೆ.
ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾ ಇದ್ದಾರೆ. They are taking.
ಆಗಿದ್ರು ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರಿಗೆ ಇಲ್ಲಿ.
PG Mugli had appeared, my lord.
The PG Mowgli is directed to accept notice for respondent number 1 to 3 since he had appeared for the respondents earlier in WP number 110075 of 2019. Relist on 13th February.
Please.
52, Sharanappa Kolivad.
I appear for petitioner, my lords.
Yes.
My lords, we are challenging the order on rejection of IA number 22, my lords. My lords, we had filed IA number 22, my lords, seeking to amend the plaint, my lords.
What stage did you file it? After evidence?
My lords, the matter was remanded, my lords, by this honorable court, my lords. After remand, my lords, we have filed the present application, my lords.
What was the stage of the suit?
Evidence of defendant, my lords.
Where is the order of remand? Why was it remanded?
My lords, that.
ಏನಕ್ಕೆ ರಿಮೈಂಡ್ ಆಯ್ತು?
My lords, it was remanded, my lords, on the ground to consider all the issues, my lords. The suit was dismissed on the ground that, my lord, there was no cause of action on the preliminary issue, my lords, that there is no cause of action, my lords. Subsequently, my lords, this honorable court remanded the matter to consider all the issues, my lords.
Three A and 3B can be allowed, 3C difficult.
Lords, in
You
3C.
notice to respondents returnable by 19th March. The further proceedings in OS number 24 of 2011 pending on the file of Senior Civil Judge and JMFC Arapnalli. He stayed till the next date of hearing. Process fee and copies to be furnished by end of day 7th February, and acknowledgement of service on the respective counsels for respondents to be filed by end of day 13th February, failing either of which the interim order will stand automatically vacated.
Obliged.
53 urgent, 54 KL Patil.
Taken next week.
Though counsel for the petitioner is present, none appears for the respondents. Relist on 13th.
55, SB Abballi.
My lord, this is petition of defendant number 2, my lords. In the case, we have filed return statement along with counterclaim, my lords. Defendant number 3 has filed a counterclaim against defendant number 2, my lords, which is not permitted under order 6 to
Suit for?
partition, my lord. Partition position.
Can be filed in a partition. Everybody is plaintiff and everybody
No, my
is
lords.
that is in a regular suit, not in a partition suit.
In that suit, the defendant can file the counterclaim against the plaintiff, my lords.
In a suit for partition, everybody is a plaintiff, everybody is a defendant.
It is.
So between each other, they can file.
My lords, it is suit for relief for partition separate possession, man.
ಎಲ್ಲರಿಗೂ ಶೇರ್ ಬರುತ್ತಲ್ಲಪ್ಪ. ಬೇರೆ ಸೂಟ್ ಫಾರ್ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಡಿಕ್ಲರೇಷನ್ ಹಾಕಕ್ಕಾಗಲ್ಲ.
But the order under order 8 rule 6 states that only against the
right in
plaintiff.
the normal circle, not in a partition suit. ನೋಡ್ಕೊಳ್ಳಿ, ಓದ್ಕೊಳ್ಳಿ ಆಮೇಲೆ ಆರಾಮಾಗಿ. Petitioner is before this court seeking for the following reliefs. Notice to respondent is dispensed with in view of the order proposed to be passed. A suit in OS number 3 of 2022 had been filed by respondent number 1 and 2.
My lords,
seeking
it was
for-
also filed after the lapse of time, my lords.
Seeking for partition and separate possession. In the said suit, respondent number, who filed the counterclaim?
Respondent number 4.
Defendant number 3, who is respondent number 4 herein, had filed a counterclaim. Essentially, contending that the defendant number 2 had no independent income and could not have purchased the properties as contained in the written statement of defendant number 2. The said application has been allowed by the impugned order dated
My lords, we have filed.
2/3/2024. The petitioner is before this court challenging the same. The submission of, what's your name?
Pranav.
ನಿಮ್ಮ ಹೆಸರು ಬರಿಬೇಕಾ ಹೆಬ್ಬಳ್ಳಿ ಅವ್ರ ಹೆಸರು ಬರಿಬೇಕಾ?
Hebel.
The submission of Shri SB, if it had been allowed, we would have put your name. Submission of Shri SB Hebballi, learned counsel for the petitioner, is that a counterclaim could not have been filed inter se between the defendants. In the present case, the counterclaim having been filed by defendant number 3, contesting the claim of defendant number 2, the same could not have been considered and allowed by the trial court. The submission of Shri SB Hebballi would have been correct. Having heard Shri SB Hebballi's submission, I am of the considered opinion that his submission would have been correct in a suit otherwise than a partition suit. It is tried law that in a partition suit, each of the parties who are family members are plaintiffs as also defendants for each other. Thus, the right of each of the family members being determined in a partition suit, any claim or counterclaim could be filed amongst themselves irrespective of whether they are co-defendants or not. In that view of the matter, I do not find any infirmity in the order passed by a trial court. The petition stands dismissed at the stage of admission itself.
56, Balgowda Patil.
My lord, suit for specific performance of contract, my lord.
Suit for specific purpose?
Yes, my lord.
Yes.
My lord, respondent number 1 has executed registered agreement of sale in favor of petitioner, my lord. And he has filed suit, my lord, for specific performance, my lord. And respondent number 1 is husband, my lord. And respondent number 5, 6, 7 are his wife and children, my lord. And respondent number 5 to 7 have filed impleading application, my lord. For impleading themselves in suit for specific performance, my lord.
Yes.
But my lord, they are the non-alienating members of the suit property, my lord. Even though the property is ancestral in nature, my lord, but they are not necessary party in a suit for specific performance, my lord.
So you won't claim any right in their interest?
My lord, being a Karta, he has executed registered agreement of sale, my lord.
Do you claim a right in their interest or no?
Yes, my lord.
If you are claiming as Karta, they are necessary party.
But my lord, I am relying on the judgment of this.
If you claim as Karta, they are necessary party.
Yes,
If you are claiming only as regard the individual right of that person, then no.
as a Karta, as a Karta, my lord.
Then they'll have to come on record. If the Karta is acting contrary to the interest,
But my lord, in the specific performance of contract, they are not necessary party, my lord.
you are claiming as Karta,
Yes, my lord.
not as regards individual right. Individual right andre your right.
No, my lord.
Karta
As a
andre
Karta.
ಅವ್ರಿಗೂ affect ಆಗತ್ತನೆ.
Yes,
They are affected parties. Petitioner is before this court seeking for the following reliefs. Notice to the respondent is dispensed with in view of the proposed order to be passed. The petitioner had filed a suit in OS number 299 of 23, seeking for specific performance of agreement of sale executed by defendant number 1. In the said suit, an application came to be filed by the wife and children of defendant number 1 to implead themselves in this as parties, claiming that they have a right title interest in the said property. The said application having been allowed while order dated
3/2/2024, my lord.
3/2/2024, the petitioner is before this court seeking for the aforesaid relief. The submission of Shri Balgowda A. Patil and counsel for the petitioner is that defendant number 1 having executed an agreement of sale as Karta of the family, his wife and children are not necessary parties to the proceedings, and as such, they are not required to be brought on record. The trial court ought not to have allowed the application for impleading filed by them. Heard Shri Balgowda A. Patil and peruse the papers. The submission and contention of the plaintiff is that defendant number 1 has executed the agreement of sale, subject matter of the suit for specific performance, as the Karta of the family. It is not the individual right of defendant number 1 which is subject matter of the specific performance suit, but the right of the family which defendant number 1 represents as the Karta. If that be so, his wife and children who are also having an interest in the property are proper and necessary parties, more so in the event of defendant number 1 acting contrary to the interest of the family. As such, I am of the considered opinion that even if the suit for specific performance is decreed on the basis of an agreement of sale executed by the Karta, the same being binding on the wife and children, they are also proper and necessary parties. As such, I do not find any infirmity in the order passed by the trial court. The petition is dismissed at the stage of admission, sir.
57, Srinant Chapure.
The Deputy Commissioner has rejected the application of the petitioner for conversion of agricultural land to non-agricultural without assigning any reason. Last date of hearing note, government advocate has got time to take instructions.
Lord, we have got the instructions. Today I have received.
You received.
Yes.
And AG submit that he has received instructions today. He seeks for 2 days' time to go through the same and make a submission. Relist on 10th.
Please.
58, Vinay Kumar Shetty.
Please, my lord. My lord, in the present petition, my lord, petitioner is the owner of survey number 16 2A 1B, my lord, wherein the petitioner has purchased the said property.
Shiv Sai Patil.
I'm for Arun and Auto. I filed a color.
New Year ge?
National Highway.
NHA. Please so and so submit
Please
that
delete
you would
the
be
name of
appearing
Shiv
for.
Sai
Name Esru?
BP Matpati.
Shri BP Matpati has appeared for respond number 1 and 2. Registry directed to delete the name of Shri Shiv Sai M. Patil as that appearing for respond number 2. In acquire madidira?
Yes, sir. Next time I filed my objection.
Next time andre yavaga?
My lords, within a week. Within a week, sir.
Within a week.
Lords, for annexure may kindly be seen, my lords. They have only admitted that petitioner land is not acquired. Annexure page number 29, my lords. The respondent number 1, Tahsildar, the special land acquisition officer himself says that, my lord, petition land is not acquired by the land acquisition SLO, my lords, for the construction of Hubli.
Counsel for respond number 1 and 2 seeks for and is granted a week's time to make a submission as
In the preliminary hearing only, my lords.
Bharat, please.
59,
In
Srinivas.
this case, I appear for the petitioner, my lord. This matter pertains to widening of a road of about 1.2 kilometers near the village of the petitioner herein, who has been struggling from the past 10 years to get this road widened and make it motorable. And even the Tahsildar, jurisdictional Tahsildar also has recommended, and the forest department has also issued no objection that road may be repaired and made motorable within the
ಎಷ್ಟಿದೆ ಇವಾಗ width?
width. It is just 3 meters, 5 feet, I think, my lord.
5 feet. That's not even a cart track, it's a footpath.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕಿಂತ ಕಡಿಮೆ ಇದೆ. ಎಕ್ಸಾಕ್ಟ್ಲಿ 80 ಮೀಟರ್ ಉದ್ದ ದಾರಿ, 6 ರಿಂದ 8 ಅಡಿಯಷ್ಟು ಅಗಲ ದಾರಿ ಇರುತ್ತದೆ. That annexure D, page 44, that forest department has opened. But
then it's a footpath, Mr. Gopal Krishna, that cannot be widened into road in the forest area.
it is not widened, my lord. Road is not there.
So is it in the forest area?
Yes, my lord. Forest area.
Forest area cannot be diverted for a road.
No, your lordship may kindly see annexure D, page 44.
Page 44.
The last paragraph. ಹುಲ್ಲುಂಡೆ ಗ್ರಾಮ ನಕಾಶೆ ಹಾಗೂ ಗ್ರಾಮ VFR ಅನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ರಸ್ತೆ ಇರುವ ಬಗ್ಗೆ ನಮೂದು ಇರುವುದಿಲ್ಲ. ಆದರೆ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯ ದಾಖಲೆಗಳಲ್ಲಿ ಕಾಲುದಾರಿ ಬಗ್ಗೆ ದಾಖಲಾತಿ ಇರುವುದಾಗಿ ಪಂಚಾಯಿತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳು ಹೆಗ್ಗರಣೆ ಇವರು ದಾಖಲಾತಿ ಪತ್ರ ನೀಡಿರುತ್ತಾರೆ. ಸದರಿ ಅರಣ್ಯ ಸರ್ವೆ ನಂಬರ್ 262ರಲ್ಲಿ 80 ಮೀಟರ್ ಉದ್ದ ದಾರಿ ಇದ್ದು ಈಗಾಗಲೇ 6ರಿಂದ 8 ಅಡಿಯಷ್ಟು ಅಗಲ ದಾರಿ ಇರುತ್ತದೆ. ಇದರಲ್ಲಿ ಸದರಿ ಅರಣ್ಯ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ರಸ್ತೆಯನ್ನು ಅಗಲೀಕರಿಸುವ ಅವಶ್ಯಕತೆ ಕಂಡು ಬರುವುದಿಲ್ಲ. ಬೆಟ್ಟ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಮಾಲ್ಕಿ ನಂಬರ್ 88ರಲ್ಲಿ ಹಾನಿಯಾಗದಂತೆ ಇರುವ ಸ್ಥಳಾವಕಾಶವನ್ನು ವಾಹನ ಚಲಿಸುವಂತೆ ಬಳಸಿಕೊಳ್ಳಬಹುದಾಗಿದೆ. ಆದಾಗ್ಯೂ ಅಗತ್ಯ ದುರಸ್ತಿಗಳನ್ನು ಮಾಡುವ ಮರಗಳಿಗೆ ಹಾನಿಯಾದಲ್ಲಿ ಅಥವಾ ಕಾನೂನು ಉಲ್ಲಂಘನೆ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುತ್ತದೆ. There is no road. ರೋಡೇ ಇಲ್ಲ. ರೋಡ್ ಮಾಡಕ್ಕೆ, ರಿಪೇರಿ ಮಾಡಕ್ಕೆ, even there was sanction was also granted. If your lordship look at the
Yes, but we can't issue a mandamus if it is a forest land.
My lord, annexure B kind.
ಅಲ್ಲ, ಫಾರೆಸ್ಟ್ ಲ್ಯಾಂಡ್ ಇದೆ ಸ್ವಾಮಿ, but they have said there is a road. Only they want it to be repaired. That is what
Widen repair, Mr. Gopal Krishna.
it needs to be repaired. It needs to be repaired only.
Repaired is different.
It needs to be motorable, my lord. It is not
Motorable is different.
motorable
Repair and motorable widening, all of them are three different things.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಈಗ
Don't
motorable
try to push all of them.
Page
ಅಲ್ಲ
40.
motorable ಮಾಡಿದ್ರೆ ಸಾಕು.
One
motorable
ನಿಮಿಷ ಇರ್ರಿ. What is the annexure?
Operative portion. It is an order passed by the Tahsildar. ಕಾಯ್ದಿಟ್ಟ ಅರಣ್ಯ ಸರ್ವೆ ನಂಬರ್ ಮೂಲಕ ಹಾಯ್ದು ಹೋಗುವ ಆದಾಯ 3 ಅಡಿ ಅಗಲದ ಕಾಲದಾರಿ ಯಾವುದೇ ಮಾಲೀಕ ಸರ್ವೆ ನಂಬರ್ಸ್ ಬೆಟ್ಟ ಗಿಡ ಮರಗಳನ್ನು ಹಾನಿಯಾಗದಂತೆ ಯಥಾಸ್ಥಿತಿಯಲ್ಲಿ ಉಪಯೋಗಿಸಲು ಹಾಗೂ ಅರಣ್ಯ ಪ್ರದೇಶ ಸಂಬಂಧಿಸಿದಂತೆ ಪ್ರಾಧಿಕಾರದಿಂದ ಪೂರ್ವ ಪರವಾನಗಿ ಪಡೆಯದೆ ಯಾವುದೇ ಅಗಲೀಕರಣ ಈ ರಸ್ತೆ ನಿರ್ಮಾಣ ಕಾರ್ಯ ಮಾಡದಂತೆ ಈ ಮೂಲಕ ಆದೇಶಿಸಿ.
Only 3 feet.
Yes.
ಕಾಲ್ದಾರಿ ಮಾತ್ರ.
ಹೌದು. Comes under the forest area.
Can't be widened. If it's a forest land, you have to follow the procedure and the forest conservation section 2.
Yes, my lord.
Without that, it cannot be used. But ಈ ಹಳ್ಳಿಗೆ ಬೇರೆ ಏನು ಊರು ದಾರಿ ಇಲ್ವಾ?
ದಾರಿ ಇಲ್ಲ ಸ್ವಾಮಿ. Your lordship
ಹಳ್ಳಿ ಹೆಂಗ್ ಬಂತ್ರಿ ಅಲ್ಲಿ?
annexure C.
ಅಟ್ಲೀಸ್ಟ್ ಒಂದು ಕಾರ್ಟ್ ಟ್ರ್ಯಾಕ್ ಆದ್ರೂ ಇರ್ಬೇಕಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಏನೂ ಇಲ್ಲ.
ಅದನ್ನ ಅಸರ್ಟೈನ್ ಮಾಡಿ ಹೇಳ್ತೇನೆ. I will ascertain and make submission whether there is any alternative land. Road.
Land AG is
ಇಲ್ಲ ಸ್ವಾಮಿ, annexure C may kindly be seen, my lord. Annexure C ಅಲ್ಲಿ ಅವರೇ ಹೇಳಿದ್ದಾರೆ. That last paragraph ಅಲ್ಲಿ last line, page 41. ಮೇಲ್ಕಂಡ ಅರ್ಜಿದಾರ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಅರ್ಜಿದಾರರು ವಿವರಿಸಿದ ವಿಷಯಗಳು ನಿಜವಿದ್ದು ತಾರಸರ ಮತಗಟ್ಟೆ 168ಕ್ಕೆ ತೆರಳಲು ಸಾರ್ವಜನಿಕರ ತೊಂದರೆಯಾಗುವ ವಿಷಯವು ಕೂಡ ನಿಜವಿರುತ್ತೆ. ಕಾರಣ ಅರ್ಜಿದಾರರು ಸದರಿ ರಸ್ತೆಯನ್ನು ತೆರವುಗೊಳಿಸುವ ಬಗ್ಗೆ ಸೂಕ್ತ ಕ್ರಮಕ್ಕಾಗಿ ಅರ್ಜಿ
Has to be
ಸ್ಥಿತಿಯೊಂದಿಗೆ
some access.
Yes, I will ascertain and mix.
And AGS seeks for is granted a week's time to make a specific submission. As to whether there is any other access to the ಯಾವ village ನಿಮ್ದು?
Yes, sir.
What is the name of the village?
Charakone and Kodemene, the 1.5 kilometer stretch between
Charakone village.
and Kodemene village. Either Madhya 1.2 kilometer road is not motorable. Only that extent I am seeking motorable
And
from past 10
Kodemene
years.
village, Siddhapur Taluk, Uttara Kannada district.
Also.
And what are the arrangements? And if no such road is available, what arrangements could be made to provide a motorable access road to said villages? Relist on 13th.
Grateful, my lord.
Registry is correct the appearance of counsel for respond number 5 and 6 as Sri S.V. Yaji.
So my name will kindly be shown in the cause list, my lord. I have
Registry is also direct print the name of Sri Gopal Krishna K. appearing for the petition.
60, Manjunath Torgal.
Grateful, my lord.
Yes.
Lords, I am for the petitioner, lords. I have challenged the order passed by the deputy commissioner, lords. At annexure A, lords.
There is no interim relief.
No. No interim.
AGA accepts notice for respond number
1 to 4.
1 to 4, issue notice to 5 to 7, returnable by 19th March.
Please, lords.
61, Arvind Kulkarni.
Yes, Mr. Patil.
Respond to
Yes.
ನಿರ್ಮಿತಿ ಕೇಂದ್ರ
Respond number 1 ಅಷ್ಟೇನಾ?
Yes.
74 ಜನ ಇದ್ದಾರೆ.
They were representing all in trial court. In trial
accept
court,
notice
all
for all
plaintiffs
the
were represented by the same advocate.
I'll only give it in respect of respond number 1, plaintiff number 1.
The single counsel before the trial court.
Yes, ma'am.
Then you accept notice for all. ಇಲ್ಲಿ single counsel ಅಂತ ಎಲ್ಲಿ ಬರುತ್ತೆ? They are the
Lordship.
plaintiffs, sir.
They were all the plaintiffs, my lord.
1 to 8,
Plaint-
12 to 42.
12 to 42, they are again defendants. This is a public interest suit.
Plaintiffs.
In page 30,
30.
plaint nalli.
MA ಅಲ್ಲಿ
MA ಅಲ್ಲಿ, your lordship,
ಒಂದೇ counsel ಆ?
same.
MA ಎಲ್ಲಿದೆ?
MA is at page 72. Five to 36 PKP, 4 KBM, ADGP.
5 to 36.
Yes,
40 members are the plaintiffs. So it is not all 74. ನೀವು
because
rank of parties
they are added, some of them are defendants, my lord. Plaintiff have obtained injunction against which there was MA.
You are defend number 4.
Yes.
The others are not. Yes, ಹೇಳಿ ಏನಿದು?
What has happened is there is a Raj Kalve, my lord. And to develop that, this project engineer of Nirmiti Kendra, the government has sanctioned 1 crore rupees for that. And they are developing a garden and other things for the children to play there. And when they were doing that, these people under the order 1 rule 8 suit, they filed the suit, some of the shopkeepers nearby. They say that their road is being encroached. This is beyond the road. And this is the government project which they are continuing. This is no way affecting their road or any the access at all. They claim that easement is right.
You have access over the Raj Kalve. How can you have access over the Raj Kalve?
Behind the Kalve, there are shops, my lord. And the customers will go through that on the Raj Kalve, my lord.
Raj
And
Kalve cannot
if
be
it is
used
blocked,
as
my lord.
Raj Kalve cannot be used as access.
ಅಲ್ಲ ಅಂದ್ರೆ ಅದು ಶಾಪ್ಸ್ ಮುಂದ್ಗಡೆ ಇದೆ ಅದು.
ಹ.
ಅದು ಇವರು ಕಸ್ಟಮರ್ಸ್ ಅನ್ನ ದಾಟಿ ಮುಂದೆ ಆ ಶಾಪ್ಸಿಗೆ ಹೋಗ್ಬೇಕು.
ರಾಜ್ ಕಾಲುವೆ ದಾಟಿ.
ಎಸ್
ರಾಜ್ ಕಾಲುವೆ ದಾಟಕ್ ಬಿಡಕ್ಕಾಗಲ್ಲ. ರಾಜ್ ಕಾಲುವೆ has to be empty. ದಾಟಕ್ಕೆ ಹೆಂಗ್ ದಾಟ್ತಾರೆ? ಹಂಗೆ ನಡ್ಕೊಂಡು ಹೋಗ್ತಾರ? ಬ್ರಿಡ್ಜ್ ಇದೆಯಾ?
ಪಾಯಿಂಟ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಹೋಗ್ಲಿಕ್ಕೆ.
ಯಾರು ಮಾಡಿದ್ದಾರೆ?
ಇವರೇ ಕಾರ್ಪೊರೇಷನ್ ಮುನ್ಸಿಪಾಲಿಟಿ
ಅವರೇ ಇವಾಗ ಇದನ್ನ ಡೆವಲಪ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Developing a garden and play for children.
May I read
Their
it,
children also
in
may
page
play
number
there.
135, your lordship may kindly see, my lord.
135.
135. In page number 133, my lord.
Yes.
May I read it, my lord? To the said area and submitted that defendant number 4 has taken a contention that the proposed project area is for the benefit of SC/ST category people, but the voters list clearly shows that the majority of the people residing in the said area are not belong to SC/ST category. It is further argued that as per the project plan produced by the appellant respondent number 4, there is a proposal of construction of swimming pool, kids play, but admittedly proposed construction is intended to be made over the concreted bed made over Raj Kalve. Then a question will arise, how the swimming pool can be constructed over the concrete bed, that too on the drainage area. On the other hand, learned DGP as well as learned counsel for the appellant during the course of arguments have submitted that the proposed work is for beautification of the city and the infrastructure which are intended to be made through the said project are temporary amendments. Same can be removed at any time. Admittedly, it is a Raj Kalve under the concrete bed. There is a drain and flow of drainage water. Under such circumstances, definitely a question will arise, how the defendant number 4 will construct swimming pool, children play part.
Where is your plan, proposed plan for development?
I will produce. I have not produced along with this. I will produce the plan also.
For the petitioner seeks fund is granted. Yaad produce ಮಾಡ್ತೀರಾ?
Within 2 days, I will produce.
Seeks fund is granted 2 days time to produce the proposed development plan to be implemented by the petitioner at the behest of defendant number 2.
Yes.
Released on 11th February.
62, SP Abballi.
My lords, this petition is for the rejection of IFO amendment in reference petition, my lords. It was filed before the evidence, my lords. It was rejected.
In amendment, what is the amendment sought for?
Valuation, my lords.
Valuation and insertions of certain properties, deletion and addition at page 31, my lord. Application.
Why should it be rejected?
Lord, the reason assigned by the court below is that, my lord, amendment is permissible under the old act since the proceedings is under the new act, that is under section 64. At page 45, the reasons. Had come to the conclusion that the reference made to this authority has to be considered, that is 9.01, my lord. At para 9, page 44.
Yes.
Yes. Coming to the facts of the instance case and on careful perusal of the proposed amendment, the petitioner needs to incorporate the pleading with regarding to the nature of trees, quantum of valuation, and the pleadings leading to suggest evidentiary value for claiming enhancement in the award, which is under consideration before this authority. In other words, it can be said that the petitioner intends to plead the evidence which he intends to present before the authority for claiming the enhancement of the award passed by the LAQ, which is under challenge in this authority. The reference made to this authority has to be considered as a reference under section 64 of the new act, and the determination needs to be made under section 69, wherein the authority has to consider that whether the collector has taken into consideration the parameters set down under section 26 to section 30 of the provisions under section new act while passing the award under challenge. So in view of the same, when the reference is made under section 64, it is petitioner to place cognate necessary and clinching evidence.
Order passed by the district and session judge.
Yes.
How can he place reliance on section 64, which relates to collector who has to do it? Fact finding authority or inspection ಮಾಡಬೇಕು.
ಹೌದು.
ಇವಾಗ district judge ಮಾಡ್ತಾರ?
ಇಲ್ಲ ಮಾಡೋದಲ್ಲ, ಅವ್ರು ಮಾಡಲ್ಲ. It is the collector who has to do.
Petitioner is before this court seeking for the following reliefs. And AGA accepts notice for
all the respects.
Respond number 1 to 3.
For all the respects.
The petitioner was the owner of the land in RS number 120B2, measuring 1.5 acres situated at Kadirampur village, Kamlapur Obli, Hospet Taluk, Vijayanagara district. The said land came to be acquired by respondent number 2 and 3 for benefit of respondent number 2 and 3, and the award came to be passed on 19/9/2016. The petitioner, being aggrieved by the amount awarded, had sought for reference under section 64 of the right to fair compensation so and so. The same was referred to the third additional district and session judge, Ballari, sitting at Hospete, and came to be numbered as LAC number 27 of 2022. In the said application, the petitioner filed an application and order 6 Rule 17, which came to be numbered as IA number 2 of 24, seeking for incorporation of the number of trees, the market value of the said trees, and certain other aspects, contending that the valuation would have to be affected in respect of these items. The said application having been opposed by the beneficiary of the acquisition, wide impugned order dated 2nd December 2024, the application came to be dismissed on the ground that the amendment which has been sought for is for incorporation of pleadings in the nature of evidence, which is not permissible. And as such, the petitioner intends to plead evidence in the matter, which cannot be permitted under section 64 of the Act of 2013, wherein the determination to be made by the court under section 69 is as to whether the computation of the compensation made is proper or not, and no new evidence can be laid. It is carrying the said order that the petitioner is before this court. Shri, now you can tell your name.
Pranav, my lords.
Shri, full name.
Pranav.
Shri Pranav, since it submits that the order passed by a trial court, by the reference court, is not proper, inasmuch as what is sought to be placed on record is not only evidence, but a pleading on which basis evidence would be laid in the future. And it is for the reference court to have considered these aspects to determine whether the calculation of the compensation made is proper or not. The contention of the land loser being that the valuation of the property is not proper and the relevant aspects not having been taken into consideration. The land loser now seeking to place those details on record which could not be placed earlier. The amendment being required to determine the true compensation which is liable to be paid, the reference court ought to have allowed the said application. Shri V.S. Surmat, Learned Counsel, Learned AGA, would submit that.
That has been already considered while passing the award, and we have dealt it.
All those aspects have been considered by the SLAO while passing the award.
Yes.
And as such, no further evidence could be laid by the land loser in relation thereto. Heard so and so previous papers. This short question that would arise for consideration in the present matter is whether a land loser can be permitted to lead evidence in a reference proceedings by placing on record pleadings relating to the aspects which have not been considered in the award passed by the SLAO? Question mark. It is not in dispute that an award has been, that the land of the petitioner has been acquired, an award has been passed, as regards which the petitioner has a grievance in terms of the quantum of the compensation awarded. It is in that background that the petitioner has sought for enhancement of compensation as regards the valuation made to the trees, number of trees, valuation of the trees, and certain other aspects. The valuation of agriculture land being required to be made on the basis of the nature of trees and the value and the nature of trees, quantum of trees, and the yield of the trees. If the petitioner land loser were of the opinion that the compensation has not been determined and ascertained on that basis, and the ascertainment made is not correct, it would but be required when the petitioner were to seek for reference to place those details on record for the reference court to consider. If the land loser were not to be permitted to place any evidence on record as regards the enhancement sought for, then there would be nothing for the reference court to consider while considering the application for enhancement. In that view of the matter, the finding of the trial court in the present matter that the pleadings which are sought to be placed on record are evidence is not correct, inasmuch as for evidence to be led, there would have to be pleadings to be placed on record. It being trite law that pleadings without evidence and evidence without pleadings cannot be looked into. As such, I am the considered opinion that the pleadings now sought for to be placed on record is the foundation for the evidence that may be required to be laid by the land loser for enhancement of compensation. In that view of the matter, I pass the following order. Writ petitions allowed. The order dated
2/12/2024.
2/12/24 passed by so and so is set aside. Consequently, IN number 2 of 24 is allowed. The reference court is directed to proceed with the matter therefrom after permitting the petitioner to carry out necessary amendment to the claim petition.
Please.
Please, madam.
63, Putvi case.
Challenging the order of land tribunal, wherein, my lords, the petitioner has filed, my lords, form number 11 declaration form on the basis that, my lords, as per section 66 of the act on the E-class land. Thereafter, my lords, the respond number 3, my lords, by virtue of, my lords, application filed by the petitioner before Tahsildar, had forwarded to, my lords, land tribunal to consider that application. The land tribunal, my lords, has rejected, my lords, the claim of petitioner on the ground that, my lords, he holds that, my lords, the petitioner is having excess land as per section 67, that is on the E-class land. Challenging that order, my lords, I have preferred writ petition before this honorable court, my lords. That earlier, my lords, it was a civil petition, my lords, and thereafter it is converted to writ petition. In writ petition, my lords, this honorable court, my lords, after securing the records, my lords, has held that, my lords, the remand order has been passed only on the ground of, my lords, the tribunal has to consider whether it is a D-class land or E-class land. Only on that ground, my lords, the matter has to be remanded. And I have produced, my lords, record of rights before, my lords, to show that it is an E-class land. Thereafter, my lords, pursuant to remand, my lords, the tribunal, my lords, we have filed an application before the tribunal to conduct spot inspection. Spot inspection has been conducted, my lords, and a report has been submitted before the, my lords, tribunal that I have produced, my lords, before, my lords. That is, my lords, they have report has been submitted by stating that the land is not fit for agriculture, and, my lords, it can't be allotted to, my lords, any third parties. Now, my lords, after, my lords, hearing, my lords, the tribunal, my lords, holds that earlier, my lords, in the year 2009, pursuant to Annexure H, my lords, one order has been, my lords, passed by the assistant commissioner without the approval, my lords, of the deputy commissioner as per section 77, has allotted, my lords, land to the third persons by claiming the conditions to, my lords, to grow the crops and all, my lords.
What reason? For growth of, for agriculture purpose?
For agriculture purpose.
Not fit and agriculture.
Please, that order has been passed, my lords, without intimation. And, my lords, thereafter, my lords, on the basis of that order, the tribunal has rejected, my lords, my claim, my lords.
Only on that basis?
Only on that basis, my lords.
My lord, one submission. May I take a lordship at page 100 of the earlier order?
There is no interim order sought for. We'll have to dispose. ಬೇರೆ ಯಾರ್ದು ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ.
ಅಲ್ಲ, interest ಇಲ್ಲ. The reason which has been pursuant to the direction issued by this honorable court directing whether that land is a E class or D class. But though he conducts a spot inspection, but he comes to the conclusion that at 139 operative portion last paraದಲ್ಲಿ ಪ್ಲೀಸ್ ಈ ಮೇಲೆ ಪ್ರಸ್ತಾವನೆ ವಿವರಿಸಿದ ಸಂದರ್ಭದಲ್ಲಿ ಘೋಷಣೆದಾರ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಆದೇಶ ಇದರ ಘೋಷಣೆದಾರರು ದಾಖಲಿಸಿದ ರಿಟ್ ಸೋ ಅಂಡ್ ಸೋ ನೀಡಿದ ಆದೇಶ ಬರುವ ಪೂರ್ವದಲ್ಲಿ ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಬೆಳಗಾವಿಯವರು ಆದೇಶ ಸಂಖ್ಯೆ 25/797 ನಲ್ಲಿ ಬೆಳಗಾವಿ ತಾಲೂಕಿನ ಹಂಗಾರ್ಕಿ ಗ್ರಾಮ ಕ್ಷೇತ್ರ ಸೋ ಅಂಡ್ ಸೋ ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಈ ಜಮೀನುಗಳಲ್ಲಿ ಘೋಷಣೆದಾರರು 147 ಎಕರೆ ಜಮೀನನ್ನು ಹೆಚ್ಚುವರಿಯಾಗಿ ಹೊಂದಿರುವುದಾಗಿ ತೀರ್ಮಾನಿಸಿದ ಜಮೀನು ಸಹಿತ ಒಟ್ಟು ಕ್ಷೇತ್ರ 192 ಎಕರೆ ಜಮೀನು ಹಿರಿಯ ಉಪವಿಭಾಗಕರು ಬೆಳೆಯುವ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ವಿವಿಧ ಜನರಿಗೆ ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣೆ ಕಾಯ್ದೆ 1960 77 48 ಜನರಿಗೆ ಹಂಚಿಕೆ ಮಾಡಿರುವುದರಿಂದ ಘೋಷಣೆದಾರ ಹಿಡುವಳಿಯನ್ನು ನಿರ್ಧರಿಸಲು ಘೋಷಣೆದಾರ ಹೆಸರಿನಲ್ಲಿ ಜಮೀನು ಲಭ್ಯ ಇರುವುದಿಲ್ಲ. He comes to the conclusion that there is no such land vacant in order to declare that the petitioner is the
That is on the basis of it being allotted to
somebody else. But the direction which was issued.
Okay, land extent is more, you'll have to convince us on that. Yes. But if they have submitted a report saying that it is not fit for agriculture, how could the grant be made?
That itself is error.
ಏನಿದೆ ಫೋಟೋಗ್ರಾಫ್ ಎಲ್ಲಿದೆ?
ಇಲ್ಲೇ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿದ ರಿಪೋರ್ಟ್ ಹಾಕಿ ಅವರೇ ನಿಂತು ಹೊಡಸಿಂದ ಪೇಜ್ 130
so much of land be
ಅಲ್ಲ 130 ಅಲ್ಲ ಅದೆಲ್ಲ ನೋಡಿದ್ರೆ ಅದು it cannot be useful for cultivation also.
How is this not fit for agriculture?
That melts ಅದು ಗುಡ್ಗಾಡು ಪ್ರದೇಶ ಅಂತ
ಎಲ್ಲ ಕಾಡಾಗಿದೆ ಅದು.
ಏನ್ ಲೆವೆಲ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಅಗ್ರಿಕಲ್ಚರ್ ಮಾಡಕ್ ಆಗಲ್ಲ.
But melts that order has
ಕಲ್ಲು ಇದ್ರೆ yes.
ಅಲ್ಲ since it is
for agriculture.
But it is already declared as E-class land. The report, my lords, has been submitted before my lords.
That reason, my lord, this honorable court has specifically made an observation.
A small portion of land would have passed in order. It's a larger portion. Get instructions.
Yes. My lord, accept notice for all the respondents.
He accepts notice for the respondent. Seeks bond is granted a week's time to obtain instruction submission relist on
Monday
17th.
Please.
Lords, may I request 2:30 minutes. Preliminary. Please.
64, Sabil Ahmed.
My lordships, I appear for the petitioner in this case, my lordships.
Yes.
My lordships, annexure B at page 13 and annexure C at page 14 are under challenge, which is the suspension order issued by the second respondent, Secretary APMC Ballari and President APMC Ballari, suspending the trader's license of the petitioner, who is a stockist and a commission agent in the APMC, my lords, without any due notice, whereas the rules require that prior notice has to be issued, he has to be heard, then after his license it needs to be suspended.
For suspension?
Indeed, my lord. Rule 73, Rule 73, sub-rule 4 of the APMC Act, 1966.
Rules. Sriram, APMC rules. Rule 73, na?
73, sub-rule 4, my lords. No license shall be suspended or cancelled under this section unless the holder thereof has been given a reasonable opportunity to show cause against a suspension or cancellation.
Now, which rules are you referring to?
Allotment of rules.
No, section 73.
Section 73.
Section 73, sorry, my lord. Section 73, sub-rule 4. Subsection 4, sorry.
Yes, that's suspension. And AG accepts notice for respondent number 1, Shri Pianati. He is directed to accept notice for respondent number 2 and 3. Counsel for the petitioner to furnish 2 sets of the petition along with annexes on the said counsel. The operation, implementation, execution of the impugned order dated 17/1/25 and annexure B 23/1 so and so at annexure C is stayed till the next date of hearing.
Much obliged.
Shri Pianati is directed to secure instructions and make a submission as to whether any notice had been issued to the petitioner before the impugned orders were passed in terms of subsection 4 of section 73 of the Agriculture Produce Marketing So and So Act.
Next,
65,
same.
Abdul Ahmad.
Same order.
Much of it.
66, HM Dharwad.
Date check, madam. Yes.
Give it.
No confidence.
No confidence.
Caveator andre no confidence.
Yes, Your Lordship. This is
ಏನು
the
ground
third
ಏನು?
time, third round of litigation. Now they have complied, Your Lordship, with all these conditions.
In earlier round, Malad, the Sondava could dispose the matter on 21/2025. Very next day, Mal filed an application by the members. Very next day, Malad, the assistant commissioner issued.
Very good.
That is contrary to 49(1), Malad, that one ground. Other ground is Malad rule 1, provision of rule 1(3). 3(1). Proposed motion not attached with the Malad. In so far 49(1) is concerned, Malad, for a moment kindly see Malad full court decision of this honorable court. Last pair of the Malad judgment for a moment kindly see.
ಎಲ್ಲ ಇದೇ ಟರ್ಮ್ ಅಲ್ಲಿ ಮುಗಿಸೋಗ್ಬಿಟ್ರೆ ನೆಕ್ಸ್ಟ್ ಏನು ಗ್ರೌಂಡ್ ಇರಲ್ಲ.
Namo case. Namo case. Para 19 for a moment kindly see. 19.
ಕೊಡಿ ರೂಲ್ಸ್ ಕೊಡಿ. Before 2020.
10 days clear notice, Your Lordship, that's the. Now the 15 days, they have made it very.
10 days,
15 days.
So more contention.
15 days is clear. 15 days clear. Maladi only Maladi that is contrary to the Maladi full court decision of this honorable court.
Dharwad ಹೊಸ interpretation. First notice assistant commissioner ಗೆ 15 ದಿನ notice ಕೊಡಬೇಕು.
10 days.
10 days.
10 days.
Assistant commissioner 10 ದಿನ ಆದ್ಮೇಲೆ notice
ಕೊಡ್ಬೇಕಂತ
ಕೊಡ್ಬೇಕು.
within 10 days.
That is the ratio of
That
the
is his
Maladi full
contention.
court decision.
ಆಮೇಲೆ ಇನ್ನೇನು interpretation ಹೇಳ್ಬಿಟ್ಟು.
ಅದ ಪ್ಯಾರಾ 19 ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ. Even though Maladi directory Maladi full court decision say that Maladi comply the Maladi.
And AGA accepts notice for respond number 1 and 2. 3 ಯಾರು? Irremat accepts notice for respond number 3. Petitioner is before this court seeking for the following reliefs. Petitioner is aggrieved by the notice issued by respond number 2. Dated 22/1/2025. Fixing the date of consideration of no confidence motion on 10th February 2025 at 11 a.m. at the office of the Gram Panchayat. The submission of PHM Dharwad Learned Counsel for the petitioner is that 1. The notice issued by the Assistant Commissioner in Form 2 is not accompanied by the proposed motion stroke requisition notice issued by the Gram Panchayat members. Therefore, the notice issued by the Assistant Commissioner is non-est and cannot be acted upon. 2. That an earlier challenge having been made to a notice issued by the Assistant Commissioner, this court had, by its order dated 20th January 2025, upheld the same, quashed the said notification, and as such, no requisition notice could have been submitted by the members of the Gram Panchayat for a period of 30 days thereafter in terms of sub-rule 2 of rule 3 of the rules of 1994. Lastly, he submits that the members of the Gram Panchayat are to provide 10-day clear notice to the Assistant Commissioner of their proposal to move the no confidence motion. It is only after the expiry of 10 days from the date of receipt of the requisition notice that the Assistant Commissioner could issue any notice in terms of Form 2 and sub-rule 1 of Rule 3 of the rules of 1994. On all the above three grounds, he submits that the impugned notice dated 22/1/25 at Annexure A is required to be quashed. Learned AGA would submit that the first 2 points raised by the counsel for the petitioner are covered by a decision of this court. It nenne madadu Anand Kolli ಅವರು. So, and as such, he submits that there is no requirement to enclose the requisition notice issued in terms of Form 1 along with the notice in Form 2, and that the Assistant Commissioner was not required to wait for 30 days after the quashing of the earlier notice in terms of subsection 2, sub-rule 2 of Rule 3. Insofar as the third submission made by Shri H.M. Dharwad, he submits that the period of notice indicated in the proviso, first proviso to subsection 1 of section 49 is as regards the time period between the date of notice issued by the Assistant Commissioner and the date of the meeting, and not between the date on which the requisition notice is submitted to the Assistant Commissioner and the date on which the Assistant Commissioner were to issue a notice in terms of Form 2. And as such, he submits that the third submission made by Shri Dharwad is also cannot be accepted, and the petition is required to be dismissed. Shri Jagdish Patil, who has entered caveat for respondent number 4 to 16, submits that respondent number 4 to 16 have unfortunately been required to move the notice of no confidence for 3 earlier occasions.
This is third, Your Honor.
This is third.
But on 2
earlier occasions.
And this being the third occasion, the members of the Gram Panchayat have been deprived of their democratic right to move a no confidence motion. The technical arguments which have been advanced cannot be countenanced either in law or facts, and as such, the petition is liable to be dismissed. Having made out no grounds, heard so and so, produce papers. The points that would arise for determination are: 1, whether the requisition notice in terms of Form 1 is required to be enclosed along with the notice issued by the Assistant Commissioner in terms of Form 2 of the rules of 1994. 2, whether the Assistant Commissioner has to wait for a period of 30 days after
10 days,
the
10 days.
earlier.
10 days.
ನಿಮ್ಮ ಸೆಕೆಂಡ್ ಆರ್ಗ್ಯುಮೆಂಟ್, ಥರ್ಡ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅದು. ಎರಡು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ 30 ಡೇಸ್ 22nd 23rd ಮಾಡಕ್ಕಾಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಇಲ್ಲ ಅದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲ. that is 30 days in time ಇದೆ ಅದು. ಅದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲ.
ಆವಾಗಲೇ ಮಾಡಿದ್ರೆ
only ಮಲಾಡ್ 2 ಮಲಾಡ್ದಿ only 49(1) ಮಲಾಡ್ದಿ 3(1).
ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ತೆಗೆದು ಆಯ್ತು ಬಿಡಿ, ಅದನ್ನು we have already dealt with it. 30 days after the successful challenge to an earlier notification. 3, whether 10 days notice has to be given by the requisitions to the Assistant Commissioner, and or the Assistant Commissioner has to wait for 10 days after receipt of the requisition notice before issuing a notice in terms of Form 2 of the rules of 1994, question mark. I answer the above points as under. Answer to point number 1. This issue is no longer res integra. This court has dealt with in Anand Kolli Nennedu. As such, I answer point number 1 by holding that Form 1 is not required to be enclosed along with Form 2. Answer to point number 2. This also has been answered in the same matter. What is required to be seen is that the order in WP number 100107 of 2025 was passed on 20th January 2025, reserving liberty to the respondent number 4 to 16 to submit a fresh requisition notice. The fresh requisition notice has been submitted on
21/1/2025.
The notice in Form 2 was issued on 22/1/2025 and served on the petitioner on 23/1/2025. That is to say that the requisition notice was issued after the quashing of the earlier notice in WP number 107686 of 1000107 of 2025, and as such cannot be said to be a continuation of the earlier proceedings. And as such, I answer point number 2 by holding so also. Point number 3. The submission of Shri H.M. Dharwad, Learned Counsel for the petitioner, is that in terms of the first proviso to subsection 1 of section 49, the requisitions are required to issue 10-day clear notice, 10-day notice to the Assistant Commissioner, and that the Assistant Commissioner cannot issue any further notice, any notice under Form 2 till the expiry of 10 days. And in this regard, he relies upon the decision of the full bench of this court dated 8th August 2022 in WP number 102077 of 2022, more particularly para 19 thereof, which is reproduced hereunder for easy reference. Having considered the submission of Shri H.M. Dharwad and having gone through the said para 19 reproduced here and above, it is clear that the 10-day clear notice found mentioned in the proviso of section 49 has to be submitted to the Assistant Commissioner. And it is furtherance thereof that the Assistant Commissioner has to convene a meeting to consider the no confidence motion. The aforesaid paragraph, nor does proviso to subsection 1 of section 49 require 10 days notice to be issued to the Assistant Commissioner.
Previous para of that it has been dealt. 18, para 18 dalli, it is not mandatory. Shankaregowda judgment that has been happened.
Even though mandatory, not mandatory, they follow the procedure subsequent.
That has been answered here.
The full bench, as at para 18, also observed as under by referring to another decision of the full bench in WA 200087 of 2022. What is required is, in view of the above, what is clear and what is required is for the Adhyaksha or Adhyaksha to be provided with 10 days notice of the meeting scheduled for consideration of the no confidence motion. There would be no requirement for 10-day notice to be given to the Assistant Commissioner, since the Assistant Commissioner is not answering any grievance. The Assistant Commissioner would only be required to act on the requisition notice submitted by the Gram Panchayat members stroke requisitionist, and as such, the Assistant Commissioner would have nothing to do while waiting for 10 days, since the Assistant Commissioner is not answering any grievance as aforesaid. The Assistant Commissioner can immediately on receipt of a request of a requisition for no confidence, address a notice convening a meeting. However, while so convening, 10-day clear notice would have to be given to the Adhyaksha or Upadhyaksha against whom the no confidence motion is moved. Hence, I answer point number 3 by holding that the period of 10 days as contained in the proviso to subsection 1 of section 49 refers to 10 clear days of notice to the Adhyaksha and Upadhyaksha against whom the no confidence motion is moved, and not for the Assistant Commissioner to wait for a period of 10 days prior to issuance of notice in terms of Form 2 of so-and-so rules of 1994. In that view of the matter, no grounds being made out, the petition stands dismissed.
List 3. Serial number 21. J. Shetty.
Yes, Mr. Shetty.
Tomorrow, my lord. Tomorrow it can. Tomorrow it can.
Tomorrow ಏನು ಇವಾಗ ಹೇಳಿ. Tomorrow ಬದಲು then 11th ಹೋಗುತ್ತೆ. ಯಾವತ್ತಿದೆ ಮೀಟಿಂಗ್?
9th, my lord, is the date and last date to file nomination.
ಇವತ್ತು ಇಲ್ಲ 11th ಹೇಳಿ. We are sitting only to consider all these matters. Otherwise, we would have got up some time ago.
In fact, your lordship may kindly see the, so far as the, on 2 grounds, my lord, it has been rejected. The annexure C is,
Voting ಬೇಕಾ ಇವಾಗ ಕೊಡ್ತೀವಿ.
voting right as well as the nomination, my lord.
Nomination ಕೊಡಲ್ಲ.
Allala, in fact, your lordship may
Deal with it on merits and dismiss it, no problem.
tomorrow, my lord, in fact.
That is not fair, Mr. Shetty.
No.
We'll adjourn it to 11th.
11th, my lord, it may.
Till for the petitioner
My lord,
seeks
in
for
fact.
adjournment. Relist on 11th.
My lord, in fact, no, my lord, lordship may kindly see the, my lord, no, my lord, my lord, lordship may kindly see the,
You
at
can't
least,
have everything.
at least, my lord, documents, my lord, which I have produced, my
Yes,
lord,
Praveen.
sure. My lord,
Voting rights. Land AGA accepts notice for respond number 1, 2 and 3. 1, 2 and 3, na? Alla 1, 2.
1 and 2 only.
3 garu. 1, 2 and 4 AGA.
Please.
Brahmagowda.
3.
Brahmagowda.
So and so accept notice for respond number 3.
5 and 6 notice, emergent notice.
Yaru ilva?
ಇಲ್ಲ ಯಾರು 5 and 6.
Issue emergent notice to respond number 5 and 6. Returnable by ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಏನಾದ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ?
19th ಕೊಟ್ಟಿದ್ದಾರೆ.
19th March.
19th March. 19th of this month.
ಬರುತ್ತಾ? Returnable by 19th March, 19th February. ಅದು Cooperative Society election.
Seek for hand delivery, Lord. Seek for hand delivery.
Hand delivery order.
Please, oblige.
24. AB
ಡೆಲಿವರಿ ಕೊಡಕ್ಕೆ ಕೂತಿರೋದು ಇವಾಗ. ಸೇಮ್ ಅಲ್ಲ?
Lordship, contesting rights also.
Contesting ಇಲ್ಲ.
Lordship, kindly see the annexure A, Lordship, for a moment.
Contesting ಅಂದ್ರೆ argument ಮಾಡಿ.
Lordship, yes, Lordship.
You argue the matter.
For a moment, Lordship, kindly see the annexure A, Lordship. There are total members of the society, Lordship, 431 members, Lordship. Only eligible voters are, they are preparing the list for 60 members, Lordship, out of 431 members, Lordship. And 371 members are ineligible voters list.
Yes.
Only 60 members are the lead the society, Lordship.
Yes.
Only for the purpose of their rights curtailed their rights, they are preparing this list, Lordship.
Yes.
So,
Learned AGA accepts notice for respond number 1
1 and
and
3, Your Lordship. 1
3.
and 3.
Shri so and so directed to accept notice for respond number 1, 3 and 4 alva?
ಇಲ್ಲ ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್
1 and 3.
1, 2,
1 and 3.
So
1 to
and so
3,
accepts notice for respond number 2. Issue notice to respond number 4 and 5. Returnable emergent notice returned by 19th February. Counsel for the petitioner is also permitted to take out hand summons on respond number 4 and 5. The petitioner orders on interim prayer. The petitioner is before this court contending that the petitioner's names have been improperly excluded from the list of eligible voters list. The petitioners could not have been declared to be ineligible in terms of Rule 13-(d) stroke 2 capital A stroke Roman 1 and Roman 2 of the Karnataka Cooperative Societies Rules 1960 without hearing the petitioners, and as such he submits that the petitioners are required to be permitted to vote as also contest in the elections. Having heard learned counsel for the petitioner, there is no dispute as regard the petitioners having been, the names of the petitioners having been deleted from the list of eligible voters. The aspect of whether the deletion is made properly or not would have to be considered by this court at the final hearing after serving notice, after hearing all the parties. In that view of the matter, I am the considered opinion that no right could be conferred on the petitioner to contest the elections. Since if so permitted, the same would result in a situation which cannot be reversed, thereby prejudging the matter before hearing the parties. In that view of the matter, the interim prayer sought for is rejected.
At least, Lordship, power to.
That was the choice given first. If you don't take the choice, we won't give it.
At least, Lordship, sorry, Lordship.
Sorry.
Lordship. At least.
Shetty ಅವ್ರಿಗೆ ಹೇಳಿ ಆಯ್ತು, ನೀವು ಕೇಳಲಿಲ್ಲ ಅಂದ್ರೆ ಆಗಲ್ಲ.
Please, Your Lordship. Your Lordship. Your Lordship, please, Your Lordship. At least.
Give the date, my lord, and long date.
Power to write all, at least power to write all, please, Your Lordship. Your Lordship.
Pardon, my lord, serial number 99, my lord. 99 matter, my lord, with respect to.
No, one short of century.
Fine, pardon, my lord. Serial number 99, matter pertaining to, my lord, E-Asti Khata, my lord, for the municipal corporation, my lord, town municipal.
Mentioning
Why should list the matter in preliminary hearing or, my lord, because.
ಎಲ್ಲರೂ ಅದೇ ಕೇಳ್ತಾರೆ ಮಿಸ್ ನಾಯ್ಕ. ಎಲ್ಲ ಆಗಲ್ಲ.
3 times, 4 times, my lord.
Can't help it. You quote all moved eastern.
Pardon, 106 matter where notice is also issued, not issued, only, my lord, the instruction.
It will come in a regular, no exception for anybody.
No, my lord, I am only submitting, pardon, my lord, that instruction for 108 employees, driver, my lord, salary, only mandamus matter is there, 106.
108 employees.
Only that.
Salary ಕೊಟ್ಟಿಲ್ಲ, correct. ಏನಾಯ್ತದು?
Instructions I had to get last week.
ಯಾವ serial number?
106, my lord.
108, 106. ಅದಕ್ಕೆ confusion ಮಾಡ್ದೆ. 108 released on? 106 released on? Monday.
Lord, serial number.
Mr. Bangi.
Your Lordship.
It never.
Lordship.
Lord, I put a flag. They have taken back the file. AG's office.
Who has taken the file? ಆ ಫೈಲ್ ನಮಗೆ ಬೇಕು. Reserve ಮಾಡಿರೋದು. We'll give it back to you later. Who is going to point it out to us?
Your Lordship.
Serial number 82.
Lord, I'll get back.
File put.
Password matter, Marathi. Serial number 9 password matter.
Pardon me, Lordship. Pardon me, Lordship. Serial number 24, Your Lordship. Reconsider, Lordship.
Password matter. Sriram.
Sriram sir.
Madam, one
Password matter.
Sir, court officer, sir.
Sir, 76.
24 interim order extension. Sir, interim order ಎಲ್ಲೆಲ್ಲಿದೆ ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀವಿ.
ಆಯ್ತು. Court officer, sir.
ಸರ್ ಹೇಳಿ.
Court officer, ಇದು 73rd serial numbers list 1 ಯಾವ ಡೇಟ್ ಏನಾರು ಹೇಳ್ತಾರೆ?
ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್
73.
73 ನಾ?
ಹೌದು.
ಸರ್ 24/2.
24
ಹಾ.
ಏನಾರು ಬೇಗ ಆಗ್ಬೋದಾ?
ಸರ್ ಅದೆಲ್ಲ ಆಲ್ಮೋಸ್ಟ್ ಆಲ್ ಜಾಮ್ ಆಗಿದೆ, ಅದಕ್ಕೆ 24/2 ಕೊಟ್ಟೆ.
24/2 ನಾ? ಆಯ್ತು ಸರ್.
Sir, 79. Number 9 at date ಕೊಟ್ಟು.
Sir, ನಮ್ 76 ನಾಳೆ ಹಾಕ್ರಿ.
84